All right, good morning. I invite all of you to take your seats as we begin again this morning. So good morning to all of you. My name is Nick Briner. I'm a professor at Louisiana State University and working as one of the academic coordinators for this conference, this symposium. And I'm very delighted to welcome you back for the second day, and a special welcome to all of you who are joining online throughout the world. We're very pleased to have you with us. Yesterday, we heard some inspiring messages as well as some cautionary messages as we reflect on 50 years since the Stockholm Declaration of 1972. Professor Jeff Sachs yesterday noted that in many respects, we have failed to change the trajectory, the self-destructive trajectory of our planet throughout the past 50 years, and that law has played frequently a negative role in working toward environmental conservation and sustainable development. But law also presents many great opportunities and is necessary in order to ensure an equitable transition toward a more sustainable future. We were pleased last evening to hear from Inger Anderson, the UNEP executive director, who spoke of how we might be able to turn toward a new and more inclusive multilateral approach to environmental protection. So I'm looking forward to our continued discussions today with so many distinguished speakers, high court judges from throughout the world, and many other experts who will be speaking to us about access to justice issues and other topics related to environmental law. So I'm pleased to turn to our first panel of the day, which will be on an official launch of the Global Judicial Environmental Portal, an important initiative of the Global Judicial Institute on the Environment, together with the UN Environment Program and other partners, to provide an opportunity for judges to exchange information and share and exchange experiences about environmental adjudication in order to promote and disseminate information about access to justice and other environmental matters. So I'd like to call up here to the front Justice Antonio Benjamin from the National High Court of Brazil and the president of the Global Judicial Institute on the Environment, and would also like to welcome other members of this panel who are joining us virtually on Zoom. Eva Duer, legal officer from the UN Environment Program, Judge Marc Clement from the Administrative Court of Lyon in France, and Peter Spielman, associate legal officer at the UN Environment Program. Please, Justice Benjamin.
And the chair.
Oh, and
we have two co-chairs.
Yes, and two co-chairs for our panel as well. Justice Luc Lavriesen President of the Constitutional Court of Belgium and Chair of the European Union Forum of Judges for the Environment, who is joining us online, and Donald Cagnaro, former Director of the UN Environment Program Law Division as well. So please join us here at the front.
Good morning, Stockholm. Greetings.
And with
from
that, I'll turn
Dakar.
it over then to the chairs of our panel, Justice Lavrisan and Donald Cagnaro.
So good morning, Stockholm.
Oh, yes.
Greetings from Dakar, Senegal.
Please.
I'm attending here a
Like to explain
conference of the Constitutional Court.
Good morning, everyone. Yes, I will just explain the gifts that you have been provided with. Unfortunately, you haven't got any. It's on the tables here in Stockholm. Unfortunately, the letter here, it's from Hanna Werth, who you met yesterday, the chairman of the Swedish Association for Judges, that has provided you with these small gifts. Unfortunately, due to the constraints of our post office, we haven't got the cheese slicer that is mentioned in the letter from her. But I hope you will accept these small gifts anyhow, and I hope you will continue to have a fruitful conference today. Thank you.
So thank you very, very much. So as indicated by Nick Breiner, we will have this morning the official launch of the Global Judicial Environmental Portal. It's one of the, let's say, major projects of the Global Judicial Institute on the Environment. And I think we can say that judges must be able to communicate with each other, to learn from each other, to have access to sources of environmental law, including jurisprudence, and because the environment is a worldwide issue, also jurisprudence from other parts of the world. And of course, these days, if we are looking to sharing information, having access to information, we have to look, we cannot other than to look to the internet and to ICT technologies. In this panel, we have 4 speakers. The first one is live, I understand, in Stockholm, is Justice Antonia Herman Benjamin, who is the chair of the Global Judicial Institute on the Environment. And of course, he took also the initiative for the development of this Global Judicial Environmental Portal. I think I do not need to present to you Justice Antonia Herman Benjamin, because I think yesterday was in nearly every panel. I think the second and the third speakers are in the first place Eva Duer and then Peter Spielman, both from Informea. Informea is the United Nations information portal on multilateral environmental agreements, and the judicial portal has been developed in close cooperation and with the support of Informea. Eva Duer is a legal officer in the team and team leader of what's called the Collective Intelligence for Environmental Governance of UNEP. And Peter Spielman is the associate legal officer with the same unit. Furthermore, and maybe that can come as a surprise, there are also some, let's say, ICT nerds within the judiciary, including one of the judges who is in the panel, being Judge Marc Clément, who is now a presiding judge with the Administrative Court of Lyon, but that's just one of his activities. He is furthermore member of the Autorité Environnementale in France. He's also a member of the Aarhus Convention Compliance Committee, and he has been closely involved with the development of the portal. And I said he is an ICT nerd. He developed also different websites for different associations of judges, including the first website of the European Union Forum of Judges for the Environment. So I will give now the floor to Justice Antonia Herman Benjamin, who is with you in Stockholm.
Good morning, good afternoon, good evening. For those that are in different time zones, I would like to begin thanking Hanna Wert, the president of the Association of Swedish Judges, for giving us not just a lovely gift, but a useful gift. I'm already using mine. So please, I asked Judge Bergenson to convey to her that it was very appreciated, the gift that we received. Let me thank the two co-chairs, and I'll be brief because we are more interested in knowing how our portal, the Judicial Portal of the Global Judicial Institute on the Environment in cooperation with UNEP looks and what it can offer and how we can add more to this. As Justice Luc Lavrissen mentioned, and I believe he is in Dakar, and that's why he is not able to be with us here today in person. The Global Judicial Institute on the Environment, even before it was formally started, the founding members, several of them are here, others are connected, wanted to build a judicial portal. So that was the first thing that came to all those that were involved in the preliminary discussions that led to the establishment of the Global Judicial Institute on the Environment in 2016. And it was decided that we would build a judicial portal by judges for judges. As I don't need to repeat that for us judges is very important that we preserve the independence of our work, and not just the way we see ourselves, but the way we are seen by others. Then I had the opportunity to meet Eva Doer, who is with us. And I already knew about the fantastic work that she and her colleagues were doing within the context of the MEAs and building a set of jurisprudence, but also connecting that jurisprudence with the specific MEAs. And also, back many years before, IUCN, FAO, and UNEP established what was then called and still called ECOLEX, more on legislation and also embryonic jurisprudence. So we discussed among ourselves, among the judges, and we thought that why invent the wheel if we could work together with our natural partner, UNEP. So that's how it began. And many thanks to Eva and later on to Peter. Both of them will be speaking and presenting the extraordinary preliminary results, not the final portal, but this is the global launch. We have already launched regionally and more incomplete versions of the portal, but now the portal is operational with the exception of the part of the portal that is reserved for judges. Only judges will have access to that part, but I will not go into the technicalities because both Eva and Peter will explain that. From the Global Judicial Institute on the environment side, we asked two colleagues to take the lead in this collaborative work with UNEP, and they generously, kindly accepted the task. First, Justice Luc Lavrissen, and second, Judge Marc Clément. And they have both participated in technical discussions, virtually, in person, and I am on behalf of the judges of the Institute very grateful to both of them. So I think that's, in a nutshell, a very brief introduction. I'm not going to use my 15 minutes. One last point, though. We judges depend on knowledge and information. But it's not just any knowledge or any information. It has to be good knowledge, both legal and non-legal, and information, both legal and non-legal. And as Justice Lavrissen has just stated, we also depend on communication among ourselves. And communication, or means of communications in which we feel that we are safe to discuss in a reserved manner among us about concrete cases that or difficulties that we are facing in our work as a judge. And the portal, as you are going to see, provides for that. The next step that we are working as we speak is to finalize an MOU with UNEP. We still, we couldn't do it before because the Institute was not registered in Geneva. Now it's fully registered, and we can then proceed to a more formal approach to this rich and important collaboration. Mr. Chair, in fact, the two chairs, Donald Cagnaro and Luc Lavrissen, I stop here because I think everyone is much more interested on the portal itself than on things that I could say as a non-expert. Thank you.
So thank you very much, Justice Antonio Herman Benjamin. Let's turn now directly to Eva and Peter to give us a glimpse of this judicial portal. So please, Eva, the floor is yours.
Thank you so much, Luc, and thank you so much, Justin Benjamin and Luc Lavrissen, for this introduction. Indeed, this is a very exciting day for us. We have been having this collaboration flourishing over the past years, and it is, of course, a big moment to have the Judicial Portal officially launched today. And as both justices have already indicated, and Justice Benjamin, you have initiated this whole process, we have been approached by the Global Judicial Institute first in 2018, and there were initial brainstorming discussions, and of course we were very excited about this development right away. Indeed, the Global Judicial Institute was welcomed as a partner to the Infomea initiative in 2018. And as you said, it was already an opportunity for UNEP to having piloted and tested a system that allows different knowledge sources to independently connect to each other and share each other's information. And of course, the MEAs who had increasingly developed interest in jurisprudence and how jurisprudence actually brings to the ground international law have been very enthusiastic about this collaboration. And so a first prototype was then developed already in August and presented. And from there were a lot of maturity issues and further development issues, a lot of discussions with Justice Clement, Justice Lauresen, and in the end of the day, the first beta version was launched or was presented to the third General Assembly of the Global Judicial Institute on the 8th of December in 2021, at the height of the COVID situation, where it was very fitting to make this information accessible for the first time without much outreach. And as it has been mentioned, and I think this is very important from UNEP's side to mention, it is indeed very important that both aspects, that of course the Global Judicial Institute is independent in managing the networking element and other elements of the portal. And at the same time, it's very important for us to still mention that the value of this portal, which is the jurisprudence collection and the capacity building section for the non-members, for the public at large, is of course where the interests of UNEP and the Global Judicial Institute totally converge. And it's important to mention that what is on the Global Judicial Institute's judicial portal will go straight to Ecolex, will go straight into Infomea, will go straight to other tools that are servicing other stakeholders. And this is a very important asset and a very important value from the UNEP's point of view. And of course, vice versa, it also means that some of the assets that are developed under Infomea, like online courses or the support of the glossary and tagging support, are available to the portal. And that is how it all comes together, so that there is not the feeling that there are more and more portals developed. These portals that are servicing specific stakeholder groups are all linked in the background and build on each other's knowledge. What has happened since this first beta version was made available at the end of last year? Without any outreach, there were already over 50,000 people finding the judicial portal online. And at the occasion of a recent review of the Infomea portal's project performance, there was also a small question to the audience whether they are familiar with the judicial portal. And those who said they are familiar have already, even though not all services are fully functional, and most importantly, the networking section is still being developed, they were already they already considered the portal very useful. And so this gives us a great sense of anticipation as to where we will go. And as I proceed from here, we just wanted to show you how this pans out in reality in terms of what does it mean that the tools are linked. And so this is the Global Judicial Portal as it is being launched today. I hope you are seeing the right screen. Are you?
Yes, yes.
Okay, but I'm somehow missing the right one on my end. So let me give it one more try. No, it's probably. Okay, now I think I'm sharing the right screen. And if you go to from here to the e-learning section, because I will then let Peter show the main services, you already find the courses that are available through the resources section, which includes many materials that come from some of the other tools. And here you can jump right into e-learning courses. In this case, there is a course on climate litigation that has been made available just a few weeks ago. And all this information is available from the Infomea portal that, of course, encompasses many courses that could be interesting and relevant. And I also wanted to show that in the context of the glossary of the Judicial Portal, it is possible to then get further information on related treaties and related legislation from these linked tools, such as here, the Law and Environment Assistance Platform, which is the platform of the Montevideo Law, Montevideo 5 process, or here on the treaty text of the Kyoto Protocol, which you can access from the Judicial Portal, and how it relates to the SDGs, which are on the forefront of today's joint struggle for the environment. So with this very brief introduction, I will maybe hand over to Peter to show you the most key features of the Judicial Portal. And thank you so much for your continued collaboration. Once again, specifically to Judge Clement and Judge Lauritzen, and of course, Judge Benjamin, for this excellent collaboration. Thank you.
Thank you, Eva. So now the floor is to Peter.
Thanks, Justice Lauritzen, and thanks, Eva, for introducing the background, and Justice Benjamin. And thanks for the opportunity to present a bit in more detail the portal today. We're very excited to see the fruition of this number of years of collaboration in this official launch, and to see where it grows from here. So I would go into a bit more detail of the functionality of the platform, and maybe illustrate a bit what Eva has already introduced in terms of linking platforms, interoperability, digitization, how that actually works and function in this platform, where the main architecture is now there and ready to be used. So the portal can roughly be divided into three main sections. The real backbone of the portal is, of course, the library of jurisprudence, in contrast to these other portals which it interacts with that focus on legislation or on MEAs or on treaty decisions. The real focus, of course, of this portal is on case law, on jurisprudence. So this takes the form of both a library that's publicly available, but also importantly, the digital architecture to be able to collect cases from users of the platform. So the first is the jurisprudence library, basically. The second component, which was introduced or mentioned by Justice Anthony Benjamin, is also very important to the collaboration between GJIE and UNEP, is the judicial network. So this is a space specifically for GJI members and GJI judges to be able to discuss and network and find each other. So it consists of a directory and of a forum. And lastly, the resources section, which Eva touched on, which is basically the library of information, of video lectures, of reports, of whatever content that's sort of a space specifically for GJIE to be able to find and host these resources. So I would start then with the jurisprudence section. So I started specifically logged out to show that the portal is a bit split between the public facing section and certain elements that are specifically for people who are authenticated to either be able to contribute content, or additionally to be able to contribute content as well as access this networking section. So if I want to browse jurisprudence, of course, that's publicly available from anyone who accesses the site. If I want to submit, just to show you, then it of course prompts me to be able to log in. So then to be able to create an account, this would go to us, to the content managers, to be able to authenticate that user. So the idea was, of course, for judges and members of the judicial network to be able to share their cases, but additionally, all other contributors, potentially prosecutors, partners of UNEP with UNEP projects, with GJA projects, regional UNEP staff members, whatever the case may be, so that it really is a tool that has a broad reach to be able to collect and start populating jurisprudence. Then additionally, if you try to go to the judicial network, you're specifically given a prompt where you need to be a member of the Global Judicial Institute, and then you can go to create an account. That also goes to this validation section, where if you do say that you are a judge, there are some additional fields that need to be filled out. And one last word in terms of the process of this and the pipeline of it, both cases as well as users then go to the second step of authentication. So there's a bit of a workflow behind the scenes where the structure of the site is set up to be able to validate the people, validate the cases that come in. So there's a quality control built in. So then if I go now to start with submit jurisprudence and log in, I'll show you some of the fields that hopefully concretize a bit what we mean by the linking between these platforms and the utility of housing all of this process within one platform and making it internal and digitized. So things like, so if I do this test case, so that's a case I already know is there. Functions like showing you that there's already a duplicate. So you can see that perhaps someone's already added it, or it's a related case that you can link to. So then if there's a certain minimum set of fields, of course, and then this is another very interesting thing to show. If I add the PDF file, so this is just the PDF of the decision of actually a UN body decision. But then I'll go down to this, which is a very interesting thing, which hope it works live now, where it can actually extract tags from the glossary, which is really the value add, another value add of having within this digital platform. It'll actually scan the PDF and give you suggestions from the glossary. So if you're not super familiar with the glossary yourself, it can already give you some suggestions, but you know the case. You can say, yes, climate change, that's right. Yes, admissibility, that's right. Civil procedure, that's not really right. Property, that's not really right. So of course it's not perfect, but it already gives you, and myself knowing the case, it's actually fairly good, this individual tagging. In addition, you can add some text to the key environmental legal questions or abstract, and it would also scan these fields to be able to give you some tags. And then finally, in terms of those many different fields, it can give you specific hints so that the users understand what we mean by these individual fields. Then at the very end, to demonstrate how this is linked to the other platforms. So if it's specifically about UNFCCC, let's say, then it will automatically pop up. This creates a link with a unique identifier where the system knows that this is specifically linked to the record on Infomia of the United Nations Framework Convention on Climate Change. Same for court decisions within the portal. So this is based on a previous Supreme Court quick case from New Zealand, and I can click this to show that it's linked, and that creates a specific identifier in the back end. It kind of removes the human error if you type the case wrong, and it captures this information a bit better. And then lastly, the idea is, of course, that this then gets imported to the related platforms. So we're not recreating the content types on each platform, where Ecolex and LEAP are already generating legislation. Infomia already has these connections for MEAs. Then the jurisprudence would come from here, and we hope that judges can still opt out, but in most cases, then it would naturally or automatically be forwarded to these additional platforms. Just quickly then to see what the front end looks like, the publicly available side of jurisprudence. You have, so these, of course, the tags, then you can see over here. So then if you select climate change, but then you can further narrow by this legal specific glossary. So then if you want to more specifically about climate change evidence, it narrows down to these two cases. If you select one case, this is the one that's already added. You can see how these tags are reflected and all the additional linked material. Quickly, I would introduce then the network as well. So Judge Clement and Justice Levereisen were kind enough to create example profiles already, just to show this is what the directory would look like. Of course, it's not useful with just two judges, but if you have a volume of judges, you can filter by the specific type of law that they've indicated they're interested in, as well as the name. And then just to show you quickly what a profile looks like, you can have a little bit of an excerpt of your biography, link to either decisions, but hopefully decisions would be entered. And you can see here actually all the jurisprudence that user has uploaded. The second aspect of the network is the discussions page. So this is basically a forum. It's 3 levels. The first level is basically the very broad topics. So right now, just for example, so we call them forums, I've created a broad forum of human rights, everything human rights in the environment. Within that, you can have topics. These topics can be added by any judge user. So I've created one, human rights and climate change. Within that topic, you can ask specific questions. And so besides this case that we were just looking at, are there other cases brought on the right to life? And then you can have a back and forth, basically, discussion over here. So fairly light touch forum, but it's there, and it's basically available to these authenticated judge/GJIE users. The glossary we've already a little bit been over, but then the advantage of the same set of cases being on both Infirmia and on the Judicial Portal. On Judicial Portal, it's the same set of cases largely, except it's tagged against this legal litigation-specific or adjudication-specific glossary. Whereas on Infirmia, it would be tagged to this more MEA-specific everything environment glossary. And Eva already showed you a specific glossary page. And then finally, just rounding out, we mentioned e-learning. So these then connect to the Infirmia portal. So these are what we think are more specifically interesting courses for judges. But you could also create specific e-learning courses that are only available on the Judicial Portal, not on Infirmia, but still using the learning management system and architecture that we already have in place there. This is another way to navigate the courses that are in Infirmia. We have a space here for video lectures, because I think there are a lot of those within GJI members that often give addresses that are recorded that could be useful to store in one place, and then other e-learning platforms where we want to link to other platforms that are doing much the same work. We have training materials, which is basically just PDFs, a lot of UNEP materials, but it's open to anything UNEP and GJIE, or even just relevant to the judiciary. Similar, but reports, not specifically on, not as specifically on capacity building or training. Partners, just to point to platforms that are doing similar work that we don't want to replicate, where GJIE in the portal is specifically for these GJI members and material. University still needs to be populated, but it's in place there. And finally, legislation, pointing to these tools that are more engineered specifically to navigate legislation, which already exists, which are already connected. It's the same body of legislation, but again, not to reinvent the wheel, where if your entry point is legislation, it's better to start from those tools. So thank you very much for the opportunity to present, and I'll hand it back to Justice Levereisen. Thank you.
So thank you very much, Peter. And let's turn now to Marc Clément for his intervention. Please, Marc, you have the floor.
Yes, thanks. Can you hear me? Is that okay?
Yes.
Okay. So thanks a lot for the invitation, and this is really great to be part of this big event, and especially the launch of this official launch of this portal. I don't want to be too long, but I want to stress three points why, and indicating why is it so important to share case law and jurisprudence for judges, and also to progress in networking in the domain of environmental law. First of all, and I won't be long because this is probably obvious for everyone, that there is an international dimension of environmental issues. Obviously, the planet is only one ecosystem and one thing that is to be protected everywhere. And also, and I think that's why UNEP is so useful in this context, there are many international conventions, and as judges, we are basically using the same legal body of text that is to be applied across the planet. We are facing common issues as judges. For instance, climate change is obviously one big common issue, but water pollution is to be tackled everywhere, air pollution as well. And so that means that per se, the exchanges between judges are very, very important. And that's also what we experience in the EU Forum of Judges for the Environment, where we had this annual conference where we compare the way judges are solving cases and very similar situation across Europe, seeing big differences, but also big similarities. Second point, which is very important, is sharing means for us, for judges, to find inspiration from other solutions. I just briefly give an indication from Europe, but we could probably find things similar like that everywhere. In climate change, we had, for instance, a very important Dutch Supreme Court Dutch case based on human rights applied in the domain of climate change. The German Constitutional Court issued also a very important case in climate change, but which is based on constitutional rights, and constitutional courts applied these constitutional rights, moving in the same direction as the Dutch court, but using different reasoning. And the French Conseil d'État was also delivering a very important case on the basis of European directive and national laws. But we know also about there are many cases in India, in different countries related to air pollution or protection of biodiversity. And so having a tool, as it was presented by Peter, where you can identify easily for one sector, a set of cases which is relevant to one area, is very, very useful. And I think that the brief presentation of Peter should be a way to be an incentive to go on the portal and to look at the different at the database, and to find that we have many relevant case law which is already available and very interesting. And the last point I wanted to say is that the portal is a way for each jurisdiction to promote some of the cases, the landmark cases that have been decided in each jurisdiction. This promotion is very important. We all know that some judgments are known by many people in the world, such as, for instance, the Dutch case I mentioned on climate change, due to the fact that academics will comment these judgments very extensively. But there are other and many interesting judgments and cases that are not covered by these academics discussions. And I think it's a pity that we only focus on very specific countries. And I think that for the tool that is provided with the Global Institute Judicial Portal is a tool that will allow every country to promote some interesting cases for the benefit of everyone. I see that if you look at the database as it is today, you will find a lot of cases from India, a lot of cases from Tanzania, and this is very, very useful to have this global perspective. The Global Judicial Institute is a global institute, and it is not aimed at promoting specific case law from specific areas of the world. And I think that the last message I wanted to share is that there is a need specifically for Supreme Courts in every country to really find a way to provide cases to the judicial portal. This is something that is not too complicated to do. As Peter has shown, this could be done quite easily. And I think each Supreme Court, or possibly each court, but I think if the momentum is given by Supreme Courts in every country, I think this is a very positive thing for everyone. And I really encourage everyone to share as much as possible what has been decided in every country. That will be very useful for every judge in the world. So thanks a lot for listening. And that was my brief intervention on that.
Thank you very, very much, Marc Clément. I don't know if the co-chair, meanwhile, managed to be online, Donald Cagnaro. He was not online at the beginning, I think, but I don't know if he's, meanwhile, has managed to join or not.
Yes, Donald Cagnaro is here in Stockholm.
Ah, he's in Stockholm. Okay. So I hand over now to Donald for his final remarks. Donald Cagnaro, he joined UNEP shortly after its headquarters was based in Nairobi, and he was involved with different, he performed different functions, including that of the director of the Division of Environmental Policy Implementation and much more. And after his retirement, he is still very active in bodies like the World Commission on Environmental Law and the International Council of Environmental Lawyers. So, Donald, please, the floor is yours.
Thank you. Yeah, thank you. Thank you, my co-chair. He has been with me on this road of sensitizing each other, understanding each other for a long time. And it's a pleasure to take the forum together. It's time for questions, comments from the floor on the presentation so ably presented by the speakers you heard. And of course, you are in the spirit of bring ourselves together to inform each other, to know one another, and to move forward together. It's a long way we have come, by the way. It is amazing. And the fathers of that development are here. As we close the meeting later on, I'll make a few comments that bring you up to date with the process starting 1996 and the first global judges symposium in 2002 in Johannesburg. For me, it is rewarding that in 20 years, these 20 years, you are on your 20th year, you are now mature. You know, over 18, you are now free agents in this particular area. So it is rewarding to see a number of those that were there at the beginning. I have here Antonio, whom you all know. I see a chief judge of the Land and Environment Court that pioneered this process in 1979 and is still going strong. And of course, I do remember the struggles we had with the United States to begin with. My friend Scott Fulton there and Professor Dan McGraw would remember. And of course, even in our own countries, we had people who were saying, no, you don't understand. Judges know the law. They know it all. So why do you be saying you are training judges? Said, no, we are not training judges. We called it Symposium, we called it colloquia. And from then now, you are actually running with a subject that was so at that time. Nobody had studied it. We were not sure where it was going, but now we are up and running with it. So, comments from the floor?
So very briefly, before we have questions and comments on the portal, there is still a lot to do in terms of refining the portal, but it's also relevant to recognize the work that has been done. It's amazing. So congratulations to the colleagues, both on the UNEP side and on the Global Judicial Institute on the environment side. I would like to thank, in particular, the colleagues from the board that have been participating since the inception of the idea. First of all, as I already mentioned, Luc Lavricin and Marc Clément, directly involved, Ranghil Noe, Michael Wilson, Brian Preston, and Mansour Ali Shah, that will be arriving at any moment, and Riccardo Lorenzetti that spoke yesterday. So now we are hoping to expand the conversation as we move to the more sensitive part of the portal, or the design and the implementation, which is the segment that will be open only for us judges, our space. And from the UNEP side, I would like to thank Inga Andersson, who has been very supportive, as I mentioned yesterday, of the Institute since the moment she was still director of IUCN. Elizabeth Merema, who was then the director of the Law Division, and Donald keeps telling me and Elizabeth that he hired her. So he selected Elizabeth. I will not say when this happened, but it was quite some time ago. Then in the division itself, Arnold Kreihuber, great supporter. Andrew Rain, I suppose Andy is connected with us. He'll be speaking at the closing. More recently, Patricia Mbotti, she was here yesterday, and great supporter, very enthusiastic about the portal, and the wonderful team of two, Eva and Peter. And originally it was Eva. So Eva, we would like to thank you and this large team for putting together such a magnificent product. This is really the cutting edge of what, as Donald said, of what we have been looking for and thinking that it will be possible, and now it is possible. So Nick, I think there will be comments.
Yes, thank you. We have time for just 1 or 2 minutes of comments or questions if anyone has any questions they would like to raise. Right. Please, Justice Preston.
A question for Eva and Peter. With the uploading of the judgments, it's really important, as a number of speakers said, to have representative judgments from all over the world, all jurisdictions, all languages. The only problem is, and I suppose this is particularly for somebody like myself who is not multilingual, we find difficulty in accessing the judgments if they're not in one of the well-known languages. Now, sometimes courts have been really good in producing an unofficial English version of the judgment. So in, for example, the agenda case, they did that. Also in the Norwegian Greenpeace case, they did that as well. So my question is, could both versions be uplifted to the portal so that people who are not fluent in Dutch or Norwegian, for example, are able to read the unofficial translation? And the second would be, could there be any flagging of a translation of some of the more important cases which could be uploaded. So if the court hasn't done that, somebody could do it, because otherwise a lot of us will miss out on all those words of wisdom that are in other judgments. So that's just a question. Thank you.
I will ask just one additional question that perhaps can be responded together with these matters from a questioner online, Maria Diane Rowland, who asks whether there is any possibility for creating an account in the judicial portal for non-judges or non-lawyers. Is that envisioned? Do you create an account for someone else who is interested in doing research on these matters? Or how does this work for a non-judge who's interested in looking at the information on the portal? Yeah, please.
Maybe coming back to the question of Brian Preston, I think more and more there are some automatic translation programs of which the quality is becoming better and better. And maybe we can consider if such a tool would be helpful to have access to other languages. So the second question, I'm more reluctant, but I'm giving the floor on that to Justice Antonio Herman Benjamin.
Well, I would like to hear from both Eva and Peter, but just on the question that came from a virtual participant, the portal, as the name indicates, is a judicial portal. But early on, we agreed that part of it could be open to the public, because it's also in our interest as judges that the public, and especially researchers and those that are experts in the subject, know what's going on in different jurisdictions globally. But the DNA is a portal by judges, for judges, in cooperation with UNEP. So we don't envision portal accounts for others than the judges. The open part of the portal is open to everyone. You don't need to have an account. But the part that is just for the judges, and that's the core of the portal for us from our perspective, in that one, only judges and sitting judges, not even retired judges, will have an account.
Yeah, are any additional comments from Eva or Peter on those issues?
Maybe just yes to come in here to say that, of course, even in UNEP, we are struggling because the translation into English, or at least even the summary in English of a case, is already a high level task for which you have to have a high level of understanding. And that is why it is very crucial that we have a number of vetted contributors, often universities, because judges tend not to have the time to do this work. So there is probably the option to have a contributing role through an institution with a vetting role of the Global Judicial Institute. And I think we would find a solution that would suit all of these. And I wanted to say on the tagging, the system is multilingual. So the 5 UN languages are possible to pick up the issues in the 5 UN languages. But of course, as soon as it's a non-UN language case, we are depending on the summary that comes with the case. So this is just a small practical intervention.
Thank you. We have time for just one more question. Justice Wilson, please.
Thanks, Nick. And thanks very much, Eva and Peter. I just wanted to be clear about the relationship, if any, with the established databases for legal research, such as Westlaw. It's my understanding that the judges are being asked to do the analysis of those cases that are of significance, and that that would mean the judges are the source of information and the analysis of, for example, which cases from Westlaw should be included. Is that correct? Maybe that was a hard one.
Maybe I can respond to the question. So, of course, this is an open source database. So it's not possible, I think, to copy or whatsoever jurisprudence from more commercial databases. And we can harvest on the basis of databases of the courts themselves and so on. But I think it's impossible to import or whatsoever any material from commercial databases where you have to pay for.
Yeah, if I may complement, because this question was raised early on, even before we approach UNEP. As we know, in many countries, there are commercial data banks. And Mike mentioned Westlaw, which is probably the largest in the world and is operating not just in the United States anymore. So there was the suggestion from colleagues that once we have the portal fully operational, including the part that will be open and accessible only for judges, to contact Westlaw and other companies of that type and see whether the judges that are members of the Institute could have free access via the portal to the data bank of Westlaw, but not importing Westlaw cases into our data bank. So that's still pending because we need to finalize the part of the portal that is just for judges.
Well, thank you all very much for those questions. And I'm sure there are many more questions about the operation of the portal. So I imagine that colleagues at the UN Environment Program would be willing to be contacted by email or otherwise with additional questions that you have. So in the interest of time, I think we'll need to close in order to move on to our next panel. But I'd like us to all give a round of applause to our chairs and panelists for this presentation. Thank you all very much. I'm going to head to call our next panel, which will be on theory and practice of the environmental rule of law, with special emphasis on independence, integrity, and the use of technology in the judiciary. And as co-chairs of this panel, we have Veselina Haralampieva, Senior Counsel at the European Bank for Reconstruction and Development, and Carl Brook from the Environmental Law Institute. So I'd call them to come forward. And I also would like to invite speakers, Justice Suntaria Muanpawang from the Vice Chief Justice of Region 5 from Thailand, Justice Karen Zarikian, Administrative Court of the Republic of Armenia, Justice Samson Okongo, the Presiding Judge of the Environment and Land Court of Kenya, and we have joining us online Federal Judge Marcos Livio Gomes from the National Judicial Council of Brazil. And I will turn the time over to our co-chairs, Veselina and Carl, to introduce the panel and provide an introduction to our speakers. Thank you.
Thank you very much for your kind introduction, and good morning, everyone. It's a real honor for me to be here today. It has been a fascinating series of panels and discussions of dignitaries from around the world. So I've learned a lot, and I think there has been so much ideas for further collaboration and really insightful thoughts on sharing innovative legal instruments, practices, case law. So on this very topical, very important panel today, it's my privileged to introduce first Justice Sontaria Muanpaung, who is Vice Chief Justice of Region 5 of Thailand. Hello and welcome to the panel. Justice Karen Zarikian, who is at the Administrative Court of Armenia. Hello and welcome. They're joined by Federal Judge Marcos Livio Gomes from the National Judicial Council of Brazil. Virtually. Yeah, he's joining us virtually. And we will have also Justice Ambang Kandakasi, Deputy Chief Justice from the Supreme Court of Papua New Guinea. No? That's on my agenda. So maybe there has been some updates on the program? No? Okay, so he'll be joining us later. And with my co-chair, we will turn first. Okay, so Justice Samson Okongo from the presiding judge of the Environment and Land Court of Kenya. And my co-chair, Carl Brunch from the Environmental Law Institute. Well, so with this, I'll turn over first to you, Justice Sontaria Muanpaung, and thank you.
Justices, judges, law professors, ladies and gentlemen. I'm so honored to be here with you all in this historic event. Today, this morning, I would like to share our experience from Thailand. Actually, I have PowerPoint. Someone will, okay. So, yeah, we are talking about theory and practice, and I'd like to choose a topic on intellectual integrity of green judges, and would like to share my experience and my ideas. So next slide, please. First of all, I'd like to show our environmental problems in our region, especially in Thailand. I'm not sure you have some ideas about the country in Southeast Asia. So Thailand is developing, has been developing for, in the Western direction. So we learned a lot about the industrial problems. And although we have many, richness in natural resources, so the fair and just allocation seems to not to happen well in Thailand. So you can see that during the development of industry, so we have got many kinds of pollution, and this affects not only the people, but also the wild animals or forests. We have the rich and the poor. They have also minorities or indigenous people in the forest. And sometimes, mostly when the problems happen, it's like impact to the people who have like intersectionality of vulnerabilities. Next slide, please. Actually, after the Stockholm Declaration, Stockholm Conference, only 6 years, we had created the law on environmental protection, and we set up like a body, an agency to preserve the environment. So it means we had this kind of agency for more than 44 years already. And last 25 years, we had the constitutional rights, constitutional provisions which confirm the right of the people, and not only the individual right, but also the community right. It means the community can have access to justice, access to natural resources, and also they have rights to be heard, or even the EIA and HIA process were confirmed in the Constitution. And absolutely, we had created many good laws and regulations. Next slide, please. So, and our environmental law enforcers, we have, I think every country, we have police, we have environmental law enforcers. So we have like Department of Forestry, or the fishery, or, factory, industry department, something like that. And we have public prosecutor, we have court and enforcer to execute our judgment. Next slide. Yeah, and in our judiciary, I'd like to say that I think more than 15 years, I went to visit Justice Preston with our senior justices from the Supreme Court. So at that time, we learned the experience from the Australian court, because we heard that Justice Preston and his, senior justices so created the Land and Environmental Court, and it was the best model. At that time, I went also with Justice Puno, and later he became the Chief Justice of the Philippines. So two groups of Thai and Filipino judges learned together. And after that, when Justice Puno came back to his country, so he created like the Supreme Court rule to regulate and to have like a practice and procedure in his court. Also in our country, after that, so we created like the green bench in the Supreme Court. And so now, until that time, until now, so we have like green bench in the, not only in the Supreme Court, but later in all 10 appeal courts, and in some ordinary court of the first instance. And later, so the administrative court, they separate from our court of justice. So they also have like a green division in their courts also. And so we try to have like created like green jurisprudence, and try to develop our educational program. And we have good collaboration. So we met many of you beforehand, because we have not only the internal collaboration, but also international collaboration and networks. Next slide, please. So, but today, I think when you want me to talk about the general environmental rule of law, so I thought that maybe I should select only one and the most important topic. So I think that for Thailand and maybe for many countries, it would be very important, because I think if apart from the problem of corruption or something, yesterday Justice Benjamin said that, we don't need activist judge. But for me, activist judges are very needed, and it doesn't mean that we need to protest or something, but I think we need to reconsider about our integrity. And integrity doesn't mean only like corruption or not corruption, but it means that we need to have like intellectual integrity. And this is like from the ethical, code, we need to be active and proactive to protect the people and the environment. So this is from the dictionary, intellectual integrity means you need to be honest to learn the fact or the truth in your case, and you must fight to reach the best decision. And you must have a driving desire to follow reasons and evidence courageously wherever they may lead. And you must, manifest intellectual integrity, value, objectivity, and evidence-based decision-making, and courageous, fair-minded, and complete the pursuit to pursue the best possible knowledge in any given situation. I would like to explain more about this. Next slide, please. So I think firstly, when if you want to talk about you know, the environmental justice in some country like Thailand, which has like a big gap between the poor and the rich. So many people said that the prisons are only for the poor. You know, prisons are only for the poor. What does it mean? So if we talk about the land encroachment, no? Encroachment in public land or in forest land. So many people encroach the public land, not only the poor, but maybe the privileged, you know, the politicians, the mafia, or, you know, like the rich. But only the poor were enforced, were arrested, or, you know, mostly, and not only, but mostly. So if the court cannot understand this social situation, so how can we set the fair sentencing guideline? So this is like, we need to be wise enough now who came before us, and when in equal society, you know, brought only the poor to our court here. And about the environmental ethics, you know, you talk a lot about the ecological centric, eco-centric approach. In Thailand, actually, we had more than 20 years now that with the Environmental Protection Act confirmed about the ecological compensation or the value of the nature, and who destroy the nature must pay. You know, 20 years later, nothing happened, you know. We just consider this paragraph, this provision that we need to apply this, no? And I think firstly, we did not even understand what's the meaning of the value of the nature. But later, if we, you know, try hard to understand this, because this is the ecological centric, you know, approach, and it's not easily understandable for judges. And firstly, so we try to calculate. You might heard, one Black Panther was shot dead, by a rich, privileged guy. And so not only the problem that he should be arrested or not, but later we talk about the value of the tiger, the Black Panther, and the Public Park Department wanted 12 million baht, but the court gave only 2 million baht, something like that. So what's the meaning of this idea? About the polluter pays principle. So every time when the factory discharge contaminated water, something to the public land, something like that, not only the factory will sue, but, you know, the government agencies will sue. So it's like, it's not finally, so the department must pay and not the factory, or both, but finally it's not the polluter pays principle, but it's the taxpayers pay principle. So I think this kind of things that we need to revisit and rethink what we should have, like, to try to develop our jurisprudence and try to understand the real problem in Thailand. So finally, about I think we need to dream of the problem-solving court. I think we talked a lot also yesterday that after the judgment, what would be happen next? And I think about the execution of the judgment, enforcement of the judgment. Until now, the court stopped our work when we write the judgment. We finish the writing, But actually, there are many things to be done, and we need to do more. So I thank you all for your attention. And I think I learned a lot from these events, not only now, but you all are like our role models. And I am so respecting you all. And I wish you all have a great job in your work. And yeah, we will work together in the near future. Thank you very much.
Honorable colleagues, dear friends, I'm happy to be here in Stockholm, in beautiful city, despite of the weather, and to speak on the topic of environmental law and the efficient role of judges in securing our planet. It is impossible to overestimate the impact of judges on environmental policy on both international and national levels. We judges have a power to control the process of both making and executing environmental rules in the context of the rule of law. I think all of you agree that the process of the evaluation of legislative rules and executive regulations turns them from soulless text into the real effective law. Even international conventions and declarations need to be recognized, interpreted, and implemented in a particular case to become a true part of a legal system. As Professor Robinson mentioned yesterday, many of them, including Stockholm Declaration, would remain merely as a good idea if the courts did not bring them to life by their decisions. We judges should profoundly realize our responsibility in the process of the exercise of environmental law and take our right place among other actors. Of course, politicians have a primary position because they make initial political decisions considering environmental issues. We can see that many of these issues don't reach the court, and political decisions thus become conclusive ones. But if just one individual or non-governmental organization brings a case to court, it might have crucial impact on the whole subject. When deciding a case, it is up to the courts to decide either political decisions meet legal standards and principles, protect human rights on clean environment, and establish fair balance between concurring interests or not. This function of just fair monitoring of environmental law can be performed only by judges due to our independence and impartiality. When making decisions on various issues, including such as environmental matters, politicians cannot ignore the political reality, pressure coming from public expectations, and international relations. In most cases, politicians primarily evaluate the political consequences and of made decisions because the latter obviously affects their popularity, raising or lowering and chances to be re-elected next time. I consider to be quite a significant problem the fact that political decisions on environmental matters don't always become an object of critical public attention, particularly because of its specific difficult nature. Ordinary people not included in scientific environmental researches are both rarely informed and don't really rely on the professional opinions. It makes environmental political decisions not properly challenged by by society members, which I consider to be a dangerous trend that can lead to various manipulations in decision-making processes. Meanwhile, an adequate and thorough reflection on the environmental issues usually requires unpopular decisions that politicians are not always willing to make. On the contrary to political decision-making process, principle of independence and impartiality that underline judicial branch mean that judges are able to act without any fear of being criticized not only by politicians, but also by public. Acting on behalf of justice and people, we are often going against public opinion to properly protect human rights and establish fair balance between different interests. At the same time, the power to cancel decisions made by political bodies independent from decision makers and public opinion, puts an unprecedented responsibility on us. If politicals keep in mind that their decisions can be revised in case of any need and in the end corrected by the court, we, on the contrary, are deprived of such a privilege and have to act being aware of the final nature of our decisions. Besides, as I have already mentioned, we may not find the public support for the decisions being made, remaining alone with our beliefs and priorities. In order to handle these difficulties, we should be aware of the environmental situation in the whole world and not being limited solely to legal knowledge of existing environmental regulations. We are all to get acquainted with environmental scientific reports, statistics, risks and predictions, etc. We should carefully listen to experts, being able to conclude whether they are more or less persuasive. Thereby, dealing with environmental matters and environmental law requires us to have the appropriate outlook, knowledge that will allow us to make a responsible, balanced decision, taking into account its global consequences. In other words, legal knowledge should be supplemented by humanitarian one. This brings us to the necessity of special trainings for judges who deal with environmental cases. As I tried to show, the basic knowledge of judges is not enough to function proper in the complicated sphere. First, we need to promote more frequent meetings in order to share our knowledge and experience. But it is also important to have trainings on a regular basis, both on national and international levels, that should be held by law and environmental experts. These kind of events will not only provide us with appropriate professional skills necessary to deal with environmental cases, but also with crucial feeling of confidence when facing the problems mentioned above. At the same time, I realized that it would be quite difficult to train all the judges who are in charge for deciding on environmental matters. The organization of judicial trainings requires a lot of human, financial, and technical resources. For example, there are overall 23 judges dealing with environmental cases in my court and 10 more judges in the Court of Appeal. I consider it to be unproductive and merely impossible trying to train all of them, especially taking into account the fact that there is an electronic distribution of cases that currently operates in Armenia that makes it impossible to predict whether you are going to deal with environmental case or not. In conclusion, I want to say that I think that effective solution in case of Armenia might be the implementation of specialization of judges. If only, for example, 3 judges official level specialize in dealing with the environmental cases, it will be enough to solve all such cases in our republic. It is obviously better to have 6 specialized judges instead of 33 judges of general jurisdiction, in case when they have all necessary skills to decide on environmental matters. I'm happy to inform you that some discussions on this matter are currently taking place in Armenia, and I hope that we will have this specialization of judges soon enough. To be honest, I'm not quite sure if there is a similar approach in your countries and whether it would be handy for you as it seems to be in case of Armenia. So consider my observations as a kind of opening room for discussion, and I will be happy to hear your comments. Thank you for your attention.
Thank you, Justice Zakarian. That's already one comment for the Q&A session. So, and the specialization of judges in environmental matter. With this, I will turn to Justice Samson Congo, please. Floor is yours.
Good morning. In the topics, the impact of Stockholm Declaration in shaping global environmental law and jurisprudence, theory and practice of the environmental rule of law with special emphasis on independence, integrity, and use of technology in the judiciary. I'm going to just share with you the application and enforcement of the environmental rule of law in our jurisdiction. I'll consider some challenges we are facing, and I will conclude. There is a consensus that a gap exists between theory and practice of environmental rule of law. While environmental laws are now in existence in almost all jurisdictions world over, in most of the countries, they only exist in what I would say in paper. In my country, Kenya, where I believe that we have some of the best laws and mechanisms for the protection of, I believe we have some of the best laws and mechanisms for the protection of the environment. We have a very progressive constitution that guarantees a right to a clean and healthy environment. We also have a framework law on environmental management and coordination, in addition to other sectoral laws. Our constitution also makes all treaties and conventions on environmental law, to which Kenya is a signatory, part of the Kenyan law. We also have a specialized court dealing with only the environment and land disputes. Also, we have a tribunal established under the framework law, which handles disputes relating to development planning. However, best laws and mechanisms for enforcement of the environmental laws which are undertaken by the government are, in effect, best laws and mechanisms for enforcement of environmental rights have, however, not translated to perfect environmental protection. In some countries, the implementation and enforcement of environmental laws which are undertaken by the government are ineffective. In others, the laws have no structure for effective implementation. So in Kenya and the neighboring countries in East Africa, we have a number of cases that illustrate the environmental rule of law in action. I will highlight them briefly. One of the cases, I would call it the Serengeti case, where an NGO called Africa Network for Animal Welfare sued the Attorney General of the United Republic of Tanzania. And the case was filed to challenge the intended construction of a tarmac road across the Serengeti National Park, which the applicant contended would have serious environmental effect in the Serengeti National Park and the adjacent Masai Mara National Park in Kenya. There was a contention that the action was against the East African Treaty, the Rio Declaration, and the Stockholm Declaration, amongst others. The Republic of Tanzania argued that it was within its rights as a sovereign nation to make decisions for socio-economic development, such as construction of the road. Also, it contended that it had hired environmental consultants who had advised that negative environmental impact associated with the project could be mitigated. However, the court found that the Republic of Tanzania had intended to construct a road across a public national park, and that from the evidence on record, the adverse effects of the road could not be mitigated. So the court actually restrained the United Republic of Tanzania from continuing with the construction of the road. The other case, which is in Kenya, is a case where the residents of Islam in Kenya claimed that their right to a clean and healthy environment had been violated by the construction of a lead acid factory within the residential area, and that toxic waste from the factory caused deaths and illness among the villagers. Several ministries in Kenya were sued in that particular case, together with the owners of the factory. The petitioners, the contention by the respondents were that the slum dwellers had chosen to stay in an area which was polluted, so they had exposed themselves to the pollution. However, the court found that the slum dwellers' right to a clean and healthy environment was violated, and the court awarded the petitioners a sum of Kenya shillings 1.3 billion Kenya shillings, which is about 1.5 or so US dollars. Another case, I will just go quickly. Another case is of interest in Kenya is, I would call it the toilets case. This is where the petitioners argued that the respondents had infringed on the right to a clean and healthy environment. Of commuters using Kenyan highways. The petitioners argued that lack of toilets on the highways forced commuters to relieve themselves in the full glare of the public or in containers that are then flung out of moving vehicles. The respondents sued a number of authorities, the Council of Governors of Kenya, the Kenya National Highways Authority, then there is the Kenya Rural Roads Authority. The court found that a clean and healthy environment included physical infrastructure and road aesthetics. And the court also found that the Constitution obligates the state to eliminate activities that are likely to endanger the environment. The court found further that people relieving themselves in bushes and other open spaces was one such activity. The court also found that the road authorities are empowered to provide necessary amenities for users of its services and facilities. The court ordered that a working group be constituted to formulate a policy for the provision of toilets and other sanitation facilities on the country's road network to give effect to the right to clean and healthy environment. We have also had another case. I would call it the Nairobi River and Dandora dump site case. In this case, the petitioners alleged that the respondents had violated their right to a clean and healthy environment and sought orders compelling the respondents to adopt a precautionary principle in preventing the upstream and downstream pollution of Nairobi and Athi rivers, as well as restoration of the rivers. Because there was a dump site next to the two rivers, the dump site used to pollute the river. So a suit was filed by the residents that the pollution of the river endangered their right to a clean and healthy environment, and the court found for them. The last case, due to time, that I would mention is a famous case. We call it the plastics case in Kenya. The government had banned single-use plastic carrier bags in Kenya. A suit was then filed to challenge the ban. And the matter came to our court, the Environment and Land Court of Kenya. And the court found that the ban of single carrier plastic bags procedurally and substantively, it did not violate any law. And the court of interest said that the Cabinet Secretary for Environment had power to issue the Gazette notice, as the state was constitutionally required to eliminate processes and activities that are likely to endanger a clean and healthy environment, which is the highest form of right in the hierarchy of constitutional rights, because that right is a sustainer of life in itself, in the trajectory on which all other forms of rights gravitate. Moving quickly, I will skip this. My time is running out. There's the case of there's a case of Patrick Kamotho and Githinji and 4 others versus Resgios Enterprises. The petitioner had moved the court to stop the construction of a road next to their residence on the ground that the works were being undertaken illegally without environmental impact assessment. And the petitioners accused the respondents of indiscriminately cutting down trees which were providing shade and fresh air to the residents. In the ruling, the court accepted the petitioner's contention that the respondents had indeed violated their rights to clean and healthy environment. The court also agreed with the respondents' contention that the petitioners had submitted no specific scientific proof that the ailments which were allegedly being suffered by them were as a result of a road project. The court held, however, that in the circumstances of the case, it was appropriate to apply the precautionary principle, which is also referred to as in dubio pro natura. The court stated that in a case of doubt, matters should be resolved in a way most likely to favor the protection and conservation of the environment. In the final order, the court stopped the construction of the road in question until environmental impact assessment was undertaken and the petitioner's concerns addressed. I'm sorry, my time is up. So thank you very much. Let me stop there. It was a long paper.
Thank you. Thank you very much, Justice Okongo, for this very detailed and useful summary of some of the Kenyan cases relevant to today's topic. With this, I would like to turn to our virtual participants, to the federal judge, Marcos Livio Gomez. Do you hear us? Are you with us?
Yes. Good morning, everyone.
Good morning. The floor is yours.
Oh, thank you very much. Good morning, everyone. I'd like to thank Justice Herman Benjamin for inviting me to participate of these events, these wonderful events. So my main goal in this presentation is to give an overview of the Brazilian judiciary initiatives in order to tackle deforestation and illegal mining. In fact, the National Council for Justice is trying to support judges and courts with tools in order to improve the hearings, improve the actions of the judiciary against deforestation, against illegal mining, supporting prosecutors and many other institutions that are involved in environmental law, and climate change law. I will share a presentation in order to guide my overview. Can you see that?
Yes.
Oh, wonderful. Just 1 second. Let's go. I will present the Sirene Jude. Sirene Jude is a tool developing by the National Council of Justice in partnership with United Nations. Brazil Judiciary has an international cooperation with United Nations program of development, and involving the lab of ODS. We are trying to introduce this new tool to be used by judges and courts. This Sirene Jude is included in the 2030 Agenda for Sustainable Development. Sirene Jude observes the following sustainable developments, mainly climate change, life on land, and peace, just and strong institutions. All work that is being done by Brazil is focused on moving on side by side the United Nations 2030 agenda. But what is Data Jude? Data Jude, to put in perspective, the degree of complexity of this initiative. The National Justice Database is a centralized database that contains metadata of 300 million cases, considered pending and closed ones. It was used to identify an environment-related case in each court of Brazil. Within this environmental theme, there are almost 1 million lawsuits, 1 million, pending and closed, considering all the time series that started at 2015. Data Jude contains metadata obtained from currently more than 300,000 judicial cases. Sirene Jude, as uses a subset of Data Jude, is reaching 1 million cases, considering the pending and concluded on since the beginning of the time series. But what's the main goal of Data Jude, of Sirene Jude, in fact? We can see in this screen, for instance, the main interface of Sirene Jude. In its right, there is a menu that allows the user to select one of the many layers that contains environment data, such as deforestation polygons, indigenous territories, traditional occupied lands, protected and reserved territories, national parks, private sites, mining location, federal roads, water bodies, and several more information that are being constantly improved and collected in a regular basis. Also, some of these layers are dynamically and continuous updated by data mining bots and data gathering algorithms. In this screenshot, we can see the red and orange area, which represents the deforestation identified by remote sensing methods, specifically using satellites that monitors periodically the Brazilian territory and can provide information about the forest coverage. These images are compared using machine learning tools to spot change between old image and updates ones, and a polygon is automatically drawn and plotted in the layer. Each one of the black spots are judiciary units, courts that have a case law of environment case and is organized by its geographic coordinates. So any interested person or citizen, the platform is open to public, can access this information. Click in the black spot and obtain the specific metadata of each one of the judicial cases that exist in Brazil that are related to environmental issues and climate change issues as well. This is updated daily, and anyone can download the full spreadsheet or this shape file containing the polygons and attributes. Yes, everyone will be able to download the information that is provided by Syrenjud. It allows that the judge and the public prosecutors see the exact location of the land that is being discussed in judicial case and identify territories that are relevant or protected by law, so it can be taken in consideration during the trial and the decision process. Due to its continental size, Brazil territories often contain a large social and natural complexity that must be geospatially identified to be perfectly understood. And a specific deforestation area, for instance, can be protected by federal, state, or municipal administration, and its features must be foreseen. Syrenjud is a relatively recent project, but it's always involved, and the team that maintains it in the National Council of Justice is always implementing new tools, layers, and data visualization interface to provide a better tool to the society. Some recent features can be seen here, like the integration of the Syrenjud with the federal prosecutor data about class actions. From now on, the judge and the federal prosecutors can be exchange information remotely and online, updated information that can be shared to be used in trials and court decisions. With this data, it's possible to visualize where the environment damage effectively occurred, and not only the judiciary unit location where the case is being processed. Each one of the damage can be viewed in the Syrenjud interface, and when clicked, it displays the case number. This is an important information, the proceeding type, the court, and the other useful information. It is a mix of geographical and judicial metadata that will be disposed for the society. In this screenshot, for instance, we can see the full description of the case metadata and attributes that are currently available in Syrenjud, such as the environmental teams that it contains, the name of the judicial instance, the proceeding status, some timestamps, and the name of the litigation parts, if they are incorporated companies and not natural persons. The system automatically filters information about natural person to maintain its privacy, but shows the information about corporations. Also, Syrenjud allows the use of several filters to refine search, such as year, curse acronym, justice segments, among others. Each attribute can be filtered and combined with others so the user can easily access the part of the information they actually need, use the filters and layers that is being disposed of. In addition to the geographical representation of the maps, by clicking on data panel, general left side menu, it's possible to see some panels, dashboards, with statistics from the database, such as total number of process, number of processes in progress, number of state and court case. DataJud was developed based on free software, and this is an important information because using a free software, we can share this tool with any other country that would like to use in their courts, and allows the consumption of different data sources through web service, enabling the interoperability of that data from different institutions. The layers are programmatically updated by data mining robots that read the websites and APIs for public institutions that provides the data source. It is done in a database and aims to provide a table formats, CSV, and in geospatial layer format, shapefile, in a machine-readable way for a final user. One of the new features of Syrenjud are the automated reports. What are the reports? Serene Judes nowadays provide automated reports to the courts and to the judges, created periodically using Judicial National Database, DataJudes. It can help the court's case management, identifying constraints in the proceedings and excessive delays. The target users and stakeholders are the judiciary agents and the judge itself and prosecution service. The report contains case load per court and states, aggregate numbers about the pending case and timeline, average ruling time per court and per judge, ranking, comparing courts by average procedure duration, and many other information. In the next screen, we will show the new layers that we were recently inserted in Serene Judes. One of the themes is the integration with the Federal Prosecutor Service initiative that is called Amazonia Protege, in English, Protected Amazon. It is an initiative where they have mobilized a task force that aims to combat illegal deforestation in the Brazilian Amazon forest. With a new work methodology, which uses satellite image and cross-reference of public data, the prosecution service opened public civil actions against those responsible for illegal deforestation with more than 60 hectares, resisted by the project for monitoring deforestation in the legal Amazon. This initiative opened 1,000 public civil actions against 2,000 defendants for illegal deforestation and illegal mining in the Amazon, in mapped polygons of more than 6 hectares that were deforested between August 2007 and December 2019. These actions charge more than almost $1 billion in compensation for damage caused related to recovery of 200 hectares of degraded forest. So, going to the end of my presentation, I have many other slides to present, but I think that the most important is understand the new tools and the update of Serene Jude. Serene Jude also employed new tools like the polygon creation tools in polygon formats. It is required to do it to the normative resolution enacted by the National Council of Justice and the National Federal Prosecutor. This measure has the objective to identify the damage area and allows complex calculations like the sum of the area currently in the dispute in Brazilian judiciary, the average area in the most affected states and municipalities. Also, we must explain that with the new judiciary policy for environment protection created by the resolution of the National Council of Justice. So, next steps. Closing my presentation. What we are aiming to do. In the middle of this year, in July, I think, I guess we will be improving Serene Jude in the integration with initiative related to artificial intelligence. One of them is called the Codex. Codex is a data management platform that supports the use of AI and judicial policy. Currently, the justice AI models are available on the Synapse platform, which congregates Brazilian courts' initiative to share and leverage solutions, which contains more than 41 AI projects, and the other thematic models are going to be inserted in this platform. Related to the environment initiative, having more effective and useful data with information management is essential to sustain good AI models with a consistent degree of accuracy and precision. The future projects are initiatives and partnerships that are already ongoing are the ones with the Federal University of Rio Grande do Norte to develop models that can classify cases related to this topic. Also, we are hoping to create algorithms that can also identify cases that are related to climate change impact. The future in environmental topics are the extensive use of these tools so we can fully understand the topic with a judiciary data approach. So thank you very much for your attention.
Can I have 2 minutes? Marcos Livio, many thanks. Can you put the map of Brazil with all the dots so I can say something in addition to what you have just said? Well, first of all, many thanks to Marcos Livio, a federal judge that with his wonderful team at the National Judicial Council of Brazil is doing this fabulous work. It is the most, you have never heard me saying this type of thing about my country. I am usually, sort of negative, and this is the most sophisticated judicial system in the world for the control of deforestation. But this doesn't mean that deforestation is controlled because we don't have the tanks. We are not the police. But at least we can show where deforestation is happening with real-time satellite data. We can show, and it's transparency about us, the judges, where the cases are, for how long they have been there, the name of the judges. Unfortunately, we judges in Brazil cannot hide and say, don't publish my name. No, the name is there, federal judge, state judge. And then look at this map, because I want to explain something to you. For the first time, we judges and Chief Justice Luis Fux wanted to present this to all of you, but he couldn't come. This is his creation. And but it's important that we show what exactly we see on the map. For the first time, we can see that the area in the Amazon, which is the red on the left, the northwest part of it, that's the whole Amazon. You see how few dots we have. And you can click on those dots and you go all the way down to even the picture of the location where the damage, the deforestation happened. And then you look at Sao Paulo. Marcos, you can show this in a second. Go back, please, to the previous one. And then look at Sao Paulo and Rio, the number of suits protecting not the Amazon forest, but protecting the Atlantic forest, also very important, even more critically endangered than the Amazon. And then you go to the south of Brazil, the Pampas, other biomes. Look how effective judicial implementation is. And my home region, the Northeast, the protection of the coast, the dunes as well, and the Atlantic forest. But in the Amazon, and we are talking about an area the size of Europe, we now have in front of us what judges are doing or not doing, both at state and federal courts. So it is a transparency tool. It's also an integration tool. The government, the federal government cannot deny us the information. So it comes, it feeds the system automatically. And I am very proud of it. So congratulations to Marcos Livio, to the Chief Justice Luis Fux, and the whole team of the National Judicial Council.
Thank you. And this is truly impressive. Judge Bengtson and I were in Colombia convening a series of symposia on deforestation. And there's, no, it was deforestation in the Colombian Amazon. And there are no tools like this in Colombia. It's this is really impressive. That experience though raised a question that I think goes to the heart of this panel on integrity and rule of law, environmental rule of law. When we got out of the capital, when we got into the rural areas, we started hearing multiple stories of judges being threatened. That a lot of the deforestation, a lot of the land grabbing was linked to organized crime. And this is a country that has seen 60 environmental defenders killed in 3 months, the first 3 months of the year. So when a judge gets threatened, it's not an idle threat. And we struggled with what to tell the judges. I mean, we're trying to give them the tools to issue decisions. But what do you tell a colleague who, in issuing a decision, puts his life or his family's life on the line? I'm very curious if you have any experience or perspective on this, because this goes fundamentally to the ability of judges to fulfill their roles and to achieve environmental rule of law. Any thoughts? Please.
Yeah, I did some research project on environmental justice. And so firstly, the people asked what are the environmental cases. And so mostly when we think of follow the international standard, so it's like administrative cases or, civil liability or criminal law. And actually in our country, there are many environmental defenders who were killed, murdered, because of the environmental campaign or fighting. So I think this is sad, but it's a real story that happened all the time in Thailand. And also about the role of the NGOs and the work with the communities. Sometimes the real villagers in the rural area, they cannot understand even the language. So how can they have access to justice, or how can they have like a big campaign to against the projects? So I think the NGOs or the civil societies try hard to work with them. But now our government try to initiate a new law to control, they want like NGO governance, so they want to, and mostly so the NGO, environmental protection NGO, so they work with the international partners, or they were supported by the foreign NGOs also. And so sometimes maybe it's like the government fear of them or something like that. So, so I think it like intellectual integrity actually is not only needed for judges, but actually is for government. They need to understand what is the big picture and who protect the environment when the state or the officers cannot do it on their own. So let the people do. And when the people are weak, not so strong enough, so they need someone to support them. Thank you.
Thank you. This is not a big problem in our jurisdiction, particularly with regard to judges, but there is last year when one environmental activist was actually murdered in a place called Laikipia. So with the judges, it is really not a big problem. The problem we have, as I had mentioned in my presentation, we have a great constitution, great environmental laws. But among the challenges that I was going to mention, if I had time, was that not many environmental cases are finding their way into court. So most of our very hotly contested cases where lives are on the line are really political, but not environmental. But of course, what I've seen they do in political cases where the life of the judge is on the line is to actually beef up security. But it's not really in environmental sphere, not much. Thank you.
Please.
All right.
And if there are any questions online, I don't have access to that, but after this justice, please.
Good morning. I really enjoyed the presentations, especially of Judge Gomez from Brazil. So I have a couple of questions for Judge Gomez. My understanding, because I look at technology in my courts also, and I think it's critical, AI and machine learning and technology is very important for courts. But I think the essence of technology to courts is, and I just want to share that idea, is that we could have better reforms. We have data. Number one is collecting verified data. Secondly, it could lead to reform. And thirdly, it improves your governance, judicial governance. That's what technology helps do. So that's what we are working on in Pakistan also. But this is an absolutely fantastic technology that I've seen. So the question for Judge Gomez is that, are you in a position to identify how long does a case take to be decided? And can you sort of, by looking at this data, tell me what has been the case which has been the longest, which took the longest in being decided? I mean, the life of a case, can you give us an indication that there are cases pending for maybe last 6 months, for like 6 years, 5 years? Can you through this software find that? I would be very interested in knowing that. And secondly, the data that you collect, is there a central repository system where you have the entire data for the country and you can sort of then go into it? Is there a location for that data and it's central? My third question relating to the software is that, could you explain a little bit more on the data mining robots that you mentioned? How does that really work? And what are the possible algorithms that you plan to develop under the AI to identify environmental cases? My problem with identifying environmental cases is that most of the cases that come to courts do not really, people are not articulate enough to explain what's the environmental problem. And it is at times for the judge to identify what the environment is. The 2 cases out of Pakistan that have come do not mention that it's a climate change case, but the judge can smell it and can tell that it's a climate change case. So how does the artificial intelligence and technology tell you that whether at all it's an environmental case? Because you said you can identify an environmental case. How do you identify the environmental case? Judge Gomez, I will be very interested. Thank you.
Please go ahead, Judge Gomez.
All right. It was an interesting question. So how long? In fact, we can split the problem. The technology is one of the solutions, is a part of the solution, but it's only with technology we won't be able to tackle deforestation and illegal mining in Brazil. We need support. In fact, environmental needs support from the federal government and especially the state governments in order to tackle illegal activities, special invasion of indigenous areas, and they're all. 1/3 of the Brazilian territory nowadays is occupied by indigenous areas and protected areas. So 1/3 of the territory. And there is a really aggressive movement of the agribusiness going to the forest. It's not only one state of Brazil. Amazonas is one of the states, but in the legal Amazonia, we have 9 states, and in at least 4, 5 of them, we are facing problems with the moving of the agribusiness and going directly to the forest. So, trying to answer the questions, how long? The average in the courts is 3 years. Federal judge, special federal judge. These issues is most common in federal area, in federal judiciary, and we have an average of 3 years to have everything done with a final decision of the courts. Going to the National Court of Appeal, there are few cases in the National Court of Appeal, the Brazilian National Court of Appeal, regarding environmental law. It can last much more, but mainly the average in the court, in the federal court, is 3 years. The second question is about the database. In fact, Serenjud is trying to get information by public data sets. We have currently 5 public data sets that is being included in Serenjud and creating the layers in order to be able to filter the most important information. And so the information, the search of the information is not centralized in the National Council of Justice in the judiciary, but now we are able for integrate the information data in this system, updating daily. And the third information, but it's not only, it's important to say that the judiciary is creating a data lake with more than 300 million lawsuits, including environmental law as well. In the third question, the last one is about robots and algorithms. I'm not an expert in IT, but currently I'm really involved in issues regarding IT. The team involved in IT in the National Council of Justice nowadays, it's about 200 people that is being hired and being that's being hired by with the support of the United Nations Development Program. One of the teams, Alpha team, is working on environmental law in Serenjud, and this ongoing project involving AI is about to classify class actions, to classify lawsuits. In fact, as was told, the defendants or the prosecutors, in fact, the prosecutors in Brazil can classify the case like climate change, environmental law, illegal mine. But many times we can see mistakes in classifying the lawsuits. And the main idea is that the system, the AI and the robots and algorithms will try to check out the information done by prosecutors in order to understand if the information is right, if the lawsuit is correctly classified, and creating layers in order to be able to have this information easier to the society and to the judges. I think that's it's a really fast explanation. I'd like to know if is there any other question, please.
Because I know there will be other questions, but I'll give you Marcus Livio email and WhatsApp. And he's very quick in responding as opposed to me. But a couple of comments on this. First of all, as you saw, it's a very sophisticated system. And unfortunately, this cannot be replicated in other countries where courts still work with paper files. In my in the Brazilian judiciary, now 100% of the cases are electronic, including the evidence, absolutely everything. So we can then use artificial intelligence for gathering information that might not be climate change, be used in the judgment itself, but is in the experts' testimony, and the system can do this. In your question about how long it takes, well, first of all, for the now we have a system in which judges will be exposed, are exposed not just to society, but to the National Judicial Council that has disciplinary powers. So it's not just something, oh, my name is there. No, there will be repercussions. And also, when this is happening, we have to understand that when, and here we're talking about both criminal and civil, and that later on I'd like to discuss with Thailand to see if you also have both, because I understood you mentioned several times criminal law, but here's for both criminal and civil. So sometimes we have a suit that is filed, and what the plaintiff really wants, the Federal Office of the Attorney General, is not immediate restoration, but to block that piece of land out of the market. And this is immediate. It cannot be sold. It cannot be circulated in the market because it is within the judiciary, and nobody would buy that. And then even if it takes 3 years, 4 years, the longest case is from Sao Paulo against the biggest industrial complex, petrochemical complex. This lawsuit was brought 30 years ago. But you know what happened in those 30 years? Appeals, one after the other, the biggest law firms in the country, blocking everything. And what was asked in by the plaintiffs has now been achieved. And several of those plants shut down, restoration done, people fired. So this also is reflected in the system.
Okay, and then Justice.
Yeah. Is this microphone? Oh, great. So Justice Santaria, a question from Georgie. I expect it's Georgie Lloyd of UNEP. She says, thank you, Justice Santaria. What do you think needs to be done in Thailand to encourage judges to ensure execution of a judgment or enable proceedings to enforce it? And I'll just ask the second question because I think that can be answered very quickly. Another from Marina Janusz. Thank you, Marina. She says, thank you very much for presenting the impressive Serenejud tool. Sorry about my pronunciation. I was wondering if there is consideration to include citizen science and crowdsourced data from the public. So perhaps if we start,
I might suggest that we take the series of questions and then let people respond. So Justice and then Michael.
I think it's better we get the questions out first and then the panelists can try and answer the questions for us. I'm very fascinated with IT. I chair the IT case management and IT committee of the PNG Judiciary. We've moved into e-judiciary as the next project. We will go completely paperless. That's our contribution to preserving the environment and everything that we are here talking about and the challenges that we have faced. Rather than the judiciary taking a judgment seat, we need to do something. And I think the judiciary has made, and I think Brazil is taking the leadership to go e-judiciary. And that becomes paperless. We will save a lot of forest. So my challenge to all of us present is if you are not yet fully e-judiciary, perhaps that's the direction we should be taking. Now, my question is, we lack in the area of data, raw data that Brazilian presentation has shown. The idea, what I'm trying to get to is if the, I think it's the satellite-based zooming in on areas, that's the technology or the ability we'd like to adopt. Is there a way that we can be able to share that, link up? We're working with an Armenian technology company, and everything from filing through to final disposition, you will know where is the dead end, who's locking up. So I manage the system at the moment. So the cases that are held up, we intervene right away. It should be moving. And the objective set by the judiciary is within 12 months of filing, case should be disposed. If there's a delay, we need to account. So those are things, the technology is very encouraging, but I need to find out how we could interlink and share the technology that is evolving to be able to move our judiciaries to the next level. So that's a question of just linking up. How do we go from here? Yeah, thank you.
Thank you. Justice Wilson.
Thanks. See if I can get this out of here. Thank you, Carl. And aloha to you, Marcus. Thank you for your great work. And obviously, this is an exciting area for all of us, having to do with gathering of the data that's now becoming available to explain just how effective a judicial culture is. But with respect to the issue of the murder of environmental defenders, which is the Global Judicial Institute's been quite concerned about, and you alluded to it too, Carl. It's the idea of applying the rule of law in a way that's effective to protect the planet, to protect those people that are actually giving their life during this period of time that's so important to try to keep the earth from overheating. The idea of being able to protect them through the rule of law with the integrity, as the justice from Thailand has mentioned, could depend on using the database to identify the murders and to do so wherever we have electronic data. So if we're lucky enough to have it in Colombia, for example. So I am hopeful, Carl, that Marcus, excuse me, that we would be able to maybe have a working group of the Global Judicial Institute that can start focusing on the murder of environmental defenders and utilize this database in Brazil, perhaps, as a focal point for that working group. But thanks for your work. Aloha.
Any final questions before we turn back to the panel? Okay, one quick comment before I hand it over to the judges. I may have a solution on the data side. A colleague works at NASA, and NASA collects a lot of data, and they want to get it into the hands of people who want to use it. And one good thing about NASA, all the data is free. The European Space Agency commoditizes data, and NASA, it's all free. So it's a question of how do you access it? How do you process it? I'd be happy to hook you up with the right person after this. But maybe start with Justice from Thailand.
Yeah, thank you from the question from Thailand, our Georgia. So I think we talked a lot already about the execution of the judgment, but until now, because of the lack of the legislation, it's not so clear in the law. After the judgment, how can the court play more role? So I think firstly, maybe we need to review our laws. Environmental Procedure Act. Actually, we try to have the draft already, but it's still in the political conflict on that. And also maybe I think we learned the good model from maybe New York. It's like the problem solving court. Actually, it's for the juvenile court or women domestic violence law. However, I think if we believe in this kind of model, so the court can play more role in to execute the judgment. Thank you.
And then Justice Livio, I think there were a couple of questions for you.
All right. Enforcement is something that is not easy in any part of the world. One of the goals of this project is aligning technology with the enforcement as well. And so what we are trying to do, in fact, the partnership with the prosecutors, federal prosecutors, will be able to include the polygons of the lawsuits, the class actions in the map. And then with the polygons that has already been identified by the prosecutors, the judge will be able to use this data, this information directly in the lawsuits. So in fact, the main idea is not to need, for instance, to an expert to do an assessment of the damage, because we will be able to see the damage online. And this information we'll be able to use, has already been legislated about that. This information will be able to be used in the lawsuit directly online, the polygon, online information from satellite and everything. I think that this is really innovative and can change the way of the enforcement of the lawsuits regarding environment law and climate change as well.
Thank you. Justice Okongo.
Yes, if I may add on the issue of enforcement, we have a challenge also, but we have adopted a number of ways to deal with the problem. One of them is that we issue what we call structural interdicts, meaning you don't make a decision and leave it there. You actually monitor and supervise enforcement. So that is one of the ways we have actually tried to deal with the problem. Thank you.
What did you call that?
Structural interdict.
Okay.
Yes.
Thank you. This is an issue in a lot of countries, and I'd love to follow up with you on that.
Regarding the execution of decisions of the courts, I want to say that it's a rather important issue, of course, because the access of justice and a right of fair trial is not limited just to bring a case and get a decision of the court. Article 6 of European Convention of Human Rights provides for a right of fair trial, which as many times the European Court of Human Rights mentioned in its case law, it's included the execution of decision. So it's very important to have an effective system of execution decisions. And I can say that there are many problems of execution of decisions in my country, but thank to God, it's not regarding of environmental cases. So because of type of these cases, because if court decided that the appropriate ministry did rightly rejected some permission or others, or give permission with violation of laws, it can be executed very effectively. So it's there are not many problems in this sphere. Thank you.
Great. Thank you very much. This has been an incredible panel. Maybe would you like to say a final word?
Thank you, Carl. I think we are taking into the time for the break, for the wellness break, but this has been a fascinating panel. I think that we have discussed relevant questions starting from integrity, intellectual integrity, but also the threat to judges, right, who are working on these very important matters and upholding the environmental rule of law, to technology and to enforcement. So I would like to thank everyone for the participation, and most of all our judges for their insightful presentation. So a round of applause to all of you. Thank you.
Yes. Yes, thank you. Thank you very much to our chairs, Vasilina and Carl, and to all the speakers. Given that we are a little bit behind on time, we'll not take a full break. Rather, you may do so individually if you need to step out for a moment to get a snack or use the restroom. There are some food and drink items just right outside this side of the hall. So thank you again to everyone on this panel, and I'll go ahead and call our next panel to take your places here on the stage. Our next panel here will be on access to justice, nature, indigenous peoples, and environmental rule of law. And we'll go ahead and start it immediately, especially since we have several colleagues who are joining virtually. So our chairs for this panel are Georgina Lloyd, Regional Coordinator for Asia and the Pacific of Environmental Law and Governance from the UN Environment Program in Bangkok, and Marina Janusz of the United Nations Commission for Europe in Geneva. So they'll be our co-chairs, and I would invite to come forward speakers that we have on this panel: Arnold Kreilhuber, Deputy Director of the UNEP Law Division in Nairobi, who will be joining us virtually; Justice Joe Williams of the Supreme Court of New Zealand, also online. And then we have two speakers here with us in Stockholm: Kristen Walker, the chair of the IUCN Commission on Environmental, Economic, and Social Policy, and Professor Dan McGraw of the Johns Hopkins School of Advanced International Studies. So please, Dan, Kristen, and everyone online. I'll turn it over to our co-chairs, Georgina and Marina, to get us started. Thanks.
Thank you so much, Nick. And can you just confirm in the room that you can hear me? I will take that as a yes. Good afternoon, good morning, justices, judges, and distinguished representatives, and welcome to the panel of session 6, which, as Nick was just saying, will explore access to justice, nature, indigenous peoples, and environmental rule of law. I'm delighted to be co-moderating this panel together with Marina Janusz from the Aarhus Convention Secretariat of UNECE. So yesterday, during the 40th anniversary celebrations of the Montevideo Program on Environmental Rule of Law, we heard from environmental human rights defenders who are the stewards of nature and the front line of environmental protection. Many of these EHRDs are indigenous peoples whose lands, territories, and resources are threatened by relentless, unsustainable development, which places profit over planet, ecosystem health, and ultimately threatening the ability for future generations to have access to nature and healthy ecosystems. We've heard already in the panel that just preceded this one about some of the threats that are facing environmental defenders. The failure to reach not one of the 2020 Aichi targets is reflective of the biodiversity crisis. Also, the ongoing harassment, deaths, and intimidation of indigenous peoples and other environmental defenders is also symptomatic of the biodiversity crisis. So this panel seeks to explore the role that access to justice as a critical component of environmental rule of law places in addressing the biodiversity crisis and the serious and disproportionate impacts that indigenous peoples face when nature is threatened. SDG 16.3 calls for states to promote the rule of law at the national and international levels and ensure equal access to justice for all. While everyone should have access to justice, we must work particularly hard to ensure that groups at greater risk of injustice are protected and are able to exercise their rights, hold duty bearers accountable, and advocate free from intimidation for a clean, healthy, and sustainable environment. I'm sure that our panelists will, within their interventions, look to the Escazú Agreement, perhaps to the proposed post-2020 Global Biodiversity Framework. However, my question is, what more needs to be done to ensure access to justice for those who are seeking to fundamentally change the trajectory of destruction of nature? And to answer that question and to give us many other answers, I'm delighted to introduce our panelists. So we will start with Arnold Kreilhuber, who is the Deputy Director of the UNEP Law Division in Nairobi. Then we will hear from Justice Joe Williams, followed by Kristen Walker and Dan McGraw in the room. So without further ado, let me turn to our first speaker. Arnold, you have the floor.
Thank you very much, Georgie, for this lovely introduction, and great to see so many familiar faces from Nairobi in the room in Stockholm. I wish I could be with you all. But it is very encouraging to see this judicial symposium happening. Honorable judges, excellencies, ladies and gentlemen, it is a great pleasure for me to speak at this important symposium, which is of course held in conjunction with the Stockholm+50 conference. Judges, as we've heard over the past sessions already, play an essential role in analyzing and contextualizing the emerging influence of environmental human rights. This corresponds with the worldwide growth in independent judiciaries or courts with jurisdiction to hear constitutional matters and advance new constitutional rights and access to justice. Courts can ensure the security of environmental defenders and support effective continuity of their work. Across all regions, courts are vindicating rights in a wide variety of settings, from mining to water and air pollution, and new rights are continually being recognized. While many courts have expanded standing in environmental suits upon recognizing the monumental challenges of environmental protection, courts are continuously facing new issues related to their role in protecting environmental defenders. UNEP's upcoming report on environmental courts and tribunals, for example, will outline that strategic lawsuits against public participation, or SLAP lawsuits, are usually brought by claimants on non-environmental grounds, meaning that these cases would be heard in general courts. Therefore, if general court judges are not privy to environmental issues, they would fail to connect the genuine environmental concerns that the non-environmental lawsuits seek to overshadow. This failure to identify an environmental SLAP case means that it is not dismissed for injustice. Not only does this failure lead to dangerous and traumatic consequences for the environmental defenders charged, but it also substantially impedes environmental justice and protection. According to the Business and Human Rights Resource Center, at least 355 SLAP cases were filed from 2015 to 2021. 224 of these even involved criminal charges, most of which were for libel or other defamation charges. Because environmental defenders play an important role in upholding, implementing, and advancing environmental rule of law, their legal rights and lives must be rigorously protected by courts. And this point speaks to the continued efforts that we need to make to increase judges' understanding about environmental issues, and also the objective of the Global Judicial Institute on the Environment, which is so pivotal that judges have the necessary environmental understanding if these courses come before them. This is a week, and indeed a year, which invites us to celebrate the environmental movement and its achievements. The many governments, people, and institutions that have contributed over the last 5 decades to making the Stockholm Declaration a reality for people and for the planet. This is also a moment to celebrate environmental multilateralism, its highs and lows, its opportunities and its challenges, and to advance the conversation on how we continue to build on these achievements and lessons over the next 50 years. The last 50 years have demonstrated an impressive record of environmental achievement. Much more is being learned and done to protect our health and the environment. If 1972 was the year of bolstering the human rights and the environment linkages, the task for the global community since then has been to follow through on the great commitments taken by all actors. Despite how far we have come in the last 50 years, serious challenges continue to threaten these achievements. The triple planetary crisis is front and center of these challenges. Where gaps exist between law and practice, many actors have stepped in to secure rights related to the environment. From grassroots activists, indigenous peoples communities, and environmental human rights defenders, many stakeholders are speaking up for environmental action. This action has not been without consequence, at times resulting in successful outcomes for communities and the protection of natural resources, but often resulting in persecution, criminalization, violence, and killings of these groups and individuals. We have the framework in place, but 50 years since the Stockholm Declaration, we still have some way to go in creating an enabling environment for environmental justice and environmental action. As environmental conditions throughout the world become graver and more complex, litigants are increasingly using rights-based approaches to environmental protection and access to justice, and courts around the world are responding. The Stockholm Declaration has paved the way for greater efforts to link and promote human rights related to the environment, and this is evident from the many positive contributions of environmental defenders in protecting the environment over the last decades. But there are further areas that must be strengthened to enable greater protection for environmental defenders and promote environmental rule of law. The kinds of harms that environmental defenders have been, or that have been perpetuated against environmental defenders over the last few decades implicate basic rights, including the right to life, to freedom of movement, to freedom of speech, assembly, and petition, the right to the due process of law, and the right to live with human dignity, as well as criminal violations. There have been some incredibly useful tools that have emerged over the last 50 years to help secure these rights, and which should be used to prevent any forms of attacks against defenders. For one, international, regional, and domestic law, as well as the most fundamental principles of law, encourage participation in governance. In the specific context of environmental protection, international, regional, and domestic law has gone even further to protect rights of democratic participation over the last 50 years, thanks in part to the Stockholm Declaration. And regional human rights bodies followed suit, establishing the value of procedural environmental rights, access to information, public participation, access to justice, and effective mechanisms for implementation and enforcement. First in Europe with the 1998 Aarhus Convention, and then in the Americas with the Escazú Agreement, adopted in 2018, and which entered into force last year. There are also efforts underway in other regions to understand the needs for similar agreements in these regions. At the national level, procedural environmental rights are also protected in an increasing number of constitutions. This is very encouraging, as these provisions usually complement substantive environmental rights as well as procedural constitutional rights. Environmental action has benefited human rights and collective safety of communities across all regions. But I'll say it again, environmental defenders need our support. In facing ever-increasing complexities regarding our planet, people everywhere view environmental rule of law as central to addressing challenges of environmental justice and the disproportionate environmental harms suffered by already socially, economically, and politically overburdened communities. When we ask ourselves, why do people risk everything they have to protect the environment and those who live in it? The answer lies perhaps in that it is a matter of human dignity to exercise democratic rights for all purposes, including to secure the right to live in a healthy environment. And because the law in principle promotes, supports, and protects those who exercise their democratic rights in this way. The criminalization and increasing attacks on environmental defenders are clear violations on environmental rule of law and an affront to these rights, roles and contributions of indigenous peoples and civil society in protecting our environment. Last year, 227 murders of environmental defenders were reported. Once again, the most dangerous year on record for environmental defenders. What will these reports look like by the end of the decade? When attacks are non-violent, they take the form of litigation, and I have already referred to SLAPP lawsuits, which are increasingly being used to intimidate environmental defenders and to convert public interest matters into technical private law disputes. In addition, pervasive impunity and lack of accountability for crimes against defenders makes the situation more precarious, making the case for increased efforts to strengthen environmental rule of law even more urgent. Environmental defenders, many of whom are indigenous peoples, are often sentenced under vague charges of treason, subversion, or even terrorism, are held in harsh conditions, and are at risk of being sentenced to death. Some have also died in prison after being given long sentences. The key goal for all of us, in my view, is therefore to ensure that we will not be sitting in a room, virtual or otherwise, like this one in the future, debating the lessons of a failed decade. This decade until 2030 is crucial, not only for the SDGs, but for determining a better and more just and sustainable future for us all. At the national level, there are a number of actions that have shown to promote, strengthen environmental rule of law to enable the participation and protection of environmental defenders. What are these? High-level statements of recognition of the important and legitimate role of defenders, acknowledging the threats that they face, and commitment to their protection. Laws for the protection of defenders which mandate effective protection mechanisms and which contemplate the specific needs of rural, indigenous, and environmental defenders. Special prosecutors for crimes against defenders. Effective regulation and accountability for business actors. And lastly, consultations with environmental defenders to establish plans to tackle the root causes of the risks they face. Countries which have acted on these suggestions provide encouragement to others and signal an even greater role for judges in the protection of environmental defenders going forward. I don't have the time to go through all the examples, but let me just mention that in Colombia, the law on protection of defenders can be seen as a good practice example, which includes specific provisions within the General Criminal Code to respond to the fact that attacks and offenses against human rights defenders are frequently perpetrated by a consequence of their work, and that human rights defenders are at a greater risk than many other groups. In the UK, the Charities Act of 2011 specifically recognizes the work to advance human rights and that it's an area of work of public benefit. In Uganda and also in the Philippines, the Prevention and Prohibition of Torture Act or the Involuntary Disappearances Act, impose very clear duties on the state to protect human rights defenders. And you can find similar examples where increasingly the threats that environmental defenders face are treated and responded to by specific national legislation. And this is very encouraging. Other examples of countries that have gone on this path include Sierra Leone, India, Australia, Canada, and Mali has recently also drafted a national law on human rights defenders. In concluding, let me just highlight again that over the past 50 years, the judiciary has played an increasingly critical role with regards to environmental defenders. And this role is likely to increase. And whatever national legislations can provide in terms of additional tools, resources for judges to perform this role, this will help the international community drastically in terms of responding to these increasing threats that environmental human rights defenders face. But judges, in essence, can protect defenders by simply doing what judges do. Adhere to the principles of rule of law, remain vigilant in situations where people are threatened, and insist on civil and criminal accountability of those who threaten them. The aspirations that projected the environmental movement into prominence 50 years ago are alive and inspiring today's generation, many of whom are also identifying as environmental human rights defenders. And the message from today's defenders is clear. Tackling environmental challenges demands an intergenerational response, both from those who will inherit this planet and those who bequeath it to them. This judicial symposium, and indeed UNEP's work with judiciaries across all regions, demonstrates the strong contributions of judges in dealing with the triple planetary crisis of climate change, nature and biodiversity loss, and pollution and waste. It has shown us the judicial commitment in building a healthy environment for more peaceful, inclusive, and sustainable societies. At UNEP, we are determined to continue this engagement with you and judges across all regions to make environmental rights work for everyone, everywhere, and to contribute to the recognition and protection of environmental defenders. Thank you very much.
Thank you very much, Arnold. And I'm somewhat in the dark now because ESCAP has decided to turn off the lights. So I apologize if I'm a bit dark. But thank you, Arnold. And you highlighted a few really vital things such as SLAP suits and the need to have perhaps rules of procedure in place for environmental matters, for environmental cases that seek to prevent SLAP suits being brought. Amongst many other important points that you raised, but let's now turn to Justice Joe Williams from the Supreme Court of New Zealand. Joe, you have the floor.
Kia ora, Georgina. Tēnei te ara kei runga te araurangi atu nei te arau papa e takato nei. Tēnei te araurangi rā ko papa e takato nei. Kia rau te tapua e tāne ki raro nau mai te pō tēnei te ao tihe i Mauri ora. The brief prayer I just recited is used when something new is being launched, and I'm going to try and translate it. It's something like this. This is the path to my father, the sky. This is the path to my mother, the earth. The words I utter help bind my father, the sky, to my mother, the earth. I stand before the sacred footprint of my uncle, the forest, and I bid farewell to the darkness and welcome anew the arrival of light and understanding. I am going to take a slightly different tack, I think. I want to talk perhaps not so much about access to justice, but what is justice in the context of the environment. And it's 10 o'clock at night in my country, so I'm going to do it with a little less energy than I might have done if it was 10 o'clock in the morning. So bear with me, please. The system of law that I grew up with in my country in New Zealand was one introduced by Western settlers. It has some fundamental predicates. One is the idea that there is a central and impersonal government, unrelated in any familial sense to those it governs. Second is the idea that the individuals within my country have autonomy and separate dignity, and therefore rights. The third idea is that the relationships the humans in my part of the world choose to have with one another are, in theory at least, freely entered into by means of contract. So thoroughgoing is the idea of contract that, in fact, the promise to marry somebody was, until about the middle of the 1970s, an enforceable contract, the breach of which could turn you into a defendant in a court case. So relationships were between people in my country and in most other, what might be called Western countries, were arranged and organized by means of contract. And the relationships between the people and the environment were encapsulated in the idea of property. It followed from all of that that nature is a separate thing to be subdued and conquered. Now, over the period of colonization, the West decided that those peoples on the earth who did not share those ideas were backward and that they needed civilizing. They needed to be saved, and ironically, in the process of saving those people, the Westerners got to take all their resources too. That philosophy of a contractual approach to human relationships, of the deification of the individual, and of an impersonal and disconnected government, are now seen as deeply problematic. The discussion in the last, by the last speaker and in the last session about mortal attacks on Indigenous people and other environmental defenders is a discussion that's been going on since 1492. It is not a new discussion, it is itself a phenomenon of colonization. The Amazonian Indigenous peoples are not the first to be caught in its trap. They are in fact the last of thousands upon thousands of Indigenous nations treated in the same way over the last 500 and some years. So let me contrast that with something I do know about, the Maori approach to humanity and the environment. First of all, the idea of an impersonal government is, in my culture, rather strange. The idea that a judge is not your uncle or your aunt is rather strange. The idea that an individual is fully autonomous with no obligations and no necessary connection to a wider group is rather strange. The idea that one's relationship with other individuals is defined by freely entered into agreements rather than by kinship is rather strange. And the idea that your relationship with the earth, the water, the forest, and the creatures is defined as a relationship of property rather than a relationship of kinship is rather strange. So in my culture, the world hangs on the idea of kinship. You heard in the incantation, my father the sky, my mother the earth, my uncle the forest. In my culture, the water is an ancestress. She comes in many forms, and her genealogy is well known and often recited. In my culture, the mountain is an ancestor, and his or her genealogy is known and recited by those who belong to him or her. One of the most famous river tribes in my country, the people of Whanganui, say this: mai te kahui maunga kia tangaroa kuau te awa ko te awa kuau. From the distant mountains all the way to the sea, I am the river, and the river is me. So, nature is not nature in my culture. Nature is me, and I am nature. We are not a disembodied binary, but a single holistic being or series of beings. Now that means that what might be called nature in Western culture has in my culture certain rights and obligations. And judges like to talk about the rights of nature. But that's not really the indigenous way of looking at their place in the world. Rather, the relationship between the humans and the environment is a relationship of mutuality and negotiated coexistence. To speak about rights and obligations between myself and the environment is like speaking about rights and obligations between a parent and a child. In theory, they exist, but in reality, they are so inherent, there's no need to talk about them. And of course, that set of mutually negotiated coexistence-based obligations and rights are backed up by rules and values. These ideas in my country are slowly finding their way into the structure of our environmental law. So the river that I talked about, the Whanganui River, I am the river and the river is me, has been recognized as having legal personality in some recent legislation in my country. Now, of course, in Western thinking, that's an incredibly radical idea. But in Maori thinking and indigenous thinking, it's utterly orthodox and has been so for thousands of years. It's just that the Western law is catching up. In my country, the largest river system, the Waikato, is jointly managed by the central government and the river tribes. and the river hasn't stopped flowing. In my country, one of the densest forests in the Northern Island, the Urewera forest, has a recognized legal personality. None of the birds moved out. These environmental components, you might call them, these places with which Indigenous peoples have deep, intimate, kin-based relationships, have become stakeholders in their own right, have become, in a sense, a second form of citizen. Here we are just beginning to explore the implications of integrating these Maori custom law approaches with Western forms of environmental management. And it's too early to say whether that integration will work or not. But one of the challenges is for judges to come to understand not just the colonizers' view of relationships with the planet and with each other, but the Indigenous people's view of relationships with the planet and each other, because they too are now a part of the law. We've started with a few environmental components, I guess, that have been recognized by our legislature as having legal personality. But it seems to me inevitable that over the next generation, the idea of iconic environmental components having personality will seep into our general law, either through the legislature or by judicial pronouncement. The government last year announced a new policy on the all-important environmental component of water. The interesting thing was that the policy was named Te Mana o Te Wai, the dignity of water. A deeply Maori idea, a deeply Indigenous idea, seen as resonant not just for the Indigenous minority in my country, but for all. So, it seems to me that if we are to speak of access to justice, then we have to understand what justice is. And the process we are going through in my country is redefining justice so that it is not Western colonizing justice, but the integration of Indigenous knowledge and values and Western science. This is important because the process we have been embarked on now for, I guess, 20 years or so, and we're still only beginning, is the process of decolonizing our environmental law, and in the process, producing true environmental justice. Perhaps that's a good point to stop. Tēnā koutou.
Thank you so much, Justice Williams. And I think the point of giving priority and to customary law and recognition to customary law is an incredibly important perspective that needs to be captured further across the region and globally. And as you said, it's a matter of laws catching up, the Western colonized laws catching up to the knowledge that is thousands of years old. And I think the important case of the Whanganui River is one that, although you say it is not radical, to traditional thinking and traditional culture, it is one that was, it's, I think, still incredibly important to take those steps in that direction. And you say that there are still environmental components that are being given legal personhood. At what point will we get to the stage that ecosystems are given personhood rather than just components of the environment? Thank you so much. And I'm sure we'll have some questions and come back to those ideas. So next, we're going to pass to Kristen Walker, who is in the room there in Stockholm. So Kristen, you have the floor.
Great, thank you. And I just want to acknowledge I'm so pleased to follow Justice Joe Williams. I've heard so much about him for many years. So my name is Kristen Walker-Painemia, and I chair the IUCN Commission on Environment, Economics, and Social Policy, but I also work at Conservation International. I'm not a judge. I'm not a lawyer. I'm a mother. I sit in the crossroads of social issues and conservation. And I'm also married to a Mapuche Indian whose family has also suffered as environmental defenders, where my father-in-law has been jailed in defense of his own territory. So when I listen to Justice Williams talk about what is justice, that is the question we have. At the IUCN Congress in Marseille in September, through the work of the Commission, we launched a campaign and work around reimagining conservation. And I think it's really appropriate to bring that conversation here. We are here this week celebrating Stockholm+50. I think we've heard what has happened since, and much has been achieved. But I think if we look, we're on a cliff, right? We're on a cliff in terms of the lands that we occupy, the air that we breathe, the rights that we have, the identities that we have. And it's time for us to sort of wake up. Plus, we are on borrowed time, and we are borrowing this planet from our future generation. So I'm here really to think about, and the question that Justice Williams posed is, what is justice? And what I wanted to pose to all of you is, as a component of this reimagining conservation, which is a Western construct as well, we have talked about reimagining justice within the context of the Commission, within the context of the work I do at Conservation International. We often work on the issues of human rights and conservation. I work with environmental defenders, whether it's Indigenous peoples or whether it's staff at Conservation International, at staff at other organizations. And I think what I wanted to bring to this conversation is, how can we work across these issues? And I very much appreciated the judge from Thailand talking about intellectual integrity and talking about, one is, once a decision is made, it's done, according to justices, right? And then it has to go to enforcement. I think we know there are plenty of environmental laws out there. And really what happens is the implementation of those laws. So we have one side is the implementation, and the other side is the actual access to information. And I listened to you all talk about the new portal and the issue of language. While it does have translation, some of you are also limited by the languages those come out in. So take that to a community context. In PNG, there are 700 languages, right? Take that to a community perspective who are trying to defend their territory, but the language they speak is not the language of law. And how can they possibly be able to defend their rights and their lands if they don't have that language, or if the language of law is not in their own language? So I just wanted to bring that together in terms of these issues. One is taking those conversations down to those communities who are on the ground, those who will be in charge of and are in charge of taking care of their lands, their waters, and their territories in many manifestations. But how can we bring a better dialogue together with judges who are all here in this room, but with communities? And part of this reimagining work that we're doing is in a platform of 4 simple things. Listen. How can we all listen better? How can judges listen to communities? Listen to those defenders of what's happening? How can you open up a broader dialogue and build that awareness and understand the social and economic issues? And also look at those problem-solving court models that could happen. But then also, from your perspective as judges, how can you imagine? How can you imagine coming over those hurdles and being able to support and implement what is there more effectively? And then finally, how can the collective take action? You are all here as judges trying to help each other be more grounded in environmental law. But how can you collectively take action? And I think, or protest in your own way of making sure it's done effectively. So I just wanted to bring that to this conversation, is how do we ground those things? How can the collective reimagine justice, or perhaps define what justice is from various perspectives, as Joe Williams said? And I think that's a task that I charge you all. We are all here this week celebrating success, but also on the cliff of potential failure. And we need to recognize that. So my comments are short. I tend to challenge, I like to provoke, and I really like to poke Antonio a lot on these issues. So he knew what he was getting when he asked me to speak. But I wanted to just leave you with a poem. As part of the work that we're doing in the IUCN Commission on Environment, Economics, and Social Policy, we are working with environmental defenders. And we launched a 3-part publication on environmental defenders that looked at the many faces of environmental defenders, how grassroots are in action, and then what do we need to do to protect them? And we did that at the IUCN Congress. There's a 3-part series. We're happy to share it. But what we did is not only told their stories, but shared their art and their poetry. So I wanted to share a poem that's a bit challenging, I think, for you all to listen to, but it underpins what the issues are. So I ask you all to close your eyes, take a deep breath. And this poem is called The Supply Chain of Violence by Sams Illingworth. Illegal logging in community forests, oil drilling in indigenous territories, mining concessions in native soils. These have become our war zones. Activists hailed as terrorists, while global agribusiness is paraded as unchallenged and unchosen liberator. Forever on the right side of progress, writing its history with checks and laws and body bags. Outsourced resource consumption underpinned by marginalization turned ancestral lands into contemporary killing fields. Defenders fall in muted protest, their deaths the tip of melting icebergs, as slow violence bleeds through faceless communities. Trading alms of avars, we wash our hands in waters, offering salvation for those that we no longer care to name. So this is the picture that we need to change. We've heard about the experience in New Zealand and how that's changing, but it's taken time. But I think we need the bridge to gap between what we have here and what we're confronting and where we need to head and who has rights and what is justice. So I challenge you all in your roles in your countries to think about how you all can work with stakeholders, communities, activists, and reimagine justice. Thank you.
Thank you very much, Kristen, and thank you for the challenges and the challenging words that you presented. That I think what you said about the language of law was very interesting. The language not only in the linguistic sense, but also in the conceptual sense as well, when the very foundations, very concepts within those laws may not be the same as the concepts understood within the communities who are expected to address access to justice under those laws. So thank you so much for that. And that poem you read was so powerful. And I think we need to talk more about the businesses, about the industry. We know we have the data that says that mining, agribusiness, these sectors are causing the greatest number of violations of environmental rights perpetrated against environmental human rights defenders. And so I think we need to talk a little bit more about how, why, and what do we do to really address the issues that are there. Thank you so much. So we now go to our last speaker, Daniel McGraw, who is from the Johns Hopkins School of Advanced International Studies. Dan, you have the floor.
Thank you very much. It's an honor to be here. I am a lawyer. I'm not a judge. I've been an arbitrator, but I deeply respect the work that all of you have to do. And I want to say that it's hard. It was hard to imagine in 1996 when Donald and others started this work that we could ever have a meeting like this. And I hope you all recognize that this is one of those success stories, actually, that we need success stories. This is one of them, and you're part of it. And I thank you all for that. There's truth in what each of the earlier speakers said, and I want to refer to that. In terms of what Arnold was talking about, the space for civil society to participate in environmental and human rights protection is diminishing. It's partly because of SLAPP suits. It's partly because of restrictions on access to information and communication technology, to the internet and that sort of thing. There are other restrictions as well that are being imposed. And judges, I think, have to be very aware of that. In terms of SLAPP suits, I've always wondered why there aren't more cases that recognize an abusive process, for example, but that's just my own view on that. What Kristen is talking about, she's talking about a broader view of judges, I think, as being parts of civil society, parts of the community, and her challenge is extremely important. What Judge Williams talked about is something I want to talk about in a different context, in a sense. I want to talk about a recent tool, because I know as an arbitrator, we had to apply rules. As judges, you have to apply rules. I think rules matter. I represented the Mapuche, for example, in the Inter-American Commission on Human Rights, and I think we were able to protect their rights to a significant degree because we had laws. We had human rights laws that we could work with. And so as much as I agree with Judge Williams about we need to reconceptualize humans' relationship with nature, I want to come back to the rules that you all need to apply as well. The one I want to talk about primarily is the right to a healthy environment. Now, as you may know, many constitutions and national laws and even treaties contain this right. It's phrased differently in different instruments, but now there are about 155 countries that are, at least in theory, legally bound to respect the right to what we call a healthy environment, the right to a healthy environment. Countries do this to different degrees, as you can imagine. And one of the goals of many of us has been to get universal recognition of that right as a human right. And we achieved that this fall. It was a remarkable constellation of efforts by many, many different people, including businesses and children and NGOs and 15 parts of the UN system. And I could go on. But in the Human Rights Council on October 8th, by a vote of 43 in favor, 0 opposed, and 4 abstentions, it was universally recognized that there is a right to a healthy environment. And so it's something we're going to the General Assembly now. We are fairly certain it will pass. We're also certain there will be a vote. There will be countries, Russia, the United States, that will block consensus. But we think it will pass. Over 100 countries have formally endorsed it. And so the question is, well, is this a big deal? I mean, we've now changed the pantheon of human rights. There is now an environmental right in that pantheon. There wasn't, of course, in 1948 because there was no environmental consciousness. We weren't thinking that way. But there is now, and it will be more powerful once the General Assembly endorses it. So the question is, well, what's the value added there? And I think there are quite a few things, and I think it will come up in your court. So that's why I'm raising it, obviously. One thing is that it adds substance. It's different than adding the sum of the right to life and the right to culture and those different rights. And I wasn't convinced of that myself, I should say, until I represented the Inuit and the Maldives, both of whose cultures, whose whole existence is threatened by climate change and other environmental harm. And I realized that it's not just the right to life, which is threatened in both cases, or the right to culture, again, threatened in both of these very, very dissimilar environments. It's really a more general issue of the right to a healthy environment, a right to an environment that's capable of supporting our civilization, of our societies. So that's one thing. It adds substance. A second thing it does is that it clarifies the scope of what countries' obligations are. They're the duty holders, states, and it talks more about the whole environment. It doesn't just talk about, again, the right to life or clean air or clean water. It's the whole interdependent system of the biosphere. It also is a capstone in a way. And what we've found is that countries that really try to respect this right have better environmental outcomes. And it can lead to a kind of normative cascade of different protections of people, primarily about the environment, but that includes the working environment, et cetera. It also can be a hook in the sense that countries, intergovernmental organizations, agencies, parts of organizations like UNEP can use to organize programs and to get resources. An example of that is in 1996, we were able to get the global community to agree to eliminate lead from gasoline. Now, it took many years to actually have that happen. But once we had that happen, we could go to UNEP and say, let's have a program on this. Let's get funds for this. And a couple of years ago, Algeria was the last country to eliminate lead from gasoline. That saved millions and millions of lives. There's no question about it. But we needed that hook. We couldn't really do it globally until we had that global agreement at the head of state level. So this is important in that sense. I mean, as a judges, you don't have to worry about that, I think, but understand that it's an important right from that point of view. It also can be a springboard, I think, for going back to the issues that Judge Williams raised. I mean, it's a right, it's a human right to a healthy environment, so that the duty is owed to humans. But the object that has to be protected in a way is nature. That is, nature has to be protected. We have to have a healthy environment. And I think it's a way to begin to have a different discussion about this relationship between humans and nature that can be very healthy and is totally within both kinds of traditions, I would argue. Also, the final point is it completes the notion of environmental justice. A couple of the speakers this morning have mentioned that concept. And it has a number of different components. One is that no group, indigenous peoples or environmental human rights defenders or any other group should bear a disproportionate burden of protecting the environment. A second is that all groups should have equal access to environmental amenities, clean drinking water, sanitation, spiritual, recreational activities that nature provides, that sort of thing. A third is the ability to participate effectively in decision-making about the environment. A fourth is our access to justice that all of us are talking about here. But you could have all of those without having justice. If we go back to what Judge Williams and Kristen were talking about, and Arnold too, we need to have justice there. We need to have an outcome that is just. And the way to get to that is with the right to a healthy environment, because that will be a just outcome. So I recommend this to you as something to think about and to honor if it comes up to you in your courts. I want to say one more thing about, and that has to do with indigenous peoples. From a lawyer's point of view, this question raises a lot of issues. When I was the president of the Center for International Environmental Law, we represented a group in the Amazon that did not want to be contacted. So we could not talk to our clients. And you could imagine the kinds of issues that raises. But nevertheless, and it's not just a language issue, it's a whole way of life whole outlook on life, a whole ontogeny that's different. And to have, as a lawyer, to try to somehow interface with that is really very different. One question I have for Judge Williams is, I'm not sure all Indigenous peoples view these things the same way. If they do, that makes it easier to try to make sure they're involved. I'm just not sure that's correct. But in any event, that issue is, Indigenous peoples have all the regular human rights. They also have rights under the UN Declaration on the Rights of Indigenous Peoples. And there are other things happening too. It's a dynamic system in the International Law Commission draft principles that were just approved on protecting the environment in the times of conflict. There's one article specifically about Indigenous peoples' lands and protecting those. So, as we know, the law is not static, it's dynamic. But we have to pay particular attention for various reasons to access to justice by Indigenous peoples. Thank you very much.
Thank you very much, Daniel. And, putting the focus on the upcoming, hopefully, General Assembly resolution on the right to a healthy environment, that will be a very important step to further the recognition of the right to a clean, healthy, and sustainable environment following the Human Rights Council resolution last year. So now it's time for the Q&A, and I'm going to hand over to my co-moderator, Marina. You are here?
Yes, thank you very much, Georgie. Distinguished participants, I am honored to join this meeting today and the co-chairing this session from my dear co-chair, Georgina from the UN Environment. Thanks all the speakers in this panel for their inspirational and thoughtful presentations. I assume that all participants have many questions to the panelists and would like to suggest continue this fascinating discussion and invite participants in the meeting room to come to the microphone and online participants to pose their questions in chat. And then we can invite the panelists sharing their brief feedback, and I can sum up the session. Thank you very much.
Hello, my name is Ragnhild Nord. I'm a judge in the Supreme Court of Norway, and I will thank you very much for very interesting presentations. You are highlighting Indigenous peoples and what climate change and environmental degradation can do to their culture and their way of life. We had a case in the Supreme Court of Norway recently, which was about this aspect, but the damage was caused by the erection of windmills, which was erected, of course, to try to combat climate change. And it's necessary in Norway to erect a lot of windmills if we are going to manage the shift towards a greener economy. But the Sami group who lived in this area and who had reindeers grazing in part of this area sued the government and said that this erection was in breach of the Convention of Civil and Political Rights, Article 27, which gives Indigenous people right to have their own culture. And the Supreme Court of Norway assessed the case, and in fact, we came to the conclusion that the decision to build these windmills, and windmills were already standing, but it was in breach of Article 27. But it's a difficult case because Sami people are also those who are most affected by climate change. They need these windmills also. But still, we came to this conclusion, and mainly because we found that there would have been possible to put these windmills in areas where they didn't affect the Sami people that much. But still, the windmills, they are still there. It will be extremely costly to take them down, and we don't know exactly what will happen. But I just want to put this on the table as an example for all the difficult challenges on this area.
Thank you very much for the excellent question, Justice Neuer. I could say also from our experience in the region, there is an increased number of cases related to renewable energy. And of course, it explains that we are now in the era of great energy transition and increasing use of sources from renewable energy. And we know that many list of hazardous activities that have been established, like in the Aarhus Convention or the ESPO Convention, they have been negotiated 20 years ago, maybe when these technologies were not yet spread. And sometimes they indeed, the decisions on launching these activities, on approving these activities might go under the radar of the environmental impact, or it's maybe difficult to balance all the interests that are involved in this case. And I really appreciate your question and would love to hear the view of the panel on this matter.
I'd be happy to comment. Thank you for telling us about that case. That's very interesting. Nobody said this would be easy. And that's one of your points. It was very hard to get the international community to recognize that climate change and human rights were related at all. I mean, it seems obvious, I think, to lawyers that if a state has to obey human rights with respect to all of its activities, that includes activities regarding human rights, including mitigation of climate change, including adaptation of climate change. So, but getting countries to agree to that took literally decades. And so it's important that countries are now doing that. In terms of replacing the windmills, well, things are expensive sometimes, and there are going to be conflicts about that. It does, as I think our co-chair was saying, it reminds us of how important environmental impact assessments are. And there is a human rights obligation actually to do an environmental impact when an environmental harm might impact human rights. And that's established. That's an international human rights law impact. And as we also know from the International Court of Justice, there's a general international law obligation to do that in the transboundary context. But this was not transboundary, I take it. It was within Norway. Well, thank you.
Thank you very much for the thoughtful feedback. I would.
Can
I comment really quickly?
Oh, sure.
Or someone online?
Yes. No, you go ahead.
Are you sure, Joe?
Yeah, that's fine.
Without knowing the case, except for the results, I guess my question was, how did it get that far? Because it was already established, right? I guess I'm thinking that how did it get that far that it would have already been constructed? And I know that in the work that I do, we have been working with Indigenous peoples and negotiations. Learning from what our Aboriginal colleagues in Australia and First Nations in Canada have been doing related to negotiating agreements related to their lands and territories, whether it has to do with oil, gas mining, or conservation, and how do you bring in their traditional practices in negotiating those agreements, but also Western sort of legal tactics in doing that to make sure that the outcomes abide by their views, but also that they benefit from the agreements that are happening or can reject them as well in terms of using those things. So we won't have time to open up the case, but I guess my question in my head was, how did it get that far that they're already constructed and needed to take down? But
I can just answer shortly. The Sami people took it to the court to try to stop it before it was erected, but the court said no. So as a pre-assessment, they found that it was legal, but they also then was given or a big amount of compensation. And so everybody thought that they would say yes and thank you and stop there, but they didn't.
Yes, ma'am.
I think Justice Williams wanted to say something. I thought I heard his voice.
Okay.
Well, I was just going to add to the comment that Kristen made. In my country and other countries a bit like mine, it's usually the case that the first property to be compulsorily acquired or condemned, I think you Americans call it, is the indigenous resource, whether it's for a road or for a dam or whatever it might be. And the level of procedural safeguards around that has in the past been very poor. And it does appear to me that that may well have been the situation in Norway. I did say that the trick is negotiated coexistence. And in order to achieve that, there has to be high levels of trust and engagement throughout. And for the most part, we're not there yet in most parts of the world.
Thank you very much. I thought that there was also interest to speak in the room.
Thank you so very much. Yeah, we can speak on the mic.
Yes, thanks. Sorry. I feel a little intimidated. It's long since I appeared before this number of judges. My name is Keriako Tobiko from Kenya. I am the minister responsible for environment and forestry. We are here as part of the co-host with Sweden for the Stockholm+50 celebrations. Now, this event was mentioned to me this morning by my colleagues who are here, and I'm quite proud of them. Donald, it's an institution. Judge Samson, again, a judge who in Kenya, a very short time, has managed to organize, and you had him say structural interdict in terms of litigation. Kenya's constitution is one of the first constitution to include a fundamental human right to clean and safe environment, courtesy of his court and his colleagues. Jurisprudence now has been developed in Kenya. And I'm a lawyer by training. I was once a prosecutor. When I was appointed Minister for Environment and Forestry, everyone was wondering, what does law have to do with environment? And sitting here now, I'm sure you have answered that question. Kenya is one of the leading countries, being the environmental capital of the world. Our jurisprudence, we have just tabled before our parliament a revolutionary amendment to our environmental law, which includes a number of what I have had the judges speak to about today, including the protection, recognition and protection of environmental right defenders. It's now in a law pending before our legislation. You know, some countries were mentioned, Kenya was, but yes. Also recognizing the right of nature, distinct from the right or the right human rights. And similarly, and this is very important, a crime of ecocide. I'm sure just as much as we're talking about establishing jurisprudence at domestic level, and the debate about who bears attribution for bearing the greatest responsibility, and especially where we're talking about climate change. So Kenya's law now pending in the National Assembly includes the crime of ecocide. We borrowed largely from the template that is now before the ICC, maybe I missed during your discussions because we have been pushing so very hard at global levels in COP26 and other COPs. Now we will have COP27 in Africa. The responsibility of those who bear the greatest responsibility, historical and current, for the greatest greenhouse emissions. And the whole issue about loss and damage, who should bear responsibility, and so on and so forth. So to be very interesting, and this is a question, the professors and the judges, whether at international levels, these establish or can be established the principles of liability for those who bear greatest responsibility for those harms that flow from. And finally, we meet as ministers for environment. Judges meet as environmental judges. I wish, how much I wish that my colleagues, I've just come in from another meeting with ministers for environment, and I wish we were here to see what is the interface between jurisprudence, law, and practice and policy. We in executive, we make our own policies and sometimes take our decisions without necessarily reflecting upon or being informed our advice about the jurisprudence, the best international standard. So my suggestion is let's look at see how, whether, including business. In the morning we spoke so much about financing nature. So and I congratulate you, judges, and see how we can work together. And we need a policy interface with judges. And finally, under my ministry, we have we have subordinate tribunals that do also dispense environmental justice. And I believe the same applies for other jurisdictions. And I don't know, and I'm sure a number of appeals go to our environment court. And how do we harmonize the jurisprudence of our subordinate tribunals with the High Court and Supreme Courts that you judges preside over? I thank you.
Thank you very much for sharing many important points, and your intervention highlights actually the crucial importance of looking into the nexus between the environment and the human rights and the good governance. And only this nexus approach could help us to advance in action into better protecting the environment. Very often, many decisions indeed are taken into silence. And systems that were presented, for example, in Brazil, there's a digital tool could actually serve as a very important point for the decision makers, because seeing the greater picture of where the legal challenges are in the country, at which stage of decision-making process, could actually help to improve the decision-making itself and to improve laws, to strengthen the procedure that recourse to justice is not indeed done at the very later stage, and the problems can be anticipated at the earlier element. And I would like to see to invite also panelists if they would like also to comment on the point that mentioned by the Honorable Minister of Kenya.
Well, thank you, Minister. I would comment on a couple of points the interface between the executive and the judiciary is always, it's like porcupines cuddling. You have to do it very carefully. And there's good reason for that. I agree that there'd be a lot to be said for sitting around a table and having an open and frank chat, but it's a very dangerous thing to do. And the better thing to do is to have a chat on the end of a 40-foot barge pole called case law and statutes. Unfortunately, but the independence of the judiciary is too important for the sort of conversation we'd all like to have actually have. As to, I was struck by that idea of the crime of ecocide. I'd be very interested to see how that crime is articulated and how widespread that is beyond your country, beyond Kenya. One of the things I think this organization must have been constructed for, this is the first time I've ever participated in anything related to it, and one of the great contributions it can make is in sharing developing standards, developing principles, developing values in the application of environmental law by the judiciary, so that we are not in our own silos, me at the bottom end of the Pacific and you in Africa, each of us independently reinventing the same wheel. Inevitably that produces a wheel that's got a wobble or a flat tire. So this opportunity to share these ideas, to hear what is best practice, what has worked and what hasn't worked, is something that is greatly empowering for judges who are having to apply law to actual facts usually that the politicians haven't thought of.
Thank you very much. Are there any other contributions also in the meeting room?
If I could ask a question, and I am particularly interested in asking Kristen and Arnold about the role of judges with respect to environmental defenders. This is a great luxury to have two people who have spent so much time giving consideration to the unfortunate pattern that's arisen, which is a continuing use of murder against a group that's maybe the most committed to trying to protect the earth. But with respect to the role of judges, would mention that one of the great justices of Colombia, Luis Tolosa, flew to Peru because of indigenous leader that was assassinated, Edwin Chota, in 2016, to support the village of Edwin Chota. I suppose that might be an example of something that could be done in an organized way by a group like the Global Judicial Institute on the Environment. But on the other hand, there's a concept of judicial independence that would suggest that judges aren't actually supposed to be involved in promoting prosecution. So you've got the role of judges to make clear that the rule of law that is important includes not using murder. So the rule of law should be applied there, but how far can judges go? So I'd be interested, Kristen, in what your thoughts are maybe about the extent to which judges can help in an organized way. And Arnold, I know that's been a big focus of yours, so I'd be interested in your thoughts about that.
Thank you very much. Can you comment, please, on Arnold? And
Marina, you want me to go first or Kristen goes first? I lost the audio, Marina.
Sorry, I suggest that as you open the microphone, maybe you can go first. Thank you.
All right, happy to do so, Marina. And aloha, Mike. Good to see you. I really wish I was there with you all. But Mike, I think in part you've sort of answered the question. I mean, what I tried to highlight also in my remarks to you a little bit earlier is that we at UNEP feel one key challenge for judges is awareness of the challenges that environmental defenders are facing, right? I've hinted at these SLAP lawsuits, but also the basic understanding of the role that environmental defenders play in the administration of environmental justice. And I want to congratulate also my learned friend Dan, who has really summarized excellently the different components of environmental justice that we believe judges need to look at. But ultimately, Mike, I think we need the entire enforcement chain to work on this complex topic. And so you're right, we need prosecution, we need enforcement agencies. And that's why we at UNEP also, when we look, for example, at environmental crime, and the minister mentioned these very exciting developments that are happening in Kenya with respect to that, we need the entire enforcement chain. And then, you know, the judiciary needs to do its part. But I also try to illustrate that for the most part, I think judges going forward simply need to do what judges do, right? But with this additional or added increasing awareness of the environmental issues that come before courts. And that's why what you are doing in this room right now in Stockholm is so important, and what the Global Judicial Institute on the Environment does is so important. We need to improve the understanding, the awareness, and the education of judges on environmental matters, because this, I believe, will go very, very far in protecting environmental defenders when cases of intimidation, threats, harassment, come into court proceedings, so that judges are aware of the underlying issues. I've highlighted a lot of these SLAP cases, of course, brought on completely different matters, but if judges have that understanding, then they can make the right connections and ultimately then protect the environmental defenders. But long story short, Mike, I think we need the entire enforcement chain. That's why we at UNEP, yes, we have a focus within our work to work with judges, but we do also work with the other legal stakeholders to make sure that also they are aware of the threats that environmental defenders face, because only then can we make a difference. And as the minister has rightly pointed out, there needs to be also, and this is, I believe, part of environmental rule of law, the legal basis needs to be adequate. And so also our work with parliamentarians is underpinned by this effort to make sure that, from parliamentarians onto the enforcement chain, ending with the judiciary, we have the same sort of objective in terms of protecting environmental defenders, because only then can we make a difference. Many thanks for the question again, Mike, and back over to you, Marina.
Thank you very much. And I would invite Kirsten to also to share the perspective.
Yeah, I mean, I think I would agree with that. It's building that awareness, right? I mean, Global Witness puts out a report every year. We know that 227 environmental defenders died in 2020. And understanding the why, the how that happens, and understanding that in that decision-making process is probably one of the most important things that can happen, and how you move that forward. But I think, as been highlighted, it's the whole system. And I think part of this reimagining is looking at the systems we have to protect the planet, whether it's through the judiciary in the court, or whether it's through how we actually protect nature in different ways. These are the things that maybe aren't as sexy out there that people want to talk about, but it's how do you tweak those systems or rewire things to be able to respond more effectively to the issues at hand. And I think as judges, the best thing is to be able to build awareness, understand what's going on. and then see how things are executed into the future. But I think that's probably the best thing. Dan wants to respond.
Thank you. If I could just add to your question, what can you as an institute do? It seems to me that one question that came up in a webinar a couple months ago was, well, what should the standards be? And I think that that's something that the Judicial Institute could engage in a discussion about. There is a case in the Americas that says, well, it holds that what a country needs to do is, first, it shouldn't interfere with an environmental defender, if you want to use that term. Second, if there's a threat to an environmental defender, it should protect against that threat. It should take action to stop that threat. And third, if there is harassment, and we have to remember that murder is just one way of harassing. The Kenyan judge described the case of the lead batteries. Well, the woman who brought that, her partner's kid was kidnapped. And, as part of the retaliation, and was only released actually when the head of UNEP and the special rapporteur on human rights and environment contacted the president of Kenya and said, you've got to help. And he did. And the child was released. But there are all sorts of ways of harassing. So this covers all of it. But on the third point, when there is harassment of any type, then there should be a serious investigation and prosecution. So I think if those standards were well known, and the Institute can help train judges on that, then that would do something. That won't take care of the problem, but it would help.
Thank you very much. And I know that this is a fascinating discussion, but I'm afraid that unfortunately our time is running out. I get many helpful takeaways from this discussion, and actually that underline not only current challenges, but also opportunities and actions required to safeguard the nature and environmental systems, empower people, and guarantee the rule of law. And the Stockholm Declaration initially paved the way to many multilateral environmental agreements. And one important point that was mentioned by several speakers is that the judges have a pivotal role to play in interpreting provisions of domestic law in accordance with these treaties that establish the common standards in the various areas. For countries in Europe, the Caucasus, and Central Asia, the Aarhus Convention and its access to justice pillar became a common ground influencing environmental case law and providing legally binding standards in empowering people to seek justice in cases of information refusal and flaws in decision-making and compliance with environmental law by public authorities and by private persons. Following the Aarhus Convention example, the Escazú Agreement also embedded access to justice provisions for Latin America and the Caribbean. And COVID-19 pandemic underlines the importance of this international legally binding standards and standing scope of review, costs, and remedies that should be complied by the parties, and overcoming existing barriers in access to justice, notwithstanding other crisis pressures from economic and social dimensions. Additionally, both treaties, as well as also mentioned earlier, a human rights instrument and other initiatives are stepping up the protection of environmental defenders against murder, unfortunately, harassment, and any other form of retaliation for exercising their rights. And strategic lawsuits against public participation or abusive litigation, their threats and their impunity also have become a significant barrier to access to justice that requires special legal and practical measures for their detection and prevention. We have heard that additional barriers are faced by indigenous people, people in the rural areas, people in informal settlements, poor people, and other groups that can be disproportionately exposed to environmental injustices. And these challenges include distances to courts, access to legal and environmental expertise, and language barriers. A special assistance to such groups should be considered to enable their effective access to justice, and we would need to continue to search for good practices and solutions in this area. Handling of environmental cases also bear legal, scientific, technical, and social complexities. Specialization, access to advanced training programs in environmental law, and independent environmental expertise and assessments can provide critical solutions for effective handling of such cases. And promoting judicial cooperation at the national, regional, cross-regional, and global levels remains crucial for harnessing good practices and innovative tools in this area. So let me warmly thank the organizers and contributors of this session for their excellent event, and confirm our readiness to continue the collaboration with all present partners to turn thoughts into action for strengthening access to justice, protecting environmental defenders, and promoting environmental rights, the rule of law, and environmental matters. Thank you very much. And with this, I close the session.
Thank you very much to our co-chairs, Georgina and Marina, and to all our speakers. That concludes the morning session of today's portion of the symposium. We will now break for lunch. Lunch will be, for those of us here in Stockholm, will be upstairs in this hotel restaurant, and we'll return here to begin promptly at 2:30 in the afternoon.
In fact, we need to be here at 2:20 because there will be a short video from Kazakhstan, and then we start the afternoon session at 2:30 promptly. Remember that in addition to the fantastic panels we are having in the afternoon, we'll be receiving Achim Steiner, the head of UNDP, and Elizabeth Medema, the head of the Convention on Biological Diversity Secretariat. So we really need to do work within the time framework we have done. It has been great. Congratulations to everyone. So a good lunch, and many thanks to our panel. You guys need that, okay?
We'll begin in just a moment. Yeah, we'll begin in 2 minutes. Thank you. into that then.
Yeah.
How long does everybody have? 10 minutes?
10. So
Okay.
it's like an hour.
All right. Thank you. Good afternoon and welcome back to all of you to the final afternoon of our symposium on judges and environment. We'll begin this afternoon session with a brief video. And for that, I would like to introduce and recognize Justice Beybut Shermokhamitov from Kazakhstan. And we have, I understand, a brief video from Kazakhstan to show as well.
В публично-правовых спорах при обжаловании решений и действий органов власти граждане зачастую находятся в неравных условиях. Их возможности несоизмеримы с ресурсами госаппарата. Поэтому необходимо внедрение административной юстиции как особого механизма разрешения споров, нивелирующего эту разницу.
С момента обретения независимости в правовой системе Казахстана отсутствовал действенный механизм защиты прав и свобод граждан и юридических лиц в споре с госорганом. Создание административной юстиции имеет важное значение для утверждения верховенства права. С 1 июля вводится в действие совершенно новый закон – Административный процедурно-процессуальный кодекс.
Последние 15 лет введение национальную правовую систему Института административной юстиции стало одним из ключевых направлений реформирования административного права. С принятием нового административного процедурно-процессуального кодекса Казахстан стал на принципиально новый прогрессивный путь развития культуры рассмотрения публично-правовых споров, исходя из лучших международных практик и стандартов. Во всем мире административная юстиция – это важнейший атрибут правового государства, сильная опора слышащего государства. Основная его цель и задача – охрана прав, законных интересов и свобод граждан и юридических лиц от незаконных действий государственных органов.
Проект АППК получил одобрение Венецианской комиссии и признан соответствующим всем международным стандартам. В кодексе содержатся правила осуществления административных процедур и судопроизводства в сфере публичных правоотношений.
Административные органы теперь должны руководствоваться новыми принципами в национальном законодательстве. Принцип охраны права на доверие, что означает, административный акт должен быть законным и последовательным. Ошибка, допущенная административным органом, не может ложиться во вред лицу. Принцип приоритета права, принцип соразмерности, принцип запрета злоупотребления формальными требованиями.
Прогрессивными являются и новые принципы административного судопроизводства.
Активная роль суда особенно важна, исходя из неравенства сторон по отношению друг к другу. В этом административная юстиция кардинальным образом отличается от гражданского процесса, который основывается на принципе состязательности сторон. Принцип активной роли суда включает в себя 7 аспектов, которые подробно раскрываются в положениях кодекса. Активное поведение судьи не следует расценивать как предрасположенность к одной из сторон процесса. В административном процессе это, как правило, сторона истца. Помогая истцу как потенциально более слабой стороне, суд прежде всего стремится к достижению объективной истины, чем способствует приближению законности к справедливости. Теперь государственный орган обязан доказать в суде, что его действия были законны и в пределах его компетенции.
Важно, что судья вправе высказать свое предварительное мнение по правовым обоснованиям, относящимся к фактическим и юридическим сторонам административного дела.
Отмечу, что речь идет не о предварительном решении, а лишь о предварительном мнении по отдельным правовым вопросам. Это позволяет сторонам лучше подготовиться, привести дополнительные сведения. В целом это повышает качество судебной дискуссии. От того, как судья разъяснит правовые вопросы, зависит в целом доверие сторон к суду и к его решению. Доверяют, когда понимают и принимают.
Новшества административного процесса учитывают стандарты зарубежных стран, где административная юстиция действует длительное время.
Новшество административного процесса. Истцу достаточно подать иск, который будет автоматически зарегистрирован. АППК устанавливает виды исков, которые в зависимости от предъявляемых требований разделяются на иски об оспаривании, о принуждении, о совершении действий, о признании. От правильности выбора иска зависит эффективность защиты и восстановления прав и свобод. Здесь надо отметить, что суд не будет связан с формулировкой иска. Кодекс предоставляет суду право оказать стороне содействие в формулировании, изменении исковых требований с предварительным разъяснением правовых последствий. Человек имеет возможность с помощью административного судопроизводства проверить любую форму действий уполномоченного органа. АППК содержит положение, предусматривающее примирение сторон в административном судопроизводстве. Сокращено участие прокурора. Гражданин не будет сталкиваться с двойным противостоянием в административном судопроизводстве в споре с государственным органом, на стороне которого, как правило, прокурор.
Вводятся меры процессуального принуждения, замечание, удаление из зала судебного заседания, денежное взыскание. В целом есть 3 основания наложения денежного взыскания: проявление неуважения к суду, злоупотребление процессуальными правами и обязанностями и неисполнение решения суда. Госорган обязан исполнить решение суда. За неисполнение – денежное взыскание в размере 50 МРП. Суд может наложить денежное взыскание на любого чиновника. Тем самым суд сам контролирует и сам обеспечивает исполнение своего решения. Согласно указу президента, будут образованы 21 новый специализированный межрайонный административный суд в 17 административных центрах и дополнительно 4 городах. Административные споры могут быть пересмотрены в областном и Верховном суде. От надлежащего развития админюстиции должны выиграть все – человек, общество, государство.
Ladies and gentlemen, let me to clarify some moments because automatic translation is not accurate. So, so I want to say that some briefly story about this creation of this kinds of litigation. Okay. For almost 30 years since independence, Kazakhstan has retained elements of authoritarian Soviet system, in despite the priority of the interests of states, privilege over the interests of individuals, public organizations, and entrepreneurs. Sometimes people had to go to court, various instances for many years to get right. Wasted time, nerves, legal costs became exorbitant, but this could not continue indefinitely. And people, public, all types of business, and even judges, judicial systems themselves demanded justice and legality. Thanks to perseverance of President of Kazakhstan Tokayev, administrative justice was created. It took several years of hard work, enormous efforts to explain its essence. Dozens of round tables and seminars were organized. There was a fierce debate with legal scholars, heads of ministers and department. It was necessary to break through the wall of misunderstanding, sometimes outright sabotage and attempts to disrupt this progress. And just a few words about the advantage of administrative justice for Kazakhstan. From July 1, 2021, claims of citizens, the public and businesses are considered on principle that the presumption of guilt of administrative body and officials. It's enough for citizens to apply to the courts with a claim of disagreement with any decision of administrative body. For example, remove prohibition signs on the roads and etc. For example, an illegal encumbering acts is always subject to mandatory repeal. When revoking an unlawful favorable act, the principle of protecting the rights to trust shall be taken into account. This principle is a guarantee that once adopted in administrative act is lawful and consistent. Administrative error cannot be resolved to the detriment of a person. It is not his, if it is not a fault. A pre-trial stage has been introduced before the trial. A person first applies to the highest state body. Administrative bodies have the opportunity to correct their mistakes without a trial. But if the plaintiff didn't find understanding there, then he is filing a lawsuit. Judicial bureaucracy is minimal. The claim, regardless of quality and content, becomes a case. So Administrative body starts an administrative case for each application. It's together with the recall of the administrative body is transferred to judge if the person appeals against his action in court. We didn't just introduce administrative justice.
Okay. Yeah. Thank you so much.
Only one before that. I want to see about results, but
we need to start the panel now. Yeah. I'm sorry, we are 10 minutes late. Thank you.
Thank you very much, Justice Shermukhametov. And thank you for sharing that with us about the courts of Kazakhstan. Without further ado, I'd like to introduce our next panel, the panel on Global Panorama of Judicial Environmental Law Education. And chairing this panel, we'll have Justice Adele Kent, Chief Judicial Officer Emerita from the National Judicial Institute of Canada, who's joining us online, and Dr. Gomolemo Moshoyo, the Director of the Judicial Academy of South Africa. And with us here on the stage are several of our speakers. This panel, Justice Nambitha Dambuza of the Supreme Court of South Africa and President of the African Network of Judicial Academies and the Environment. Robert Wabunoha, UNEP Regional Environmental Governance Coordinator in Nairobi. Scott Fulton, President Emeritus of the Environmental Law Institute. Justice Bambang Heri Mulyono of the Supreme Court of Indonesia and head of that country's Judicial Technical Education and Training Center. Brian E. Eels, the team leader of the Environment and Climate Change Judicial Program at the Asian Development Bank, and Dimitri de Boer of Client Earth, who's also joining us virtually as well. Let me turn it over to our panel chairs for what I'm sure will be a very interesting discussion on judicial environmental education. Thank you.
Well, good morning, everybody. Good morning, everybody. I'm sorry I can't be with you in person today in Stockholm. I'm here in Whitehorse, Yukon, where I'd like to say the sun is just coming up, but we're at that time of year when the sun doesn't go down. So it's a beautiful time here, but I know you're having a great conference in Sweden. To be a good judge, to be fair and equitable to the people who come into our courtrooms requires more than a solid understanding of the law. Judges must understand the world around us, be able to weigh and understand complex scientific principles, and appreciate the impact that change and disruption can have on our citizens. There's no subject where that is more relevant than in the environmental law and particularly climate change, how it affects workers, families in crisis, youth, businesses, everybody. We do an exercise at the NJI when we're teaching social context to our judges, asking them to think of an area of the law where the fundamental principle of equality does not apply. And they can't think of one. And I would suggest that the same is the case now and certainly in the future when we think about climate change. It is through effective and rigorous judicial education that we can do our job fairly. Our panel today, Judicial Environmental Law Education, will provide a panorama of what good judicial education is and should be. Each speaker will have 10 minutes to make their presentation, and after those presentations, we'll have an opportunity for questions and answers. The bios for all of our speakers who you've heard identified are in the materials. I would be remiss if I don't shamelessly advertise the conference this coming fall in Ottawa. It is on judicial education, the International Organization of Judicial Trainers, beginning of November in Ottawa. If you go to IOJT 2022, IOJT2022.org, you can get more information. So with that brief introduction, I will now turn the floor over to my good friend and colleague, Dr. Gomolemo Moshoyo, to introduce the panel. Dr. G, over to you.
Thank you very much, my sister, my mentor. Good day to everybody here with us and good day to those that are with us virtually. The panel has been introduced and I would just like to then call upon the first speaker, that is from my beautiful country of South Africa, Justice Dambuza. Thank you.
Thank you, Adele, and thank you, Dr. G, for the introduction. Good afternoon, friends and colleagues. It is my pleasure to be talking to you this afternoon and to be part of these enriching discussions. It is not my intention to repeat what has already been said from yesterday to today about the value of judicial education and the interactions of the kind we have had from yesterday to today, and the sharing of experience of the best practices in the adjudication of environmental law cases and environmental cases, and the foundations and gains derived from the first gathering here in Stockholm in 1972. Instead, I just wish to share with you just shortly about our efforts as judges of the African continent in establishing a forum of judges aimed at enhancing the capacity of African judges in the judging of environmental cases. This started as an initiative of a number of judicial training institutes, the heads thereof, in 2017, under the theme, Integrating Environmental Training in African Judicial Education Institutes. And then it culminated in the organization now known as the African Judicial Network on Environmental Law Education. It's also called AJENEL, which is an acronym, which was launched in Maputo in August 2018. The aim of AJENEL is to provide capacity building and continued support for judges in the region in environmental law. The aim is that AJENEL will do this on its own and also in partnership and collaboration with other institutes. We are already in talks informally and formally with other institutions. I consider the Global Judicial Institute on Environmental Law a friend of AJENEL already. We recognize that our communities suffer most as a result of climate change and the general degradation of environment. The effect on agriculture, the reduction in food security, extreme poverty, depletion of water resources, the effect of rising temperature on our lakes and the effect on fish and other life that inhabits these lakes is devastating. And these effects permeate all aspects of the lives of the people in the communities in which we live. We learn from other borderless crimes that afflict our countries, such as wildlife trafficking and human trafficking, that whilst retaining our individual and territorial judicial independence is crucial, we also need to be systematic in order to be coherent and effective if we are going to serve our communities and play the role that we are supposed to as judges. We need to understand more about the relevant science, the factors that may be relevant and that may be common to our countries. Of course, we do not intend to pretend to be scientists. However, we aim to harness our joint resources in order to be able to determine how best we can be taught so that we become knowledgeable in order to be able to address the aspects that we need to. We need to talk more about the social contexts in which the effects of climate change are experienced in our communities. We need to talk more about the biodiversity loss that we are, or depletion that we are suffering, and how that impacts on our communities and the world at large, because these resources are ours as trustees, in a sense. We need to direct the course of conduct of our cases so that we can address the real issues as comprehensively as we can. For example, where papers are filed before us that do not address, I'm saying this because it did come up yesterday, when we are confronted with papers or pleadings that do not address concerns that we have, or that do not talk to treaties or international agreements that our countries are part of, or relevant constitutional imperatives. We need to be able to invite the parties concerned, their attorneys, to present to us further submissions to address specific issues that they have not. This is a principle that we use readily in civil proceedings, and it is quite in order to do so because it is the duty of legal representative to deconstruct these issues. And where they have not done so, we must invite them. We must call upon them to address the issues specifically. So in order for us to be able to do that, we need to be informed, and we need to be informed continuously. But as judges, we are notorious for our aversion to the idea of being taught. The theory that education detracts from our judicial independence is rife, and Tom Clark referred to it yesterday comprehensively, extensively. I think he said we need to be alive to evolving science. It is this realization that caused us to come together and form the Cagnaro. Progress in getting off the mark has been quite a challenge, but it hasn't been that long. In 2018, when Cagnaro was launched, and the COVID pandemic was also a factor in our inability to move with as much speed as we would have liked, but we remain determined. Our portal is also in place as well, and is not far from being launched. We anticipate that this will be a significant step in reaching out to our partners and them reaching back to us as well. We hope to be able to support each other in order to be effective in our role. We need to be able to share and fashion effective judgments and court orders, as has been referred to here before. We hope to contribute to international jurisprudence even more substantially, and to integrate what we have learned from other jurisdictions into our domestic and regional jurisprudence in a more structured and audible and coherent manner. We have a long way to go, but we are grateful, I must say, for the support and a lot of encouragement that we have already received, especially from UNEP. And I will mention Patricia, I'll mention Robert, I will mention Elizabeth as well, who will be here. And of course, Antonio has been holding our hand as well throughout the process. So colleagues, friends, I introduce you to baby Cagnaro. Thank you for listening to me.
Thank you very much, Justice Dambuza. We will now invite our friend, our colleague from UNEP, Mr. Robert Deobunuha, to take the stage. Thank you.
Thank you, Dr. G, and good afternoon, good evening, good morning, participants. I'll talk on the issue of the trends in greening judicial education in Africa. Because of the position I'm in from UNEP, I am capable of seeing how the African region is transforming itself into a formidable group of judicial education systems, both at regional and national levels. The trend in most of the judiciaries in Africa is showing that the development of modern environmental law is integrating environmental issues within the social, economic, and security and political arena. I will not go into the cases because of the time limitations, but there's a lot of evidence in the judiciaries on those issues. But then, as we see the trends in the modern judiciaries in Africa, we see that because of the relatively new arena of environment law, which is just around 3 decades on the continent, slightly short of the Stockholm 40 years, is that most of the current senior judges and so on didn't do legal training on environmental matters when they were in universities. I will come to that one when I'm making a conclusion on that. And therefore, the need for continuous impacting of skills to interpret environmental law as new judges come in and the rest is a critical issue. The other second point which we are seeing is that the environmental challenges in Africa are very many and wide. They are not necessarily environmental. They touch on poverty, they touch on development, they touch on so many other things. And therefore, to equip the judge in balancing those issues is a very critical, continuous need. As of course, we all know that the environment arena is crowded with treaties, constitutions, regulations, institutions, new institutions, and so on. And therefore, the need for the judge to be equipped with all those new things which are coming on is a challenge. New things keep on coming every minute. Now we're talking about plastic pollution. How are you going to litigate on those new things, polymers and the rest, which the judges would not have known beforehand? And therefore, we see that the 30 years or so of when environmental laws, modern environmental laws founded itself on the African continent. Of course, environmental laws were there since time immemorial, but the modern era ones is 30 years or so. Judicial education in courts of law, and therefore the enforcement, as we have been hearing earlier on, is also moving in tandem with it. We are also seeing that the trend in African courts is that they are pushing the boundaries of judicial interpretation, going into commercial law, which is also an environmental issue, trade and all those other aspects, human rights, both at regional and national courts, other economic issues and so on. They're taking them on very boldly. The cases, of course, are there to see. With what Justice Dambuza has been saying about Cagnaro is once you have a sustainable system of training institutions, you are capable of retaining the necessary capacity within the judicial institutions. Cagnaro is a very good driver for that. And we know very well judges are not like business people who jump from one job to another. They stay in the institutions longer, and therefore we know that they keep there until their retirement age and so on. And therefore training them creates some institutional retention of capacities and so on. But at the same time, we're also seeing trends in judiciaries in Africa, many of them who have not integrated judicial education on environmental matters in their systems. And the solution to that is we need to have non-traditional methods of how we can encourage those other other countries to integrate the education, and I will come to that as I'll be concluding. We are also getting strong messages from judiciaries of the need for homegrown jurisprudence. When we go from country to country doing judicial training and so on, you find the judges get more excited with their own judgments, and they feel more comfortable with them or from their own home countries and so on. The point is, how do we encourage the further development of such and so on? But we are also seeing that it's not only the judiciaries who are learning about these environment laws. The executive is also learning a lot. We have about two or three exciting cases. One of them, which I'll mention, is from the Zambia, who are developing guidelines on the award of environmental damages and compensation, which arise out of the 2018 ICJ judgment of Costa Rica against Nicaragua. I think all of us know that judgment on compensation, where the ICJ set very good standards, global standards on that. And you find a country like Zambia is domesticating it to be used both by the executive in their day-to-day work and enforcement, and also by the judiciary when they are adjudicating. That trend of learning from some of these cases and so on is also coming on. So as I conclude, one of the things which I thought would be very important is that as we mark 50 years of Stockholm, we need to start or to think very strongly on generational change of mentors. We need to start mentoring young judges, young lawyers, and so on, who will become judges tomorrow. I've been struggling with that as I also reach my time for exiting public service in some many years to come, is that we need to take these issues to the younger ones. It's a challenge, and the ideas are very welcome on that. But also, as we do that, we need to continue equipping, developing sustainable methods of equipping judicial education, mentorships, building a core capacity of judges as experts in trainings, exchanges and the rest and so on, case studies and so on are very, very useful. We found the issue of involving presidents of Supreme Courts and Chief Justices as very, very inspiring in driving systems like Cagnaro, and even at national level, driving judicial education. Chief Justices are no longer sitting there rubbing shoulders with the executive and the parliament and looking at budgets and so on, but they also provide a very inspiring method of how we can move these issues ahead. I thought that would have been a good scan through of the trends in judicial education. But as I had said, a lot of work needs to be done, a lot of mentoring. We should look for generational changes, younger judges, younger lawyers, and so on. They are very, very critical. Some of us who came into the field with other peers looking at them and they were encouraging us to do whatever we could do. I thought we can also find methods of bringing the younger generations into play. I thank you, Dr. G. I stop here.
Thank you very much, Robert. You raised very pertinent issues. Indeed, the field of environmental law is very wide and it's a headache for us who are heads of Judicial Training Institute as to what do we cover, what do we exclude. I'm hoping that Mr. Scott will come and tell us, as the former head of the Environmental Law Institute, give us some tips as to how we can do it. Over to you.
Thank you, Madam Chair, for that challenge. Good greetings, ladies and gentlemen, distinguished judges and educators. How wonderful it is to be together again with cherished colleagues and friends, both new and long-standing. As always is the case, these conversations energize and stimulate, and just want to thank you for who you are and what you are doing. As we've discussed, we can find the roots of our conversation here in the awakening that was the Stockholm Declaration 50 years ago. We should not be at all surprised that the courts would prove to be an inevitable destination in the ensuing progression from that awakening, given their role as guardians of environmental rule of law. Awareness of the key role of judges in the environmental challenge led my institute, the Environmental Law Institute, to start its judicial education program around 30 years ago, well before my time leading the institute. It was a program that would come to touch thousands of judges and scores of countries around the world through in-country and regional training events. The same awareness that tracks back to Stockholm would also inspire UNEP in the late 1990s, as has been mentioned, to establish its global judges program, which produced regional judicial symposia in every region, as well as the landmark convening that Donald Cagnaro mentioned this morning, the 2002 Global Judges Symposium on Sustainable Development and the Role of Law in Johannesburg, South Africa, a remarkable event that brought together more than 120 chief justices and senior judges from over 60 countries focused on the environment question and the role of the courts. I was a judge myself at that time and was one of the 2 judicial delegates from the United States that was at that gathering. I think all of the judges assembled there were taken by UNEP's theory of change, which is the idea that when other elements of government are failing in protecting a country's natural heritage, the courts, judges can help fill the gap. The idea that judges, when equipped with an understanding of the importance and nature of the environmental challenges at issue and charged as they are to deliver justice, can be an important engine for needed change. This idea was powerful. It was contagious, so much so that I and a good many of others have stayed connected to this dimension of the environmental solution in the years since. And judicial cohesion would ultimately, through the hard work and leadership of Antonio Benjamin and many others, lead to the birthing of the Global Judicial Institute on the Environment, which has become a shining light for the important work of the courts in producing the future that we want. So what a wonderful history. The question is, where do we go from here, and how does education factor into that? I wanted to share with you a development that may be part of the path forward. The development I'll describe emerges in the troubled country that came up in our conversations several times yesterday, that being the United States of America. This is a country that has reversed course, not just changed course, but reversed course effectively 4 times in a little over 20 years on climate change. Where climate change remains a highly politicized issue, where climate change is still debated, a debate that's fed and confused by disturbingly effective disinformation campaigns, a place where our Supreme Court appears to be about the task of reducing the role of the national government overall, a place where judicial activism is a grenade that's lobbed back and forth across the political divide, a place that I believe was missing in action even on this recent Human Rights Council resolution that we celebrated yesterday, recognizing the right to a clean environment as a human right, because that resolution fell in the gap between Trump's withdrawal from the Human Rights Council and Biden's rejoining the Human Rights Council. For those of us who were part of the Obama leadership team and thought we had finally turned a corner on climate change, the progression has been difficult to watch. Early in the Trump presidency, I began thinking about how an NGO like the Environmental Law Institute, which is really a think tank and a capacity building enterprise that does not sue people or engage in lobbying or political action, could still be a positive contributor during such a difficult time. This led me to a conversation with a leading climate scientist, Paul Hanley, the former head of Climate Central, and an idea emerged. What if we built on ELI's history of training judges to frame up a new initiative focused on educating judges on basic climate science? This idea really harkens back to the original UNEP concept. If judges understand fully the nature of the phenomenon that we are facing, then their judgments will likely be more responsive. Or in Justice Mansour Ali Shah's words yesterday, if they come to see that the building is on fire, they'll be more likely to reach for a hose. And so we created the Climate Judiciary Project, as we're calling it. Our focus thus far has been on the domestic front in the United States, working with the 2 most trusted judicial training centers in the US, the Federal Judicial Center and the National Judicial College, to hold judicial seminars around the United States designed to deliver case-relevant consensus science to judges who are likely to hear cases with climate implications. To do so, we rely on consensus reports like the IPCC reports and the United States National Climate Assessment, as well as presentations by leading climate scientists. Inger Anderson mentioned yesterday that the science and law communities do not speak enough. This project strives to bridge that divide. In the past year, we did 10 of these kinds of deliveries, and this program has thus far reached in the range of 500 US judges and is picking up momentum. While we're doing these seminars, we're also working to complete a standardized climate science curriculum. And we have leading experts in the subject drafting the modules that would be part of that curriculum. The course is intended to provide coverage from basic climate science to climate impacts to climate solutions and how these all relate to the different kinds of cases finding their way into court. And our goal is to have this standardized judicial climate science curriculum for US judges finished by the end of this year. I'll mention that relatedly, we were asked by the National Judicial College, which is the place that provides training principally to US state court judges, to develop a deep dive program for a select group of judges under the rubric of a construct called Judicial Leaders in Climate Science. And here the idea is to expand the reach of judicial climate science education through judges who have established proficiency in the subject matter and can be looked to as leaders and knowledge transferers within the judicial community. To this end, 23 judges nominated by their chief judges in their state are engaged with us over the course of a year in a program focused on leadership and climate science. Judges are inspired, challenged, and led by the thinking of their colleagues, just as I'm sure many of the judges assembled here have been moved by the sharing of your colleagues. What's next? We think we have, once we have this core curriculum developed, it's time to think about internationalizing this concept. Science is, of course, the ultimate lingua franca, an international language that is inherently transcendent and transboundary. So our thought is that the science piece of what we're constructing should serve as an excellent starting point for a judicial climate science module that is transferable and adaptable to other countries, so that judges all around the world might have the same access to understanding climate science and be in the same position to judge in a manner consistent with that understanding. So we're looking for partners, collaborators, and delivery prospects for this next phase of the project. Please let me know if this would be of interest to you. Judges are clearly, as we've discussed, an important part of our solution. Let's give them what they need to be fully effective in this space. And with that, I thank you for your attention.
Thank you very much, Mr. Fullerton. We now change gears. We're going to hear from the Asian perspective as to what is it that they're doing as far as judicial education is concerned. I will now call Ms. Justice Muliono, I hope I pronounced it correctly, who's the head of the Judicial Technical Education and Training Center. Over to you, Justice.
Thank you, Chairman. Good afternoon, justices and participants in this symposium. First, I want to say thank you to the ADB, where gave me opportunity to attend in this wonderful symposium. So, could you please my presentation? Okay, good. Before I present about judicial training in the term of environmental judges training. Before the environmental judges training, actually, we have many of training where joined together with between the Supreme Court and government of Australia. There are environmental law enforcement training in several provinces, and some of them sent by the Supreme Court to the Australia to learn about environmental law and enforcement in New South Wales and Land and Environment Court in Sydney, and the Environmental Court in Adelaide. So this training is start in 1999 until 2008, and I am as alumni of the training, and then the next training as a mentor of the training, and the lecturer is also Justice Brian Preston, and expertise from Sydney University and Adelaide University. So this training is until 2008, and then finished the project. And during 2009 until 2010, we preparing how to make a special court related to the authority of the Indonesian judiciary to examine and in the environmental cases. And the conclusion of this, we make a working group, and then we analyze what is the best choice to handle of environmental cases in Indonesia. So the best choice is a certification for environmental judges. So in 2011, the Supreme Court launching of Chief Justice regulation about certification of environmental judges. This start as certification judges in Indonesia. Then we are have experience in the training, so we make planning for the training. All of training are based on TNA, training need analysis. So before we make a training, we must preparing of, we make a 3-step of the training, before training, during the training, and after training. So before the training, we must preparing a module, choosing of good quality of lecturer, and also preparing selection of participant. Standard of the training in the Judicial Training Center is we use of taxonomy Bloom as standard of quality of the training, and for the evaluation we use a theory, and standard for evaluation is a Kirkpatrick 4 level of evaluation. And what is the need to environmental judges in Indonesia? So we have minimum three for the we give to the participant in the training. There are determinant of environmental justice, prevent of environmental damage, and environmental restoration. So that means restorative environmental justice is not only compensation or in civil cases, environmental criminal fine in criminal cases, but more important is restoration that the environment back as function as a good ecosystem. And back to the preparing of, next slide, please. Back to the preparing of the training, where there are 3 parts of the training. We also selection of the judges as a participant of the training must be careful, because we know that they have special authority to examine environmental cases. So the criteria, one criteria is the judges must have 10 years experience as judges. So that means that all of their knowledge about law, about general procedure, and examine the cases, they was experience in 10 years. What is to need to improve for the judges? Environmental science is not only knowledge about law, but also knowledge about practice of biology, practice of chemistry, environmental good governance, scientific evidence, etc. Environmental ethics is important as basic knowledge and understanding that environmental ethics is or mirror that every environmental judge is good environmental behavior related to code of ethics of the judges and Bangalore principle for judges. And Environmental Protection Management Act is not only the law as a legal basic, but all of judges must aware and well understanding. There are Forestry Act, mining, maritime, natural resources and conservation, energy and industry. Judges also must well understanding about procedural law in environmental civil procedure and criminal procedure, including anti-slap procedure. And integrity is about moral integrity and performance integrity. Therefore, every training of environmental judges, the Judicial Training Center always implement additional training to improve their integrity by character building session, which involve the Supreme Court ethical control. Ethical control body is under the Supreme Court Chief Justice. Judicial Commission, professional motivator, and psychologists. And sometimes we use outbound and role play as to improving of character. According to the message of the Chief Justice of Indonesian Supreme Court, integrity is a fixed price that cannot be interrupted. Integrity is like candle. It's like illuminate the judge's perspective. But when judge spill a candle of integrity, the fire will burn the house of justice. So as head of Judicial Training Center, I agree with Justice Speaker yesterday that judicial education is important for judicial integrity. Therefore, quality of training for judges must be improved every year to year, and implement of any innovation using technology. About integrity, if there are judges who violate of ethics, so the Chief Justice will revoke of the certificate. And this is also implement of deterrent effect for another judges. And this is a part of control and motivation for judges that the Supreme Court cannot bargaining to integrity. The fire, and about, next please. About how to improving knowledge for the participant of the environmental judges. So there are indicator. Three of indicator is about how to improving their knowledge. They must successful participant in the certification training is achieve competence of valuation in terms of environmental losses on or environmental damage in forests and land fires cases, mining cases, pollution cases, etc. In scope of environmental cases concerning to the Supreme Court regulation number 134. And improving skill and competence, and the red color is improving skill for judges to make good quality of court decision, which enrich with legal consideration in accordance with the principle of environmental law. So in this term, they need capacity to analysis and create a good quality of court decision in their legal reasoning. And next slide, please. This is about training flow for environmental judges certification. As I mentioned before, that there are three parts of training: before training, during training, and after training. So this is during the training. Before training, we announce including criteria and open recruitment for the judges at the application in the e-learning system of the Judicial Training Center. And also we use social media, YouTube, Instagram, Facebook, and Twitter. And then preparing curriculum, module, and choose quality of trainers that we need. And then meeting all of trainers in the trainers convention, with usually among trainers making a strategy and focus on the target of the training. All of module upload at the website of Judicial Training Center. Every participant have obligation to learn by self-study at the learning system. There are also tests in every material, every module, and this test is a part of assessment component. Second step in the training is online class, or perhaps sometimes we classical class, where the participant meet with the lecturer and facilitator in online class, or more understanding the material and module, and also discussion. And the third step in the training is a classical class, where the aim of this step is improving skill and competency of the participant. There are role play, case study, and good or with a good and bad court decision as a material for case study, and making legal argument. Additional session in the training is outbound training, observation, and on the real side of waste management, for example, and at the location of forest fire, or location of mining. And then we make a inspiration class with expertise justices around the world, or warrior of environment enforcement. This is depend on the focusing issue on the training. And after training, there are monitoring and evaluation by online survey and on-site, where there are interesting court decision on potential environmental case will arise by your region. And advanced training. This is important also to still manage that just environment that have spirit. It's also important for environment judges to keep high spirit of them and continuing judicial education and training. There are also training about environmental enforcement, with focusing topic about climate change issues for ASEAN judges. Last year we have two time for training for ASEAN judges. We joined together with the Norwegian embassy through the civil society in Indonesia. Next slide, please. Yes, this is, I think, only a picture. The picture is about a training where not only in the classroom, but we also observation at the location on forest fire, or perhaps on the waste management system. And next, please. And this picture is we take on Monday in this week, where Professor Christina Voigt, as a lecturer for the inspiration class for the certification environmental judges. Next, please. And this is also when we make advanced training, when Judge Anders Bengtsson and Justice Mary Beth, I think, from Sweden and from US, as a lecturer and at the advanced training in Pekanbaru, close to the forest fire area. And sometimes and several training, we also invite Justice Brian Preston, Judge Suntarya Manpawong, Antonio Oposa, and justices from Indonesia as a lecturer to give inspiration, additional session for the judges training. The last slide. So right now we have
there's 1,341 judges, alumni of the environmental training, but minus some of judges passed away during pandemic and also retired. But as the head of the judicial training, I still have optimistic and in my mind and vision. I remember that yesterday, as human, judge perhaps part of the environmental problem, but I believe that the best environmental judges is always part of solution. So thank you.
Thank you very much, Justice Muir. I know that when you are head of judicial education training and are given time to speak, it's 10 minutes, you're going to use 20 minutes because you want to tell everybody about good things that we are doing. Indeed, we are doing a lot of good things. Thank you very much. We are now going to invite one of the most important, because the organization that she's working for is one of the sponsors of this beautiful event. As Ms. Brioni Ilse, a lawyer and a team leader at Asian Development Bank. The name of the program is so long, but I'll try. Environmental and Climate Change Law Judicial Capacity Building Program. You are very important, my sister. Take over. Thank you.
Yeah. Hello, can everyone hear me? I get conscious when I'm so far from the microphone. So we get the afternoon shift. Everybody's looking like this. Everybody's jet lagged. So I'll do my best to warm you all up for Dimitri, who is coming next. So Honorable Chief Justices, judges from around the world, distinguished speakers, my fellow panelists, respected guests, friends, but most importantly, stewards of Earth. Yesterday, my colleague Cecile described suffering from imposter syndrome, where here I go, a non-judge, trying to talk to judges about judicial education. So, but knowing that I'm not a judge, I make these comments with the greatest of humility. And I encourage the judges of this room to follow the advice of Walt Whitman, and that is to be curious, not judgmental. We know that curiosity is the best inoculation against bias. And as we learned yesterday, judges have feelings. So I encourage your feeling right now to be that of curiosity. So let me start with some thoughts from the Australian luminary, Hal Wooten, QC. He was the founding dean of University of New South Wales Law and Justice faculty. In 2007, he gave a speech about living large in the law. And he said, when the tumult and the shouting dies, and the captains and the kings depart, there stands still the ancient sacrament of the law, the right of everybody to a fair hearing and a reasoned decision according to the facts and the law, by an honest and unintimidated judge. In the end, this is often all the law can offer a person, whether individual or a corporation, rich or poor, strong or weak, but it is a precious thing. Striving to make it a reality and to make the law applied in it more just and rational are at the heart of what it means to be a lawyer. So I agree, justice, fairness, honesty, and a rigorous assessment of the facts are at the heart of what we strive to do in judicial education. But what we've heard yesterday is, and I can't help wonder that in the 15 years since he gave that speech, that there's something else that the law needs to be offering in 2022. So perhaps it was implicit in his words that a fair hearing and a reasoned decision according to the facts and the law would result in justice. But as we heard from Justice Benjamin yesterday, judges have feelings. And when judges apply outdated reasoning, environmental justice may not be served.
So further, ADB as a team emphasizes consistently that in 2022, we need 21st century solutions to our 21st century challenges. And climate, biodiversity, and pollution litigation are hyper complex challenges because litigation now involves multiple stakeholders, people from around the world, future generations, and it involves the environment and other species. So if we're going to think deeply about judicial education, we need to start asking, what role might judges play in environmental, climate, and earth justice in the coming 10, 20, 50 years, and so forth? And what are the challenges and the skill sets they will need that we need to educate them for? So we need to start thinking forward for that. And who do judges need to be? Well, as Albert Einstein said, if you try to we cannot solve our problems with the same thinking we used when we created them. Significant judicial advancements have often rested on the shoulders of jurists who were willing to apply new consciousness and imagination to existing principles to resolve society's pressing problems. And we need new perspectives to create climate and earth justice. But justice will only be fair when it takes into account these diverse perspectives, principles, and the rights of women, children, elders, Indigenous peoples, the differently abled future generations, and balances them with the traditional power structures. So I think these are the qualities that we're looking for in judges. This is the behavior change that our judicial education needs to start thinking about. Because poor understanding, imagination, compassion, skill, and resources, combined with entrenched economic and governance systems, and along with vested interests and a need for unprecedented rates of change, are really what scare people or deter people from taking action. So what is ADB doing? Because that's what we're here to talk about. You've all heard about ADB's program. We've, for more than 10 years, have supported judiciaries across Asia and the Pacific. We have also created AJNE, the Asian Judges Network on Environment. So we didn't need an AJNE, symposium. And over that time, we have supported judiciaries with establishing green benches. We've helped to create special rules of procedure, and we do this. We help bring judges together for capacity building and these symposiums. And this is where magic happens. This is where you sit down with your colleagues from around the world and you share ideas and you go home and you feel inspiration. But there's more that we need to do than just these regional conferences. They're expensive, and it's a small group of people in this room. And as Thomas Clark said yesterday, if we're going to bring all arms of government along for whole of government change, then we need everyone to be well functioning, and we need all judges in all countries to be well trained. And so what the COVID-19 pandemic taught us is that online ways of educating people work. They may not be as interesting as something like this, but that's the future. The future is hybrid. What we're doing today is the future of judicial education. And our current program will continue to have judicial education. It will continue to support conferences. And we have recently published Climate Change, coming soon to a court near you, which covers climate science. But in addition to that, we are now trying to work systemically with judiciaries in Asia and the Pacific. So helping judicial training bodies with their judicial education on climate change, environment, biodiversity, so that they can embed it into their program and it's more sustainable and we can work with them more long term. We're also working with the ASEAN Council of Chief Justices. they have an ASEAN-wide program to embed education on what we do in that program. One of the latest innovations that I wanted to talk about is something called a Judicial Masterclass program. And this is something that we are working with UNEP and the USAID Reducing Demand for Wildlife on. And the idea was simple. In 2018, we went to Lahore and we sat with judges, and I sat at a table with Justice Brian Preston and Justice Mansour Ali Shah with junior judges. And the junior judges got to ask all of those questions of the experts, like, how did you do this? How did you manage this remedy? And we thought to ourselves, what if we could interview the judges and create this knowledge product where we got to ask those what if questions? And we can use that product in judicial education curriculums or in online workshops where we can take those different videos and then workshop them. And it means that Justice Preston doesn't have to always be there. It can be other people who are participating, but we get the benefit of his wisdom. And so that's one thing that we will be doing. And then another thing is remedies and enforcement. We consistently hear that judges want assistance with remedies and enforcement. Indeed, an essential component of the climate change report series was intended to be another volume on remedies, but we just couldn't do it. So now we're trying to work on that. But looking forward, I think the question is, how do we continue to live greatly in the law, and how do we continue to educate greatly in a hybrid world and make it interesting? And so I guess one of the most important things for me to do is to continue, and our team is to continue to listen to judges about what is needed, because I hear all the time fantastic ideas. So I really hope that we can now engage in discussion in the remaining time we have. So thank you very much for your time.
Thank you very much. Clearly, environmental issues are global issues. They require global response, global efforts, and lastly, coordinated global support. Because it really doesn't help that different organizations are trying to deal with this similar issue, but the response is not coordinated. We are now going to hear from Dimitri, of the Client Earth Chief Representative for China. They support and strengthen environmental governance and rule of law. Over to you, Dimitri.
Thank you, Chair. And I so wish that I could be in the room with you in Stockholm. There are so many friends, and this is an absolutely excellent symposium. I've listened to all of the discussions with such great interest and learned so much. And I'd like to tell you about our experience in China, which is no doubt one of the most remarkable examples of environmental judges education in the world. I'm going to share a few slides. I hope they come up. So they should be visible now. We started working with the Supreme People's Court of China in 2016, and there's actually a very strong political commitment in China for the environment since around 2013. And the Chief Justice of China, President Zhou Qiang, also has a very deep understanding of environmental matters and is quite committed to this space. And China's environmental law came into effect in 2015, a new environmental protection law, and it allowed for public interest litigation. And so hundreds of environmental courts were established around the country, and specialized environmental judges were appointed. And the decision was made to train all of them on environmental matters. And so Client Earth was invited to cooperate with the Supreme People's Court on this amazing effort. And so here you see the first group training that we held in 2016 on climate adjudication. The gentleman on the right is China's most senior climate change official, Mr. Xie Zhenhua, and he spoke to all of these judges about the utmost importance for them to understand climate change and to try to understand the implications of their rulings on the climate. So since then, we've held group trainings, high-level seminars, overseas visits for judges. We've had many environmental judges come to China. We did overseas secondments of Chinese judges to other courts. We did online video lectures, webinars, case collections, and joint studies on key issues. And so far, we've trained at least 2,000 environmental judges in China, and some of them, in very in-depth ways. And I also want to give Bryony some good news. I think the symposium we're having now will not stay in the room. We hope to use the recordings of this online seminar to make subtitles and share those with the online training platform for all judges in China. That's hundreds of thousands of judges, but of course, especially the environmental judges will be very keen to get all the wisdom that you have been sharing over the last couple of days. This is an overseas visit to the United States and another top-level seminar with the Supreme People's Court. So China's system of environmental public interest litigation has two main plaintiffs. One would be a qualified NGO. They can bring cases against polluters, mainly companies, to repair environmental harm. But very interestingly, prosecutors in China can also bring environmental public interest cases, and they can litigate against both companies and also government agencies. And in China, that is quite remarkable. So we decided to also cooperate with the prosecutors in China, and we started a very large environmental law training program with the prosecutors as well. And they have become an extremely powerful force now in China for the environment. And this photo is a beautiful photo where you see many of the leaders who are in the room today, who were then in 2018 with us in China. So the progress is quite impressive. In just a few years, we have seen almost no public interest cases for the environment, going up to about 80,000 cases brought by the prosecutors in 2020 alone. And the majority of those cases were against government. NGOs have been able to litigate as well, but one of the main challenges for the NGOs has been a lack of funding. And so we, Client Earth, actually established together with the Chinese Foundation a special fund to provide Chinese environmental NGOs with money. And that fund is now, I'm proud to say, the largest of its kind in China. So I want to share a few interesting cases with you. One is very little known. It's a recent ruling about a Bitcoin dispute. There was an investor and another company that was sort of doing the Bitcoin mining. They had all these computers consuming incredible amounts of electricity to produce Bitcoins. But there was a dispute because the operator refused to pay the resulting Bitcoins to the investor and owed about $18 million worth of Bitcoins to the investor. So the investor sued. But the judge ruled that that contract, the entire contract, was void because Bitcoin trading has been banned in China recently, and partly over its energy consumption. And so the court, in its ruling, the judge proactively raised the point that this Bitcoin mining was actually very bad for the world's climate. So it's one of the first cases in China where a judge took the initiative to raise climate change as an issue in the case. Another example of an interesting case I want to share with you is a case brought by prosecutors in China of illegal dumping of construction waste into the ocean. There was a resident who called a hotline, a government hotline, and complained that there was this ship dumping construction waste into the ocean. And the government failed to respond to that complaint. And the resident kept complaining and complained 11 times through that hotline. The prosecutors were able to listen in on these complaints and were wondering why the government agency took no action. So they went with drones to the site and discovered the ship red-handed dumping this construction waste into the ocean, and brought a case, several cases. One was a criminal case against the operator of the boat. The second was a civil public interest environmental case for damaging the ecosystem, which resulted in a very significant financial sum. And the third, I believe there's also an investigation ongoing as to the lack of action by the administrative agency and possible collusion with the perpetrators. So what we found in judicial education is that it's very difficult actually to communicate between different judicial systems and between different languages. But the one thing that's really easy to communicate is cases. And so we prepared what we call 10 landmark cases for biodiversity from around the world, together with some of the experts in the room. And this is a beautiful little booklet, which anybody can download online. And as you can see, the cases really are spread all over the world, developed and developing countries alike. And one of the most interesting cases in this booklet is from China. And we call it the Green Peacock case. It's the first time that a major what we call preventive case was successful in China. An NGO sued the approval of a hydroelectric dam in a part of China, which was said to destroy the habitat of this beautiful bird. And the court ruled in their favor and therefore halted the construction before it was actually destroyed this habitat. So we are hopeful that in China, more of these preventive cases will be featured both by prosecutors and by NGOs in the future. So one other point I want to make is the conference spoke quite a bit about technology. And this is quite interesting. What we're seeing in China now is that the prosecutors are increasingly making use of remote sensing technologies, such as satellite images and drone surveillance to build their cases. And I think this is a point that is really worth emphasizing because it's so powerful. These remote sensing technologies can cut straight through local interests, intentional, let's say, manipulation of data or omissions of important facts. And so for prosecutors and also NGO litigators alike, to use these technologies is extremely important. In some cases in China, the court also has the power to do some investigation of the facts. And so the courts in China may also increase their use of technological solutions. So the challenges, there still are quite a few challenges in China. In the cases where a government priority is being challenged, whether it's by an NGO or prosecutor, tend to be very complex because the role of government is so strong in the Chinese system. And so these are complicated, but I think this is where the rubber meets the road in China, and where you're seeing that there is actually a clear trend towards increased judicial independence. The judges, the courts are being increasingly delinked from the government system in order to increase their independence. And that's manifested in several ways. And there's also for example, environmental courts are cross-jurisdictional, so they won't be linked to specific, that they'll be merging several jurisdictions together, and that effectively decouples them from local interests. So I just mentioned that preventive litigation is very hard to bring in the Chinese system. That is being improved. There are various new measures that have just been released, but we still see quite few such preventive cases. It's also very difficult for the prosecutors to bring such cases. The whole system in China for public interest litigation is built around tort. And so that tends to rest on the harm already having been done. Also, there's a lack of capable environmental NGOs, as I mentioned, and there are few climate cases to date. But you may notice that President Liu Zhu-mei, in her speech yesterday, mentioned climate adjudication a number of times. And that tells you that there is actually a great interest among the court and also the prosecutors to really ramp up their work in this field. So I want to conclude with a few remarks. First of all, Client Earth used to operate on a shoestring budget in China, but I'm very happy to say that many major foundations are increasingly recognizing the importance of this work. And so we are now able to grow our teams and our programs in Asia, especially. And so to Justice Bambang, who spoke just now, perhaps we have room to cooperate in the region. We are very keen to organize more judge exchanges in the Asia region, also around the world. We're also happy to share your good materials in China. So Scott Fulton, we would love to work with your curriculum, for example, on climate science. We also hope that you will continue to invite Chinese judges. We can help to facilitate. It can be a bit daunting because of the language barriers and the, let's say, formalities, but we can help with that. We hope that we can travel again soon. And the bottom line is we want to expand our work to support these extremely valuable exchanges like the one today and yesterday for judges on the environment. So please contact me if you have good ideas. And I'll close off by saying thank you for all of the amazing work you are doing. And one final pitch: on July 6th, Client Earth, ADB, and the Supreme People's Court will co-host a hybrid workshop on climate adjudication. And all of you are welcome to listen in. So contact me if you want to participate. Thank you.
Thank you very much. I know it's in the afternoon and we're kind of tired. Can you just give them, all of them, a good round of applause? Thank you. Thank you. Before I could invite questions or comments, I would like to check with my dear sister in Canada. Is there any comment that you would like to make before I can invite the participants here?
Well, thank you, Dr. G. I have nothing to say other than I have been furiously been making notes about all of the wonderful ideas and projects and the ability to work with judiciaries around the world. And I know our Mr. De Beer, your 10 biodiversity cases, that booklet I'm going to take back to our digital project manager at the NJI, because it sounds like a wonderful tool. So, so thank you to everyone. Very interesting. Dr. G?
Thank you very much. I would like to invite questions or comments, Justice. Then you'll be the second one. Thank you.
Thank you, Dr. G. I've discovered that name. That's very interesting. Thank you. It was wonderful presentations. I had a chance of supervising and managing the Punjab Judicial Academy for a while. So I have a question from the panel as well as from people online. We're talking about judicial training of the subordinate judiciary here. And we've noticed that they come to the academy, they get trained, but and we think that they've learned and things have improved. But is there a software or a program where you gauge that what do they do in the field when they go out? Do they really make a difference? Do they really change things? Is there a system that you have, or can you share any data with me that if you've trained 100, what has been the change in the field? I mean, there will be better decisions, better executions. Is there such a software, or are you just imagining that they're doing good when they go back? So that's one question. Is there a correlation? Is there data? Is there software? Or is there any application that gauges the actual change that brought in the field? I mean, not in the classroom. One. Number two, whether at all there's a program now for constitutional judges, because nobody really takes us to any academy. So is there any initiative anywhere where constitutional judges are also being trained? I mean, I'm talking High Court and Supreme Court, and why not? I mean, thirdly, what's the complexion of the faculty? Are the judges teaching judges, or are there academics teaching judges, or are there private sector experts teaching? So what's the complexion like? What percentage of the faculty's judges teaching judges, because you're going in circles then in that sense. And fourthly, is there any scorecard at the end of the day when the judge finishes the training? I mean, and does that scorecard goes into the service record of that judge? Is that scorecard looked at when you're promoting that judge? Is there anything at the end, or is he comes to the academy, enjoys 4 days and goes home? Or is there a scorecard at the end of the day which goes into his service record and which actually helps us gauge that he should be promoted or elevated to a higher bench? So much. That's it, Bert.
Thank you, Justice. I think we could also take that second question and then the panel will be ready.
Hello, can you hear me? Hello, it's okay. Yeah, my name is Katak Malla, and I have been an educator for almost 2-3 decades, and recently retired from Stockholm University. Still have some courses, but I do not have a question, but if I am allowed, I will make a small comment, not more than 2-3 minutes. You know, one of the things that I teach to my student, environmental law teaching, most of the time it's a question of how a student as an individual, how as a lawyer, as an individual, as a group of lawyer, or even a judges, how do you see the world as ontologically and epistemologically? That's one of the most important things. But what prompted me to speak something little here is last session I heard reciting of so beautiful poetries. Even now, one of the quotation there. And what I teach to my student is the modern methodological aspects like literature and law, and legal of the socio-legal. And this fits very well with the environmental law teaching. I'll not take more minutes, just to be very specific. Literature is one of the living evidence that law is not always neutral. Law is not always legitimate. Law is not always just. I'm not saying that law is not just, law is not legitimate. And law, I mean, law is just most of the time, law is neutral. But there are situations where law is not neutral, law is not legitimate, law is not just also. So this is the challenge as a lawyer, as a judge, as a teacher also. So what I do is that there are situations, whether in environmental law or any other law, there are certain situations where the traditional way of interpreting law, the black letter interpretation, the literal interpretation, mischief interpretation, e contrario interpretation, there are many types which all are acquainted with, I think. But what is more inspiring is the recent years is the critical legal interpretation. And under this critical legal interpretation, which is also a part of black letter interpretation, de lege lata and de lege ferenda. But that part is very important, that there are situations where there is power asymmetry. In most of the environmental law cases, there are power asymmetry between the clients. Mostly it is the state, it is the executive. Or even there are situations where there is a issue of patriarchy and institutional racism. So these are the situations where as judge or as a lawyer or as a teacher, how do you teach this kind of thing? So I think my final point is that the Stockholm Declaration was one of the defining movement of international environmental law. And now at this moment of time, no law is beyond environment. All laws that we say separation or fragmentation, whatever it is within the framework of environmental law. So my point is that maybe we could have a kind of common ground to argue law in situations where there is a power asymmetry, where there is institutional racism, and where there is even patriarchy. There we lawyer and judges have to be more critical, I think. So that is the only comment I have had. And thank you very much. And thank you for so much of inspiring lectures and beautiful poetry quotation cited that prompted, that inspired me to speak something. And literature and law and legal of the socio-legal are very important modern ways of interpreting law. Thank you so much.
Thank you. Thank you very much. Thank you. I hope that the panel got those questions. It's around how do we gauge the progress after training? And are the High Court or Constitutional Court judges trained, which is a question that always comes there. We get it. Who's teaching? The complexion, the percentage, any scorecard at the end of the training. Over to you, Pariel. Any take-up?
I'd be happy to give it a shot for our work. So because it's mainly environmental judges that participate, we know that these judges go back and actually practice a lot of the things that they learn in our trainings. So that gives us an extra incentive to go the extra mile. And we notice that the judges have a very, very active participation in all of these exchanges. They're sitting up straight, taking notes. When we go to the other countries, they're not jet lagged. They will always be extremely interested in what they're being presented. We definitely do also involve Supreme Court judges and High Court judges and leaders. That was the premise from the very beginning. The Supreme Court judges want to be the most well-informed and the most well-educated in China. It's mainly judges teaching judges, but also academics. In our case, sometimes scientists or even NGO leaders will come and speak. Many of the judges that have participated have been promoted one way or another. But I think ultimately the question of how to measure it, it's still quite difficult. I can't say with confidence that we measure it very well. I was quite interested actually to look at the Indonesian experience with trying to be structured in that way.
Yeah, I'll just add to Dimitri's comment that I think our experience has thus far been similar. I don't think we have a completely satisfactory response on measuring how this kind of training influences jurisprudence. And as you all have probably experienced in systems that attempt to evaluate your work, it's very difficult without really digging into each individual case to see whether the right outcome has been arrived at and to figure out whether there was an influence from this kind of experience shown there. So that's a tough spot. I think we still have a ways to go in figuring that out. On the other questions you were mentioning, Mansour, I think at this point, we're relying primarily on academics and senior scientists for faculty. There is a thought, though, that as this moves along, and particularly this climate leadership piece, as that evolves, that involving judges in the delivery is a good thing. It's a helpful thing. I think there's nothing more influential than that, frankly. So I think we do have this thought that that's where this needs to move. We're probably a little ways away from a system that takes into account that a judge has signed up and taken this kind of training for purposes of promotion and that sort of thing. Once we have this core curriculum established, if that core curriculum is taken up by the National Judicial College or the Federal Judicial Center, then I think you've got the beginnings of a construct that might allow for consideration of that kind of credential for purposes of advancement, but we're not there yet.
If I may add, judicial training on environmental law is fairly new in South Africa. And the Constitutional Court judges have not participated as yet at all. Even the High Court judges are just starting out, but that's all a function of how long we have been doing it. But another factor to it is that the cases that have served before our courts up to now are those that implicate principles of administrative law reviews, mainly because of lack of capacity with public officials that look at, for example, environmental impact assessments in adjudicating permits. So you find that we are at the stage where we're still considering the extent to which they have even really interrogated the contents of the environmental impact assessments. And in most cases, they haven't. If you look at our jurisdiction, mostly decisions of public officials have been set aside purely because they have not even begun. I think a lot of them just look at the reports and they are overwhelmed, and then they decide to say, okay, you've got your permit. And invariably, the reports are reviewed and they are mostly set aside. So we haven't had opportunity of considering hardcore purely environmental assessment consideration aspects. But we draw a lot from our previous purely constitutional rights jurisprudence that we've had from the 90s to the 2000s, the right to life and all of that, because they implicate the same procedures and the constitutional principles. We do take, in relation now to the assessment of the trainers or facilitators, we do have a scorecard at the end of every training, but it is purely for purposes of assessing the impact that it has nothing to do with promotion, because judges are not promoted in our country. They are, you go to interview and if you want to go to a higher court, it's a totally different assessment procedure. What was the other one? Maybe I don't want to say everything all at once.
May I give additional? In environmental training for Indonesian judges, we need senior judges to teach the junior judges when we are learn in a case study. And we still hear of the academies to how to properly implement of the principle, for example. And usually we are combined in the case study. There are two lecturers, experienced judges and academies or expertise. Thank you.
Thank you, sir. Thank you, Justice Shah, for so many great questions. So in terms of how we track the outcomes, I am with my colleagues, it's very difficult. However, we have always seen anecdotal evidence of the exchange of ideas from the conferences that ADB does. And often you are an example, like in the Lagari decision, when you called it a writ of kalikasan, or when the Philippines created a writ of continuing mandamus in its rules of environmental procedure after coming to ADB conferences and talking to judges from India. But that's anecdote, or example, Deputy Justice, Chief Justice Kandakasi, we talked about standing in one of our conferences, and then in some of your next decisions, you were referencing jurisprudence from India that we'd been talking about. But that's really challenging for us to measure. But one thing that we are looking at is a database, yet another database. But that's because in our program, it's the Law, Policy and Reform program. So we don't just run training on environment and climate change, it's also gender, commercial arbitration. So we want to provide information on all of those different aspects across the program. So that's something that we are taking into account with the data that we're considering. I just wanted to address a couple of other things. Who trains? So as the judges who participate in our training know, ADB has always had an emphasis on inviting judges to train judges, but we have also always invited NGOs. We've had panels of expert environmental lawyers talking about their experience in court. And in 2020, we took children to Samoa to talk to the United Nations Committee for the Rights of Child on climate change. So we have always had an emphasis on diversity in the people who attend training, and that's also gender diversity. We are very particular about that. And in the work that we're doing now with judges, we are looking at both a basic curriculum, but also a curriculum that is more like the intermediate or advanced. And that would be where we could provide that training to the constitutional judges or judges from higher courts. So it could be tailored. We're working on it. And thank you for that feedback. I think it's really important. And just an anecdotal example from Indonesia. Sorry, one more example. I was talking to Justice Bambang the other day about incredible Indonesian litigation about peatland fire cases and forest fires, where the court awarded damages for peatland fires around carbon emissions, biodiversity restoration. And I asked him, how did your judges know how to value carbon emissions released? And he said, because we trained them. And that's remarkable. And with working with judicial academies, one thing that we do hope to do are some baseline assessments about what's happening in the courts when we come in, so that we can try to track how well are our programs going. But as to whether judiciaries or royal institutes or judiciaries choose to make performance and decision-making part of their structure for promotions, that would be something that we would workshop if that was within the appetite of the court. So thank you so much.
Over to you, Justice Benjamin.
Yeah, thank you very much. This is an extraordinary panel. A couple of comments from a comparative law perspective. The first comment is about the difficulty that we face in conducting judicial education in countries that are a continental size and without specialized environmental courts. In India, there are specialized courts. In China, specialized courts, but not in the United States or Brazil. In Brazil, we do have some, but it's not all over the country. And the question to the panel, and I believe I'm repeating somehow a question posed by Mansour, is how do we conduct judicial education in those circumstances? Are you going to train 15,000 judges? And 14,000, and I'm being optimistic here, we'll never see an environmental case. And we all know that we judges are very, very busy, with few exceptions. And I'm sure the president of the International Association of Judges, who is here with us, Justice José Igreja, probably know one or two examples in which judges are not very, very busy. So time is precious for us. To me, in those circumstances, it's hard to come up with a recipe, but we can design some guiding principles. And one of them is, the more remote the topic is, the more abstract, the more far away from what the judge is doing, the less interest or the less repercussion this will have. It will still be a beautiful event, training program, very interesting. The second guiding principle is that we cooperate among ourselves, but whomever is cooperating and coming to another country at least has a duty to take a look at the constitution of the country, read a little bit about the legal system, because most of that information now is available in English. But unfortunately, we see here and there colleagues that are very capable, and they parachute in a particular jurisdiction and say things that in fact that jurisdiction has done and implemented 20 years ago. So I think that's another guiding principle, since under the Global Judicial Institute on the Environment, the International Association of Judges, and our partners, ADB, et cetera, we want to do it correctly. So every instructor has at least to take a look at the broader legal system and discuss previously with the colleagues about what they have. Finally, our colleague Suntaria from Thailand mentioned this morning intellectual integrity. And we tend to think that integrity has to do with the recruitment of judges. Absolutely. And this is a priority of the International Association of Judges. But it has also to do, and here's intellectual integrity, with the way we conduct judicial education. We judges are not and should not be seen as entities that can be captured through judicial education. Judicial education is not to capture, it's to liberate the very best of us under, in our case, the environmental rule of law. So it's, to me, this would be another guiding principle that, as Brian Hill said correctly, it's judicial education for judges by judges with cooperation. But when you bring outsiders with all good knowledge, the basic tenet that you are there to share your knowledge, but not to benefit yourself or your institution or the vested interest that you represent from judicial education. So it's very, very hard, but I think those general principles can guide us in this exercise that is absolutely critical for us. I repeat, my colleague Santorea, intellectual integrity should be at the core of judicial education.
Thank you very much, Justice. I think one of the practical challenges for heads of judicial education institutes when put together programs, the issue is, yes, judges have to train judges, but does it mean that the judge who has been on the bench for 30 years is able to train in the real sense of the word? That's a big question. I think we have now reached the time, if we have not gone past it. I'm going to ask Adele if there's anything that you'd like to say before we can close.
Thanks, Dr. G. Just to say thank you to the panelists, as I say, all very interesting. And again, just to remind those of you who are in training institutes or training judges of the IOJT conference in Ottawa, starting October 30th for the week of October 30th to November 4th, iojt2022.org. I know that I'll be seeing Dr. G there, so I'm very much looking forward to that, Dr. G. So yes. Back over to you.
Okay, thank you very much. We'll see you soon in Ottawa. Let me apologize to the delegates who are online that due to time constraints, will not be able to take the questions, but we can try and provide answers on the message box. Would you like to say something? Let me thank you all of you for attending, and I'm going to give over to my dear professor here to make any announcements for the next coming sessions. Thank you very much.
Thank you so much, Dr. Gomalemo, and Justice Adele, and all of those who spoke at this fantastic session. We'll take just a very small break, about 10 minutes, no more than 10 minutes. So very briefly, if you'd like to stretch your legs or get a snack or anything out in the corridor, please do so. And we'll start right back at 4:35 with our closing session of the symposium, where we'll be very honored to hear from Achim Steiner and Elizabeth Marema, and the co-chairs of that session, Judge Jose Igreja Matos and Professor Christina Voigt. So we'll just take 10 minutes. We'll be back here at 4:35. Thank you.
most well-known with a wonderful reputation. Yes, yeah. Just stop it on my That is not the piece per se. Sorry. But no, we allow but so somehow this is how all I I cannot, this is a summary of COVID. No, I'm already got it book for late go right now. Yeah.
Welcome back, everyone. Good afternoon. Welcome back, everyone. I invite you to take your seats as we begin our keynote addresses for this closing session of the symposium. And in order to welcome our chairs and keynote speakers, I invite to the stage Justice Antonio Benjamin.
Thank you, Professor Nicholas Briner. Dear colleagues, we are approaching, unfortunately, the end of our program. This is the closing session of the symposium. We had discussions, most of the time agreements, but if we put two judges together, there will be 5 different theories. So we can never count on full agreement, but that's the beauty of law and that's the beauty of humanity, the diversity of us or in among us. It's now time to announce the 2 co-chairs of this session. First, my dear colleague and friend, José Igreja Matos, the president of the International Association of Judges, president of the Porto Supreme Court. Everybody's already volunteering to visit you in Porto. And you know, it's because of the beauty and the wine and the cuisine and everything that magnificent part of Portugal can offer. It's the first time that we have a president of the International Association that understands the importance of environmental law and especially of climate change. And it was Justice Igreja that so many years ago at Iguaçu Falls welcomed Elizabeth Medema, me, Justice Ricardo Lorenzetti. We were in a delegation, but more like intruders, in the biannual or triennial conference of the International Association of Judges. And there we were to propose to the board that they helped us with the foundation of the Global Judicial Institute on Environment. I don't need to give you the details, but it was not an easy meeting, to our surprise, until the then president of the Association of Judges, of European Judges, Justice Igreja, said, Mr. President, I think this is an excellent idea, and that the International Association of Judges should walk hand in hand with this new emerging institution that we call the Global Judicial Institute on Environment. So there is a long history of collaboration between him and our institute, because it began before the institute was even founded. The second co-chair is Professor Christina Voigt. You already had the privilege to listen to her as a keynote speaker, a distinguished law professor at the University of Oslo Law School. I would say, if I were to list the three finest experts on climate law, Christina Voigt would be one of them. Both of them have a quality that we also find in the two speakers, keynote speakers. And that is integrity and dedication to the public interest. So the two keynote speakers, and they will be introduced by the co-chairs, but I cannot resist saying one word or two about them. And Thomas Clark, the General Counsel of ADB, has already heard me saying those things in private about those two people. Both Achim Steiner and Elizabeth Medema are giants in environmental law and development law. And I will begin with you, Achim Steiner. Yesterday, Inga Anderson closed the session of the first day. And I said that when she was the director of IUCN, the project that she liked the most was the Global Judicial Institute on Environment. And we were so lucky to have in another continent the director of UNEP, who immediately said, this is fantastic, let's do it. And I vividly remember when I went to Bacari County to your office to present the idea of the Global Judicial Institute on Environment. And then you participated in many of our activities. Elizabeth Medema was the director of the law program at UNEP. And from day one, I didn't even ask her. I just invited her. And I knew that we would be together working with judges globally, doing capacity building, and making sure that the family would be together. Not uniform, but together. So I'm very grateful to Elizabeth Medema, as I said yesterday when I introduced it, Patricia Membotti. Those are the colleagues that we have here with us today. I do hope that in such a complicated time that we live, violence, the number of vulnerable people increasing instead of decreasing, that we judges continue to have the support of people like the ones that we have here. And I see Bruno Oberli sitting there too. Your turn is later. Those are partners like Tom Clark and the ADB and the European Reconstruction and Development Bank. On that very short introduction, I had so much to say, but I think when we are among friends, the most important thing to say is just thank you. A word of gratitude. So please welcome our guests and our co-chairs.
I sit here. Go ahead. So I don't know this. So good afternoon. Arriving a few hours from the airport, just arriving, and very important for me to be here. I put a lot of pressure in myself, in my agenda, to honor to be honored to be in this event, because I think international associations of judges should be here and must be here. And that is why I change all my schedule and happily arrive on time to be addressing some words to you. First of all, to Minister Antonio Benjamin, a dear friend, thank you. Thank you for your work. Thank you for your efforts. It is really remarkable what you are doing. I think environmental, the topic of environmental climate change is the future of the planet is absolutely essential. And we are judges, we are the judiciary, we represent a power of the state. We cannot be neutral, we cannot be like trying to throw a blind eye to the problem. So this is why when I was elected in September in Rome, as I was telling to a little bit ago, when I was elected in Rome in September, I put some priorities for my mandate. One was gender. That is another issue that is very concerning to us. And among others, the problem of environment. And to see that exist all these wonderful people, judges working on this issue for years now, and to know them, to have the possibility of be with them, work with you, it's a privilege for me. And I see so many familiar faces already. Since the beginning of my mandate, I have the fortune of meeting some of you already. And well, I'm losing my role here. So my main thing is to introduce you to the distinguished speakers. I am I have some common sense, I think. So I decided to deliver to much more skilled Christina Voigt co-share this work, and for me just to give you these welcome words. And thank you for the opportunity of being here. Thank you.
Thank you so much. And it's a great pleasure for me to co-chair this panel together. And to introduce, of course, our keynote speakers. There's perhaps not so much more to say after Antonio introduced you already, but I would like to first invite our dear friend Achim Steiner. Achim is currently the administrator of the United Nations Development Program. He also was the executive director of UNEP for several years. And he also was the Director General of the IUCN. And when Inga was here last night, Antonio asked her if that was her most difficult job that she's ever had. But I spare you this question because we have the current DG here in the room. Don't want to put you in any dangerous position, Bruno. So then I'm sure it was a wonderful job that you had. Very important. Achim is a friend, I hope I can say that, of the legal community, is a friend of the legal community. It's a double friend. He has been supportive, as Antonio said, of the work of the World Commission on Environmental Law under the IUCN for many, many years. But the interesting aspect with Achim is that he combines both the environment, but also the development agenda, both in his work and in his engagement with the WCL and the Global Judicial Institute of the Environment. And I assume, and I'm sure you'll come back to that, Achim, that this combined expertise makes you to appreciate very much the role of law in addressing both the environmental and development challenge that we have. The need for robust laws, the need for courts, the need for justice in both addressing environmental challenges, but also the development agenda. Achim, the floor is yours.
Thank you. Thank you so much for your kind introduction. And I want to begin by just saying, yes, I'm very proud to be a friend because I'm not a learned friend, just a friend, but a very passionate one, and one who owes a great deal of his understanding and appreciation of the role of law and the rule of law, the environmental rule of law, to our dear friend Antonio Benjamin, who sits here. I think, Antonio, you thank so many people so often because you are one of the great conveners in the world. You are one of the great pipers of Hameln, I think, as one would say, in this part of the world, where you are able to not only excite with the vision that you have, but you then have the audacity to actually make it happen. You know, we are meeting 50 years after Stockholm convened here. And there will be Greta and others out there who will say words, words, words. And your profession is also very well known for being very verbose sometimes. So with all the humility that I can bring to being in this exciting group of people who have come together here to reflect on that Stockholm Declaration and how our understanding, how our appreciation of the rule of law, but also of environmental jurisprudence, and the symposium in Rio will never be forgotten by any of us, I think, who attended it in the Supreme Court of Rio de Janeiro, in that fantastic building. It was historical. It was epochal in a sense because it marked a next beginning in a long journey. So in my 7 minutes, of which I've already invested 2.5 by now, let me just briefly reflect on the moment in time which we find ourselves. Yes, it's Stockholm+50. And let me also say, let's, before we start worrying about all the things that haven't happened, just pause for a moment and celebrate those who made 1972 happen. And every year since, built on what, in a sense, happened in 1972, which was to emancipate a reality that for so long had simply been considered secondary, tertiary, the concerns of those who depended on the environment being considered to be less relevant than those who actually had no more relationship with the environment, because water comes out of a tap, electricity comes out of a socket, my food is in the supermarket. Why are you talking about nature? What has environment got to do with my 21st century dream of life in a universe of technology and the cornucopia that, in a sense, that second half of the 20th century suggested to us? Well, here we are, 1972, the conference happened, institutions were founded, generations of environmental agreements have since evolved from it. I was surprised that there are not 1,000 already, because by the time I left UNEP, there were over 500 multilateral environmental agreements, and my briefing note says there's still about 500. So have we hit a ceiling? Or maybe Elizabeth, you can enlighten us on that in a moment. But it's an extraordinary body of achievement, because what we have created is not only an environmental agenda, we have also created the foundations for mutual accountability, because that's what multilateral environmental agreements create. The foundations for nations, sovereign nations, to agree with each other on what needs to be done, to agree with one another of what each one will do, and to be able to hold one another accountable. It's an element also of that environmental governance, and sometimes then codified into the environmental rule of law. So I think the 50 years since the Stockholm Declaration did indeed provide vital tracks along which countless professionals, first of all, maybe those who are advocating on behalf of the environment, but then increasingly also the profession of lawyers, of attorney generals, of judges, essentially having to evolve, and this was very much the theme in Rio also, an entirely new generation of jurisprudence, an environmental or environmentally informed jurisprudence. Where I want to end up with these brief remarks is that as we meet here at Stockholm +50, also is a reminder that in some ways, the way that the environmental community, and I'm sure many of you reflect on this daily, has to evolve its approach to dealing with what are often now dilemmas in our world. You know, Stockholm was defined by, in a sense, a very binary debate: poverty and environment, privilege versus the inability to act on issues. Well, our world has become so much more complicated, and the ability to transact decisions in our societies through our judicial system has become so much more prominent. And it is not just the disputes over a particular territory. We are now dealing with an entire generation that is stepping in front of the courts of their countries, the constitutional courts, with an intergenerational challenge. Not only are we dealing with the complexity of an environmental jurisprudence that has to deal with issues that most of us might have maybe heard about last time we were in school: carbon dioxide, the NOx, the SOx, methane emissions. And suddenly, you know, all of this and much more has to become part of a jurisprudence that is not only the product of one judge or one court, but indeed becomes the foundations for an environmental rule of law. But where I want to end up is that I think we have to even go broader. And this is partly where the confluence of Stockholm +50, but also the emergence of the Sustainable Development Agenda, and in some ways codified through 2015 and the Sustainable Development Goals and the 2030 Agenda, I think are a vital reminder that in this day and age, the best way in which to, first of all, understand what it is to have a right that relates to environment, but to have that right also understood within the totality of our society's daily decision-making, if I may put it in those terms, where an individual is not defined by 1/3 environment, 1/3 social, 1/3 economics, but where sometimes the economics of an individual is totally compromised by an environmental destruction, and the other way around. Sustainable development law may not be the right terminology, but somewhere in there is the further evolution of an environmental rule of law paradigm that has to continue to evolve alongside fundamental interpretations of human rights. And not only when human rights or environmental defenders are locked up, are killed in the defense of these rights, but also in the interpretation of how, in a world where access to resources, depriving others of that access, or destroying resources in the name of development, of progress, does increasingly become truly a crime. Sometimes a crime against your neighbor, sometimes a crime against the next generation. How do we evolve our thinking in terms of law, governance, into an era where I think people will increasingly turn to you as judges, attorneys general, courts, in order to not arbitrate, but to determine what is defensible or what is constitutionally acceptable, or where does constitutional law also have to evolve in order to accommodate this. A few years ago in 2017, I was invited by the World Bank's annual, I think, environmental law conference it's called. And I spoke at that time already about something that fascinated me, namely that young people who in many courts are not even considered to be adults and therefore are not necessarily even entitled to approach the court, were beginning to take the issue of climate change right to the heart of a country's constitutional ruling, namely the Supreme Courts. We have since then seen that happen in many countries, and we have seen green courts in India. We have seen many, in a sense, judicial platforms emerge on which people who feel they have nothing left but to turn to law and to jurisprudence to, first of all, be heard, and secondly, to be understood in terms of what they're actually saying. Your role as judges, the further evolution of this notion of the rule of law in the context of a sustainable development era that is still largely defined more by the failure to really achieve turnarounds than by breakthroughs, makes you sometimes literally the last person you can turn to in our societies. Working with you and working in where I am at the moment as head of the United Nations Development Program, as you said just now, I work daily at the confluence of something that science tells me, and that in the next moment I'm told economic imperatives contradict. That kind of trade-off belongs to the last century. It is simply no longer viable. It's not tenable. And I believe that through law and jurisprudence, we create the new rules of the game, because it is only when we change the rules of the game will the outcomes be different. In that spirit, may the force be with you. Totally inappropriate term in this room, but I mean it. Thank you.
Thank you. Thank you so much, Achim. Thank you for reminding us of the fact that the world has become more complex in those 50 years. How relations have become more complex, the challenges we're facing have become more dire, and that all calls to the stage the rule of law to create an answer and to define, redefine, reimagine the rules of the game. Thank you so much, Achim. Our second speaker, and again, a wonderful friend of our community, of the legal community, is Elisabeth Maruma Mrema. Elisabeth is a lawyer and a career diplomat, a wonderful combination. Elisabeth is currently the executive secretary of the Convention on Biological Diversity. And many of you perhaps know that currently, pretty much as we speak, the parties to the Convention on Biological Diversity are negotiating what is called the Global Biodiversity Framework, which is supposed, hopefully, to be adopted in the course of this year at a conference of the parties, which is not defined yet where it will take place. But it's absolutely crucially important work. Some have coined it as the Paris Agreement for Nature. It is a set of global targets which hopefully put a halt to the decline of biodiversity loss and nature destruction. Elisabeth was the director of the law division of UNEP, and she actually worked at UNEP for more than 2 decades. So you probably have seen it all in Nairobi. Elisabeth was also the executive secretary of the Convention on the Conservation of Migratory Species. So she has been involved in guiding these negotiations and these global meetings for many, many years. Elisabeth is a long-standing member of the steering committee of the World Commission on Environmental Law. Antonio got her in and I kept her. There was no way losing Elisabeth. And she was also, for her work in the field of environmental law for nature protection. She was awarded last year in 2021 with the Nicholas Robinson Award for Excellence in Environmental Law. It's a WSCL and UNEP combined award, and a very, very deserved award. Elizabeth, the floor is yours.
You see, my former boss says he was not invited to the party. And I'm saying it was a virtual party. Thank you very much, first, for the invitation to be here. I'm not sure if I deserve all those compliments, but what I think I'm always, especially now, to be here. And I was counting, for those who might not know, it is actually 26 years from the time when we first began engaging judges on environmental law issues. 1996, that's when we began in UNEP. At the time, I recall very well, judges were telling us, you cannot train judges. So don't be surprised when you see Symposium. So we got all, you cannot train judges, you cannot call judges. I mean, we were really criticized that particular meeting, and it was in Kisumu, Kenya. So after that, we changed the name into Colloquium, Symposium, Interactive, and you can see it is still retained today. But delighted that that development, 1996, is what led to today, the Global Judicial Institute on Environment, is what led before the Global Institute, really development of environmental justice, not just at national level in many countries, at regional level in Asia, led by Asia Development Bank. You have mentioned the region, the role of Brazil played. You have mentioned how we are able to get environment as part of the agenda of the International Judges Association. So 26 years of those development, I think it's great today to be here to see that development and to also see the development, not just of the environmental judicial activism, but also to see the growth of specialized courts on environment in many countries today. And I recall UNEP had even published, by the time we did a compilation of environmental courts chambers, we already had over 1,000, and that's a few years, or probably now several years ago. So I know now probably the number has doubled. So first, congratulations to the judges. We've come a long way, but delighted that now you have recognized you cannot be trained, yes, but you interpret the law, you make the law, you push governments to take action. And all the environmental challenges we are talking today, those actions on the ground, this is where we hope we will be able to see the environmental judicial activism coming on board. Where are we now 50 years after Stockholm, 1972? First, unfortunately, we need to take note that the world is still struggling to save itself from the consequences of the multiple environmental crises. It's climate change, it's biodiversity loss, it is land sea degradation, it is pollution, and the list goes on. The problems of 1972, which led to the establishment of UNEP, are still the problems we have today. In fact, probably I don't want even to say they've doubled, I don't know whether they've, but clearly the challenges have even increased, and probably all of us here need to ask ourselves, what are we doing, whether it's as a judge, as from development, from environmental sector, whichever situation, are we doing the right thing? And if we are not doing the right thing, what are we doing wrong? What will it change now next 50 years. By then, probably most of us might not be on this world. But then if 50 years is where we are, what are we saying the next 10, 20, 30 to another 50 years? I think that's the question we need to ask ourselves. And when I'm in front of judges, this is where I think you come in. Those who are responsible with all the pollution, the changes in climate, the land degradation, we know them. They are brought to your courts. Then what happened? I leave it to you. But we also know a lot has happened in the last 50 years. And Akim has mentioned the growth of the development of multilateral environmental agreements. 500 is just a working number. Literature will say 1,000. So clearly we don't know the number, but the fact remains there are just too many out there. But what can we say about their implementation and enforcement? It's a different question. But what the fact still remains that we have actually reached these planetary tipping points of unprecedented scale in the history of humankind. This is what the scientists have clearly told us. In this 50-year-long history and process, we have also witnessed the role of judges, how it has been crucial in supporting, in elaborating, in enforcing environmental rules, standards, to what we call today environmental rule of law, which again was a term coined by UNEP in those days, again criticized even 2012 when we brought about, again, global judges during the Rio +20, but delighted finally the UN Environment Assembly agreed to the methodology. Now we can delightfully use it. But then let me be selfish and focus on the role of the judiciary in the implementation of the long-term post-2020 global biodiversity framework, which is currently being negotiated, because that will be part of the projection of the global efforts and commitment in the next 50 years of human society to live in harmony with nature. Just at coffee break, there was a discussion of climate action for judges, and I was criticized. You cannot talk of climate without biodiversity. You cannot talk of climate without pollution, chemicals, or land degradation. So I think we need to change the narrative. Because when you talk of climate, we'll be talking of floods, we'll be talking of earthquake, disasters, and what have you. Which ecosystem are they operating, if not on biodiversity? And we all know the Convention of Biological Diversity, our own convention, as we are celebrating 50 years Stockholm, the Rio conventions, climate change, desertification, and our biodiversity celebrating this year 30 years since that Rio 1992. So yes, it's an international treaty. Yes, universal, almost 196 minus 2 countries plus European Union. So there's that universal acceptance. But with 30 years, we are still today being told loss of biodiversity has reached unprecedented rates. So I don't know whether we are doing something or we've not done anything, but the figures from the recent scientific reports are worrying. Clearly, despite decades of conservation and protection of biodiversity, destruction of ecosystem, loss of biodiversity, even as we sit here, continue unabated. Climate change is equally exacerbating this loss of biodiversity, which in turn, of course, diminishes the ability to adapt to climate change and mitigate its effects. It is the realization of this existential threat of losing our own life support system that prompted the world to embark on the development of the new global biodiversity framework, which will be the successor of the strategic biodiversity plan and its targets, popularly known as the Aichi biodiversity targets of the last decade. The new global biodiversity framework, yes, is anticipated to serve or to be at par with the Climate Paris Agreement, which was adopted way back in 2015, for which we are still struggling with its implementation. So again, we are not doing well. And I think I was in an event this morning where it was mentioned the temperatures are actually now at 3.1 when we are supposed to go into 1.5. So we still have a long way to go. The development of the global biodiversity framework is at an advanced stage. Its scope will be global, even if, although it is being negotiated by the parties to the convention, but the negotiation process has engaged all stakeholders, and I mean all stakeholders. If there's anything positive to the development process, has been the extra time we're able to get during this COVID period. Because as we're all locked down, we're able then to consult virtually all stakeholders, financial institutions, business, private sector, indigenous peoples, local communities, youth, women, and all can see themselves in the draft framework as it stands now. And of course, we need to know that the framework, when it is adopted, will immensely contribute to the implementation of the Climate Paris Agreement and also contribute to the achievement of the 2030 Agenda for Sustainable Development. If you look at the 17 SDGs, one has to tell me which one goal is not biodiversity related. I just need one, which is not biodiversity related. So clearly, if then biodiversity conservation and protection does not happen, clearly then the SDGs, well celebrated, will not be achieved. And because of the loss of biodiversity, not surprising that also SDGs were still not yet there, and the years are drawing closer to 2030. So we are fully cognizant, based on the 50 years of record, that judiciary is a key ally in advancing not just all environmental issues, but also the biodiversity agenda. The judiciary has contributed immensely in its involvement in ensuring compliance with environmental impact assessment requirements, environmental norms, standards and procedures, and implementation of biodiversity laws. The judiciary continues to contribute through prosecution and adjudication of environmental crimes, such as poaching, illegal trade in wildlife, illegal logging, illegal fishing, and the list goes on. So, and through the judicial review and adjudication of environmental disputes, or participation in legal research analysis of case laws, we know members of the judiciary are in any preempt position to increase the visibility of environmental stewardship in general and the success of the conservation and sustainable use of biodiversity. So your independent actions and opinions in favor of environmental rule of law will help the general public to be more aware of the consequences of biodiversity loss and be able to put biodiversity consideration in the forefront of all social, economic, and political actions, including development actions. And the upcoming global biodiversity framework is expected to be a global guide for local action. So the means of collaboration among governments, organizations, civil society, general public will be key. As discussed in this very symposium, Strengthening judicial interdependence and integrity is a prerequisite for the prevalence of environmental rule of law. So is legal education in the area of environmental law. As an independent branch, not affected by short-term political pressures to support unsustainable practices, the judiciary is well placed to make difficult but necessary decisions. Biodiversity issues almost always involve other areas of law. The judiciary may be called upon to find a balance between competing priorities of different public entities or different levels of government, or reconcile a variety of sector-specific laws and regulations which may not take into account the interconnected nature of biodiversity or ecosystem or production systems. So the world needs the vital role of the judiciary more than ever. And this symposium and similar forums are undoubtedly shaping your role as an impartial arbiter in reconciling conservation needs with economic and development interests. Whether functioning in courts or tribunals or in investigations, inspection, or prosecution, in the field of legal education, your role and contribution is indispensable. I appeal to you to continue to extend and enhance your professional support in the area of compliance and enforcement of international environmental treaties ratified or acceded to by many of your own national governments. Your role, your skills, not only as members of the judiciary, but also as members of the broader society, are certainly critical factors for governments and communities to succeed in their efforts to implement also the upcoming global biodiversity framework. The society at large will be looking upon you, the judges, to appropriately interpret the law, enforce the law, push for gaps in the law to be filled, and thus contribute to the conservation and sustainable use of biodiversity, and ensuring the equitable distribution of its benefits to all, in particular to the vulnerable and marginalized groups. Thank you.
Thank you so much, Elizabeth, for your wise words, for your words of encouragement, but also for sharing with us your current work as the Executive Secretary for the Convention on Biological Diversity. Maybe not all of you know what the overall vision is for the new global framework on global biodiversity framework. It's been a long day. It is living in harmony with nature by 2050. That's the overall vision for what is being negotiated now by 196 parties. By 2050. But we don't have time until 2050 to solve all the problems. We have a very small window of opportunity. And this is what science tells us. In order to be able to reach those global goals by 2050 on climate change, on biodiversity, on pollution, what has to happen are these transformative changes, systemic changes that need to be put in motion now in order to have a chance to get there by 2050, because things take time. And what is better suited to get these transformative changes on their way than the law, the governance tool that guides behavior and provides justice to all, as you said, Elizabeth. Elizabeth, thank you for your words, but most of all, we would like to wish you best of luck in your most important function to get this global biodiversity framework adopted this year. The world needs it. The world needs you. We wish you best of luck and would like to thank you for your dedicated work. Thank you, Elizabeth.
Please go ahead.
Okay. You know, as judges and Supreme Court judges, we are used to having, you know, a whole staff for protocol, but here we do it ourselves, and it's so much nicer. It's invigorating that we can do this ourselves. So many thanks to the two co-chairs. Wonderful job. Many thanks to the two keynote speakers. Many thanks to Tom Clark. But Tom, we need you there. So you are not free.
No more.
But in this case, so I will ask us to thank together our colleagues, the keynote speakers, and the two co-chairs. I know that both Achim and Elizabeth have other engagements. If they don't, we are the very best people to be with. You are most welcome to stay. So now I would ask if you'd like to sit there. And I will ask Professor Denise Antolini and Nicholas Breiner. They have the impossible task to summarize in 10 minutes what we have discussed in 2 days. And of course, it's just a summary, and they will do it. So please.
Great. Thank you very much, Antonio. I cannot adequately express my thanks to all of you for the time and the effort that you have put in to come here to Stockholm for this historic event. It's a remarkable gathering. I've been thinking throughout the day about what my dear colleague Denise and I might say are the outcomes of this symposium. And as Denise and I spoke with each other, we have 5 points that we hope you would all take away from this 2-day gathering here in Stockholm. And the first is the obvious, that judges must be included in these types of international gatherings. Now, I am a lawyer and I am a law professor. And so, of course, I think law is important. It's what I teach. And I think all of us here deeply understand the role of the judiciary in advancing the rule of law. But the message here is that that matters for Stockholm+50. Judges have been a key part of the success that we have seen since 1972. The successes are not small in number, despite all the shortcomings and the challenges ahead. The world needs that message. And the nations meeting here this week need that message in order to strengthen independent and ethical judicial systems. Second is that the global movement of judges interested in environmental law and the movement of specialized courts on environmental matters, that movement is growing exponentially. At the end of a movie, you would see scrolling along the screen a list of the cast members in order of their appearance. And we've heard from high court judges and Supreme Court justices yesterday and today from 24 countries over the past 2 days from 6 continents. And in order of appearance, those countries include Sweden, Brazil, Norway, Nepal, Papua New Guinea, Argentina, Barbados, Costa Rica, Australia, France, Pakistan, the United States, the People's Republic of China, Kazakhstan, Mexico, Belgium, Thailand, Armenia, Kenya, New Zealand, South Africa, Indonesia, Canada, and Portugal. And I apologize if I forgot anyone. It's really a remarkable gathering. And so to each of you, I know who've been involved also in gatherings within your own countries and regions to preach this gospel, thank you for your work. And the third and fourth points, and I'll leave it to Denise to further elaborate on these and to take us home with the fifth point. The third takeaway can be the successes that we have heard of. Judicial decisions that safeguard environmental rights, that apply environmental laws, that give practical meaning to constitutional environmental rights, and that give legal relevance to the Stockholm Declaration and all that has followed in these 50 years. Decisions that recognize the importance of human health and that human life cannot simply be sacrificed, and decisions that recognize that there is no true development or progress in the destruction of the environment. Decisions that give meaning to traditional understandings as well regarding our relationship as humans and as a human family with the environment. So many of you, and so many of you in this room, have been working on engaging judges and as judges working on environmental matters for 30 years. I was in elementary school at that time, and I'm one of the future generations mentioned at the Rio Summit, but look where we are now. So those have been some remarkable successes, but it's important to note the tremendous scale of the challenges ahead. Some of these challenges have been mentioned yesterday and today, and they include the challenge of responding to threats against the independence of judiciaries in sensitive cases around the world, particularly those environmental decisions that might have political ramifications or that might run against corrupt interests in the exploitation of public resources or the violation of individual or collective rights. And there is the challenge of resources needed to improve compliance and enforcement with environmental law. And the challenge is that we are in one room with many more rooms that need to be filled. Law has, as an instrument for maintaining order in society, has been used in many cultures throughout the world for hundreds and in fact thousands of years as a way of maintaining the status quo, as a way of preserving the power and interests of elites. But that is not the only vision of law. There is also a vision of law for justice, equity, and the rule of law. And that vision is possible. You are the ones that make it happen. And I'm so deeply grateful for your participation here and for all that you will continue to do in every continent and every corner of our blue earth. Thank you. Professor Anthony.
Thank you, Nick, for everything. It's been so much fun working with Nick once again, but for setting the stage for these outcomes, which we will be working on in a more formal way. So this is very informal. First, do you remember, you might not remember, when I gave my little remarks yesterday, I talked about that this is a symphony. And we all know who the conductor is, and he's been extraordinary. So Antonio, these remarks really reflect your success and the challenges ahead. So let me make a few remarks about successes, challenges, and then looking ahead. So in addition to what Nick mentioned, successes, the history that Elizabeth mentioned, it's incredible, right? So that in and of itself is something to value and not take for granted. So many people have come before you, before us, and worked so hard to get us here. Second, capacity, the capacity of our organizations like the Global Judicial Institute on the Environment and all of the partners here is tremendous. I mean, to pull this off and to pull off all of the events pre-COVID and before COVID is really an amazing success. Third, technology. The presentation on the portal, the development of the ability of judges to speak to each other across oceans and continents to keep up to date is really remarkable. I was talking to Justice Kondakasi about what their court is doing and going all e-court. It takes tremendous resources, but think about the potential. Fourth, the development of principles and how those principles have evolved through the work of everyone in this room. The principles are not static, they are dynamic, and they're so important to frame everything you do. Fifth, the amazing cases that all of you have had a major role in. You know this a little bit, but I'll just re-emphasize this. When one of you makes, or one of your courts makes an important decision and you share it, it's a spark that goes around the world and we all celebrate it. It is remarkable, the impact of the cases that you have been involved in and that you inspire, that you don't even know about. Next, the deeper understanding of all of the partners to law. For example, culture, with a remarkable presentation by Justice Joe Williams. Science, we didn't really have any scientists speak here, but that remarkable deeper understanding that you all have and are gaining through initiatives like this. Next, two more, specialized courts, along with Justice Michael Wilson and others. We are great fans of the movement towards specialized courts, and which is, as we know, in some countries exponential. And last, for the moment, key leadership. So all of you in the room, particularly the judges, it's remarkable what you have done and that you're here and you're willing to continue to network and build capacity. And on that point, I would say, find your successors, find 3 successors, right? Let's multiply all of you. Let's celebrate and multiply. Challenges, these are things that you know, but I'll just summarize them. Implementation or enforcement. I know some people don't like the word enforcement, but clearly implementation, metrics, as Justice Mansour brought up so many times, and that in each of these forums that I've been in has been the hardest question to answer for even people deeply involved in training and capacity building. So how do we know there is success other than what we feel and the anecdotal experience, which is important. Third, continuity, constant turnover in judiciaries. That is a huge challenge, I think, to maintain the momentum. Again, recruit your successors. Fourth, the balance between an independent judiciary and engagement, I think, is a real challenge. Engaging with civil society in the interdisciplinary world while maintaining judicial integrity and independence. Two more. Fifth, resources. Without major partners like ADB, EBRD, UNEP, I'm not mentioning them all, but we couldn't do this, you couldn't do this. So the resources that are available to judges, who must be careful about resources that they utilize, is a real challenge. Last, and this goes back to what Elizabeth said and Akim, the slow pace, unfortunately, of law compared to the crises that we face. That is not the fault of any of the judges in this room, but it is a great challenge ahead to speed up the law, to be more dynamic, to catch up with the crises that we all face. So those are just some thoughts to add to what Professor Breiner mentioned. This has been an incredible symphony. It is not the final act. The final act is tomorrow, the side event in the UN venue. That will be in room 5 at 1545. But for all of you involved in the side event, you know you need to arrive early, and I will speak to you separately if I haven't already. And that will be an incredible opportunity to bring the messages from the last 2 days to a global audience online and at the UN venue, and to speak to, this is it. I mean, when we were planning this, right? I mean, that was one of the major goals, is to get that opportunity to be in the venue, to bring judges into Stockholm+50. So I would say, about all the outcomes, I think that might be the most exciting yet to come. Thank you very much.
I said they would do it, and they did it. And Achim, I know you have to go, but before you go, let me remind everybody that the judges were not present in 1972. The judges were not present in 1992. But you, Achim Steiner, and Elizabeth Mirema, and Bakari Kanti brought the judges to Rio Plus 20. And now we are here organized under the Global Judicial Institute on the Environment. So many thanks to you, to Elizabeth, and to Bakari Kanti as well. So please, let's thank our two colleagues that have presented. Okay, now, oh, I'm sorry. Elizabeth's still here, and Achim, you are here. You are not going to carry. No, you don't hide. Don't be afraid. I'm not going to make you carry anything. But the Asian Development Bank put together, in my view and in the view of everybody that is here, the most extraordinary collection on judges and climate change. And I have here one of the experts responsible for this, Brian Ells, but also the director of ADB, I'm sorry, the general counsel. He was here until recently. And also Christina Pack. So if we can just formally give you the books, and then we are going to get them back and sent to you now. So, Elizabeth, could you come here? Christina, please. Oh, yeah, this is the final. Yeah, it is. That's why I told you you're not going to carry. Don't do it. No, I have the igreja. So, yeah. So, I was wondering whether you might wear it up here in the moment. 1 second. Okay, now we pretend you are carrying the book.
Ladies first. This is my side, yes. This is very weighty one. Thank you.
Okay. So now you can give the books back and we're going to.
Yeah. I promise.
I know it's like I remind me. Yeah. Okay, we're having that day. Please, thank you very much. So much. Nice to meet you. Thank you. Thank you. Okay, we continue. You know, I see that not just Achim Steiner was terrified in carrying the books, but also Elizabeth. But even more terrified is Bruno Oberli, because he thinks I am next. And you are going to get your 4 volumes and carry all the way to Geneva. So now we really arrive at the end of this today journey. And I will invite Justice Nambita Dambuza to be a co-chair. She's the president of the African Network of Judicial Academies and the Environment, to be a co-chair with Justice Anandan Mohan Bhattarai from the Supreme Court of Nepal. He is joining us virtually from the United States. The 2 final keynote speakers are the president of the International Association of Judges, José Igreja Matos, and Bruno Oberli, the Director General of IUCN. And as I said yesterday, to me, that's probably one of the most difficult positions in the environmental system, the international environmental system. But Bruno Oberli, and Bruno, please come here, and Christina Voigt as well, please. So Bruno is the former minister of the environment of Switzerland. And if you think Switzerland is an easy country to be a minister, it's because you don't know how independent each canton is and how independent-minded the Swiss citizens are. They don't like a law, they have a referendum out. Or they think a new law is needed. If Parliament doesn't act, a referendum, the law is there. So to be a minister in such an interesting context, it's not an easy task, and especially for almost 10 years. So no wonder that you feel really if I may say so, if IUCN were a sort of nuns monastery, that, so quiet, everything, there is no disagreement in this fantastic union that we call the International Union for the Conservation of Nature. So with that, I will ask Justice Nambita and Justice Bhattarai to lead us towards the closing.
Thanks, Antonio. Good afternoon again, colleagues and friends. Because we've just heard me speaking, Justice Bhattarai and I have agreed that he will start leading the session, and I will do the introduction of our speakers, which Antonio has already done. Justice Bhattarai, if you may go on.
Good afternoon, everyone. Am I audible?
We can hear you.
Oh, thank you. Thank you. Good afternoon, everyone in this Stockholm. Due to my already scheduled travel plan, I could not join in person. But I'm so much delighted to listen to several sessions conducted yesterday and today. Today's session mainly focuses on access to justice and judicial education. As a founding member of the Global Judicial Institute on Environment, and also a founding member of the National Judicial Academy in Nepal, where I spent 4 years before I was elevated to the Supreme Court. I have some fleeting thoughts on judicial education that I would like to share with you. First, what Stockholm has to offer to judicial education. Second, what we have been doing in this area in our respective countries. And third, how we can move ahead. The third question relates to some of the conversation that emerged today. Coming to the first question, what Stockholm has to offer to judicial education. You will be surprised, you might have been already surprised by the question that I posed. Stockholm Declaration doesn't talk about judicial education, but it talks about human environment, and that way blends, brings human being at the center of environmental discourse, and also blends environment and human right in the discourse. It also talks about the search for common outlook and common principles. It lays down some principles and encourages us to work on those principles and evolve other principles. That way, Stockholm Declaration is so important for us. Evolving common outlook involves several things as prerequisite. First, a common understanding on facts, especially scientific facts, which judges crave to know and get familiar with. Second, common outlook on efforts made and tools evolved, including legal tools, both at national and international level, and their efficacy. Some judges from Africa was referring to structural interdictions. We in South Asia talk about continuing mandamus. And we need to think about the common outlook on these two, commonality among these two. Third thing, and a host of other things. And third thing that I'd like to highlight is emerging principles that have recently found a place on the hard law instrument. By that, I am referring to principle of common but differentiated responsibility that was reiterated in Paris Agreement. We have to deconstruct this principle in the local situation and also talk about the compensation and reparation mechanism, which we have not much done at the local situation. Common outlook among policymakers, legislators, environmental actors, and judges on the duty to reconcile conflict between the needs of development and the needs to protect and improve environment through rational planning. That's what Stockholm Declaration talks about. This was felt in Stockholm, and it is felt no less today. It is essential for achieving what we in Nepal call environmentally sustainable development. A common outlook about future course of action so as to defend and improve human environment for present.
Sorry, Justice Patarai, sorry, colleague. I just need to remind that we don't want to eat into the time of our keynote addressers.
Okay,
it's late in the day. And
so now we have come to, I come to the final part, on judicial education. Today we are talking about how to go about it. We have anecdotal evidence coming from my country, and I'll pass on to the organizers what we have done in Nepal. With these few words, I welcome the speakers and hand over to my co-chairs. Thank you.
Thank you, Justice Patarai. Now I call upon our first closing keynote address from Jose Matos from Portugal. Thank you.
Thank you. I'm here again. You are true heroes. Late afternoon, still here, still wanting to listen. Thank you for that. Well, I learned a lot today with other speakers. It is really important, the work you are doing. Let me briefly introduce my organization. We are the International Association of Judges. Probably you all know about it. We were founded in 1953 in the aftermath of the Second World War, and trying to have international organizations devoted to what were back then and still today the main issues of civilization: rule of law, human dignity, judicial independence, and all those values that bring us together. We are now 94 countries, what is really impressive. And most of the countries are within us, the national associations of each of those countries, in the past 12 to 15 years. Because, as Antoine Garapon mentioned, we have this phenomena of the mondialization of judges. Today, the concerns, today, the most important things that worry us as a judicial career, as a legal profession, are global, are the same. In Philippines or in Australia or in Portugal, whatever, we have concrete concerns that are equal to all of us. And one of those concerns precisely is the environment. It is clear, and I like it very much when Denise pointed out that we should arrange a balance between judicial independence and engagement. Yes, we must be engaged on this global problem, but at the same time, we must maintain judicial independence and judicial integrity. But to be honest, and in the concrete world we are living now, the problem is not within us. The problem is with all the pressures, all the powerful lobbies, even national political authorities that have different motivations and that are exercising the pressure with us judges. Social media that is often manipulated, public communication in general, also easily manipulated by those powerful forces devoted to preserve their control and their influence. Many people, many scholars, I'm not an expert in these fields, explain that it can be detected a shift in the role of judiciary from spectator, adjudicator, to protagonist, to designer. And we must meet this challenge. With the present pressure on social media, where everyone can say what's on their mind, the people who tend to be most successful are the ones who shout the loudest. But science is not about exhibiting indisputable truths. It's about circumscribing doubts. If we keep oversimplifying, we run the risk of losing awareness, like in the story of the boy and the wolf that everybody knows. If you simply scream about climate crisis, even if we are right, and we know that we are right, the risk of the message losing importance is real. Climate changes is there, here and now. However, we have to think with our heads. Prudent rationality. This is the key message that I want to deliver to you, dear colleagues and friends. So I try to pull out some ideas, some proposals, some suggestions, not only words, some concrete proposals. We need to reaffirm a determined commitment of judges to the aims defined by the United Nations about environmental protection. We need to start a global commitment to have independent judges, impartial judges, chosen by strict merit criteria, working on the area of environmental law, and specialization is there. So we need to be very aware of the importance of the appointment procedure for judges working on this crucial topic. The implementation of international guides defining judicial careers of judges responsible for cases dealing with environmental law, particularly those related with their judicial appointment and non-dependency of external constraints. And especially for the Global Institute that is organizing this event, to have an international oversight with the assistance and coordination of the United Nations to properly assess the work of national judiciaries in the field of protection of environment, concerning the independence of justice towards the interests involved, along with the proper separation of state power. The planet lives a decisive battle in order to guarantee a viable future for the upcoming generations. These are not only words. A battle in which, to use Mandela's words, it is our burden to promote courage. And we need to be courageous in some circumstances, especially the judges, where there is fear. To promote agreement where there is conflict. Rationality, prudent rationality, it's always the answer. And to inspire hope where there is despair. 94 countries and a strong commitment. This is the pledge of the International Association of Judges. My greatest hope is to know that in this room, with the institute that we work on, we have the inspiration, the motivation to follow and to work together. Thank you.
Thank you very much for those words. These are closing remarks, so I will not close closing remarks. I will now call upon Dr. Obel. I hope Obel. He has also been already introduced by Antonio. I will just ask you to take the stage, Doctor. Other than that, the bios are still in the.
Esteemed judges, ladies and gentlemen, dear friends, thank you for inviting me to speak here at this conference as the Director General of IUCN. Yes, Antonio, IUCN is a complex, sometimes complicated organization, broad, vast, very exciting. And you may be right. The experience in the executive of Switzerland has formed my way to approach these situations. As you say, in Switzerland, laws can be challenged or initiated by the citizens. The citizens elect judges, and we call the citizens in Switzerland the sovereign. And in this sense, if I accept the members of IUCN as the sovereign in IUCN, I don't have a problem. I accept the rule and the indication of the sovereign, of my members, and I do my best to implement their will. And IUCN's mission is to support the members in better managing natural resources on our planet. And we know that our future depends on our capacity to face the two interconnected crises, the global loss of biodiversity and climate change. Species extinction and global warming are phenomena caused by humans. I will make two examples. Humans are extracting material from the planet to develop and to realize dreams that we have. The Sustainable Development Goals are materialized in raw material. 50 years ago, we extracted 30 gigatons from the planet. Today, we are extracting 90 gigatons. In 50 years, we will extract 160 gigatons. Our wishes, our vision drives our actions, and our action have an impact on the planet. We can change the way in which we act. We can change the way in which we use natural resources. We can go, for example, towards circular economy, but we have to understand how to do it. And we have to put the right signal at the end in legal system to evolve in that direction. On the other side, another example, the Dasgupta report that tell us we are using and wasting natural resources, and in particular biodiversity, taking too much and not reinvesting enough in our natural capital. And we do so because fundamentally at the very end, we simply don't have put a price on nature. We waste because we don't express the value that we feel through an adequate signal. Now, to put the price on nature requires decisions, require, in some cases, taking the ownership on asset away from existing owner. It requires to impose pricing and institutions that will supervise the price building. and the implementation of these prices into the market. And this needs understanding of the economical rules in this case, and it needs legal regulation to create this institutional building that we need to steer in that direction. Our responses have to come both from science and from law. Both are essential to achieve effective conservation and restoration of nature. For that, laws and policies have to be anchored in science, and the link between the scientific community and the legal community must be strong. And here, because you have invited me to speak about IUCN, I will spend some word about IUCN, because IUCN is the place where scientists, natural scientists, legal experts meet to discuss these common challenges. IUCN brings together scientists to promote and enhance conservation by laying out reliable data on the state of biodiversity, for example, the red list, and on the status of protected areas, for example, the green lists. IUCN engages with policymakers to bring forward ambitious environmental policy frameworks. Throughout its history, our organization has played a key role in initiating and drafting major international agreements such as CITES, World Heritage Convention, Ramsar, Convention on Biological Diversity, and many other regional agreements. And IUCN, through the collective effort of the World Commission on Environmental Law and the Environmental Law Center in Bonn, continues to shape the development of international environmental law, for example, including biodiversity in areas beyond national jurisdiction, or in the process of establishing a treaty on plastic use and management. But I am here to speak not only about IUCN, but about you. The success of the law depends on its sound and effective implementation, so that the gap between commitment and enforcement can be closed, and thus ensure a responsible use of natural resources. The Global Judicial Institute on the Environment is a member of IUCN, is an impressive member of IUCN. Thank you for actively supporting judges, courts, and tribunals to respond to pressing environmental crises and challenges. At the gate, as the gatekeepers of the law, judges sitting at all levels of the judiciary have the power to secure effective enforcement of environmental law and to guarantee that the states fulfills its international commitments. I would like to conclude here congratulating the Global Judicial Institute on the Environment for organizing this symposium on justice, judges, and the environment, which is a testimony of the importance of reinforcing the environmental rule of law to achieve global conservation objective. Thank you very, very much for your effort, and I wish you a very good success tomorrow in Stockholm, in the official place.
Thank you very much, Dr. Obel. I hope that next time we will hear you earlier so that we hear more about the work of the IUCN here, because we really need to get that information about the kind of work that you do and to be able to access it and use it effectively. Thank you very much. Christina, are you going to, oh, you were just here to keep us company. Oh, okay. Of course, thank you, sister. All right, that's it then, Antonio, I'm done.
Thank you.
Shall we leave the stage?
Well, thank you, Justice Nambita, Justice Batarai, and many thanks to Bruno and to José Igreja, and of course, Christina Voigt. Now we are going to really close it. And I'll ask the colleagues that will say a few words in thanking those that helped us in this journey. So I invite Justice Sapana Pradhamala, Christina Pak, Andrew Rain from UNEP Nairobi virtually, and Kathleen Rogers, President of Earth Day. Please. So we I think it's the best way to end a major event, to thank those that have taken our hands and done the journey together. And it's not common to do the way we do, and especially it's not common for judges. We tend to think that, well, I should not say what the way we think about us and how the world should pay tribute to us judges and respect. But here, under the guidance of the president of the International Association of Judges and the members of the Global Judicial Institute on the Environment, we take a different approach. We end with gratitude. So please.
Now we are at the end of today's program, but with the commitment to continue the dialogue, and our dialogue is going to again start tomorrow in a UN forum. My responsibility is to thank you to all the people, to the organization who has made this happen, but what has excited many of us is the commitment we have received from ADB, from UNEP, from different organizations. But before that, I also want to thank Earth Day for making sure that we all can participate. We must say this is an extraordinary meeting. Lots of substantive issues have been discussed. It's a meeting of extraordinary judges who have shared what they have been achieved, what they are going through, which will be continuing. But I have to thank first to Dennis and Nick Bryan, who always sits behind, who in fact architect the program and make it happen. From the organizers' side, I would like to thank you, Dennis and Nick Bryan. I would also like to thank you, UNEP, and especially Inger Anderson. She really challenged us, but she also inspired us. And then support she has extended to continue the dialogue and strengthen the judicial competency. I would also like to thank you, Thomas Clark, for your leadership, and whole team, Christina, Maria, and those people who are not here at present, but sitting behind in Manila. They have been making it happen, Angelo and other team members. I would also like to thank you, Christina Voek, who no matter where in the world, whatever is happening, you are always with us. Nicholson Robinson, and also I would like to thank you, our special rapporteur on human rights and environment, with whom we are missing today, Then the special thanks also goes to Luke Lovinson, President, European Union. Michael Staros, European Reconstruction and Development Bank. If I've forgotten anyone, Elizabeth from CBD. And I also want to thank you, Antonio, for your leadership, for your untiring energy you have brought, not only to found Global Judicial Academy, but to make it happen. And now you have given life. We have launched the portal, and that will, I'm sure, not only help us to connect, but also to empower. Thank you.
Honorable Justices, respected guests, development partners, and all the incredible environmental champions in this room. It's just been just an inspiring and amazing 2 days. During the symposium, we heard about the progress made since Stockholm Declaration, but we also heard the emergency sirens that we need to move faster and do more to achieve the Sustainable Development Goals. So this gathering, I think, the gathering of the global judiciary alongside Stockholm 50 is a response to this call to bring in the judiciary who are fundamental to achieving the Sustainable Development Goals. So we hope this symposium has provided all of you, the global judicial community, with new opportunity to strengthen your response to the triple planetary crisis. And this event has energized you. ADB is committed to supporting our judiciaries along with our partners. And we hope these 2 days have given you new perspectives and new ideas. And, we plan to disseminate these valuable sessions widely, and we are happy to support any translations so that all the countries, all the global judiciaries access to these valuable sessions. So I think, it's the closing of the closing is about thanking everyone and being grateful. So I am grateful to the global judiciary for all the incredible work that you do. And in particular, I like to acknowledge our Asia Pacific judiciaries, and in particular, the judges that are here with us today. Our champion judges, Justice Mala from Supreme Court of Nepal, Deputy Chief Justice Kandakasi from the Supreme Court of Papua New Guinea, Justice Ali Shah from the Supreme Court of Pakistan, Justice Sundaraya from the Supreme Court of Thailand, Justice Bambang from the Supreme Court of Indonesia, and our justices from Central Asia, Justice Bebut Shurmakov from the Supreme Court of Kazakhstan, and Justice Karen Zarakayan from the Administrative Court of Armenia. So we are just grateful that you have traveled all the way here to contribute to this dialogue. We are also grateful to the contributions made by Justice Bhattarai from the Supreme Court of Nepal and Judge Liu Zume from the Chief Judge of the Environment and Resources Division of the Supreme People's Court of the PRC. ADB recognizes the incredible challenges that all the judges face, that all the difficult issues that you have to grapple with. So we are incredibly grateful for your dedication. And this symposium would not have been possible without the collective efforts of the international development community. So I would like to express our deep appreciation to the Global Judicial Institute on the Environment and the International Association of the Judges, in particular for your vision and initiative in convening this significant symposium. Also, I'd like to acknowledge the amazing Justice Benjamin. you keep us all inspired and energized, and we are grateful for the bridge that you have built to connect our Asia Pacific judiciaries with the global judicial community. So thank you for that. Finally, I'd like to also acknowledge our development partners. Without all of us working together, this symposium and our work together would not be possible. So we really look forward to our continuing collaboration. And we are also grateful to the new connections that we have made, and we look forward to forging new partnerships. And of course, I have to thank our amazing ADB team again. So Cecile, Bryony, Angelo that are here, but of course, the extraordinary team back in Manila, I have to say their names: Emmy, Gladys, Hyacinth, Colleen, Paulo, and Martin. They made this all happen behind the scenes, and they were up till midnight. So, and of course, our general counsel, he's just been an amazing support. He's joined the bank since July 2020. He's helped build our judicial program and expand it. And he's been an incredible supporter of our broader law and policy reform program. I would also like to thank Denise and Nick. They are now honorary members of the ADB team, and we will always work with them, and they'll be part of our team forever. So thank you. So I hope all of you leave with a sense of optimism that collectively we can steer our planet in a different trajectory. So again, thank you so much for all your contributions and just for being here. And good luck with the rest of the events. Thank you.
Hello there. Antonio, I want to thank you for inviting me. Everyone is right about you. You are truly one of my heroes, and coming from civil society now, that's saying something. My own background started out in law. Well, actually, I was in the media before I went to law school, and I was lucky enough to be a judicial clerk at the district court and the Court of Appeals in Washington, D.C. And my judge was particularly confident in my skills and allowed me to write, and I'm not kidding, every single opinion. And only one in the entire time I was there, which was quite a while, did he ever change. And it was on standing. It was National Wildlife Federation case. And I love the plaintiffs. This is before I became an environmentalist. I had been in media, worked for the International Olympic Committee. I'd done all these things globally. But there was a hint in me that National Wildlife Federation deserved to have standing in this court. He read it, completely reversed it. It went to the Supreme Court. He was right. I was wrong. So I learned a lot about being a judicial clerk and what your minds actually are like. I then went to National Audubon and became co-manager of our litigation department. So I also litigated many, many cases and had been in private practice. And so I learned that perspective as well, how to bring cases, how to negotiate with governments, and most important, how to navigate the judicial process from the other side. Then I went to Earth Day. My organization has one of the biggest names in the environmental movement. We have almost 1 billion people participating in Earth Day. We have 150,000 organizations in our network, 25,000 mayors, thousands of faith groups, millions of teachers and students. And our organization both works year-round, but we also focus on bringing people into the environmental movement. And so as I was sitting here, and Elizabeth brought this up, which I thought was really important. She talked about two things. One is liberal education, and the second was the general public and the role of both. And having just finished multiple times various studies on the state of our liberal education, particularly with respect to climate change, I must say there isn't a single country on the planet that gets it right. They not only don't teach environmental education, which is critically important for all of you, but they don't teach civics. Not a single country teaches civics in any way, shape, or form that can contribute to society. And on the other side is the general public, most of whom, and bringing them along is my job. So it's difficult for me to say, we haven't quite made it. We're not even close. There's disillusionment with multilaterals. There's disillusionment with governments. principally because there's so much compromise that part of being a diplomat, part of being a multilateral, part of being a government. But in the state that the world is in now, and for the most part, I must say, after having worked in this business for 30 years, we're losing ground. We are not winning. And it is partially because we don't have the general public, partially because we don't have the education, partially because our multilaterals are letting us down, partially because our governments are doing the same thing. So the final thing I'd like to say, because it was brought up in some of the concluding remarks, is a question about the status quo. And my organization is focused on disrupting the status quo, along with many other environmental groups, faith groups, mayors, and others. But we are in your hands because, as one of our previous speakers said in summing up the proceedings, the status quo, you are not here to protect the status quo. Also, sometimes it feels like it. Your job is to, particularly in the environment, understand the facts, understand the science, and decide the law. But keep us in mind, because the only thing that stands between us, in my view, particularly in the state of education and in the general public, the dearth of courage and heroism at the government level, are you. All of you. You are what stands between us and desecration of the planet. We depend on you. And more important than anything, we thank you.
Hello, colleagues. Warm greetings from Nairobi. I'll be very, very brief with just 3 points. First, huge congratulations to the team who organized this symposium. I work in the United Nations and I organize a lot of global meetings, so I know how much work it entails. And so please let me echo Christina and many others in thanking Justice Antonio Benjamin, the entire ADB team, Bryony, Cecile, others back in Manila, and everyone else, Denise, Nick, everyone else who played a role in pulling this together. I'm personally very sad that I'm not there with you in person. I've been following all of the sessions, and it has been a roll call of many of my environmental law, or let me instead use Antonio's words, planetary law, judicial and environmental law heroes. You truly are icons in this movement. Second point, whilst you're icons, how do we create more of you? We've heard from many speakers and participants about the critical role of judges. I don't need to repeat that, you know that. The thing I kept on thinking in these 2 days was about how do we use the platform of the UN, of the ADB, of the IAJ to create more of you, to accelerate judicial solutions to our triple planetary crisis. More Antonio Benjamins, more Michael Wilsons, more Leo Jumays, more Syed Mansour Ali Shahs. And on this, I want to take my opportunity to reaffirm to you in the strongest possible terms UNEP's commitment to working with you and with the Global Judicial Institute on the Environment and with ADB and with IAJ and anyone else at any level who is committed to this mission. Third, and finally, I leave these 2 days with a sense of optimism. Yes, any objective analysis shows us that the scientific glass is half empty. Many people have made that point compellingly. It's left less than half empty. We're in a bad place. But when it comes to the environmental law movement or the planetary law movement and the systemic changes it can tidal wave in, I'm 100% with Nick Robinson. I'm with Elizabeth Mrema. I'm with Inga Anderson. I'm with all of the other speakers who spoke to the I'm glass half full philosophy. I'm even more than glass half full because your ideas, your commitment, your creativity, your legal imagination, your clear-eyed direction of purpose is what's needed and what is happening and what can happen to truly accelerate environmental rule of law. That's my purpose. I'm committed to it. I know you are. And I'm very, very grateful for these symposiums and the many that will come after it, and I thank you.
Time to adjourn. And I understand that Scott Fulton brought his guitar. So those that like music and good music, we don't need to pay anything. To begin with we have no funds for that. It's just Scott Fulton's generosity. And I invite Scott to come to the podium.
Somehow music started to creep into these gatherings a few years ago. And we did not want you all to be deprived. If this goes well, you can thank Antonio. If it goes poorly, you can blame Christina, who thought this should happen. This is given our all of the focus these last 2 days on future generations and this sort of clarion call to solidarity for judges that we heard from Mansour yesterday. I thought this song might be a useful punctuation point on our gathering. Hopefully the guitar will cooperate. It's a small guitar, as you can see, but that's because I only play a little guitar. Okay, here we go. The song is called Growing Tomorrow. We are the sun and the water. We are the seed that is sown. We are the soil in the garden from which tomorrow will grow. And together we are growing tomorrow. Together we're preparing the way, so tomorrow can rest on the strength of foundations that we lay today. We are the brick and the mortar. We are the tools and supplies. We are the nail and the timber from which tomorrow will rise. And together we are growing tomorrow. Together we're preparing the way, so tomorrow can rest on the strength of foundations that we lay today. If we all work together, if we all act as one, if we build on each other, a bright tomorrow will dawn. And together we are growing tomorrow. Together we're preparing the way, so tomorrow can rest on the strength of foundations that we lay today. We grow tomorrow today. Thank you, everybody. One more? All right. If I have to do another, you have to do it with me then. We've had good success with this group, with judges, with this Pete Seeger song that I think the strength of it is it's really about justice ultimately. This is one of the great sing-along songs ever written. If you know it, sing along, sing loudly. thank you. And if you don't know it, you will by the time we get through the first verse. It's called the Hammer Song. If I had a hammer, I'd hammer in the morning, a hammer in the evening, all over this land. I'd hammer out danger, I'd hammer out warning, I'd hammer out the love between my brothers and sisters, all over this land. If I had a bell, I'd ring it in the morning, ring it in the evening, all over this land. I'd ring out danger, I'd ring out warning, I'd ring out the love between my brothers and my sisters, all over this land. If I had a song, I'd sing it in the morning, sing it in the evening, all over this land. I'd sing out danger, I'd sing out warning, I'd sing out the love between my brothers and my sisters, all over this land. Well, I've got a hammer and I've got a bell. I've got a song to sing all over this land. It's the hammer of justice. It's the bell of freedom. It's a song about love between my brothers and my sisters all over this land. It's the hammer of justice. It's the bell of freedom. It's a song about love between my brothers and my sisters all over this land. Let's go do justice.
You tomorrow in the main event.